Morning, Mr. Marks. How are you?
Good morning, Mr. Lennon.
Hi.
I've got Mr. Priestkop here. He's kind of across the room from me, and we're gonna. You want to undo your video or turn your video on?
Video,
Marcus.
I apologize.
And we're gonna try and share an audio feed so we don't have feedback. But if it doesn't work well, we're going to switch over to those headsets like you're doing.
Okay. Sounds like a good plan. Right now we are off the record, so we can speak freely for about 3 or 4 more minutes, and then we'll get started. This is going to be a public hearing. There's some not dispute, but there's some issue of whether or not these need be public. These types of proceedings need be public. There are certain proceedings at the PRC which certainly must be public, and some that perhaps need not. But I'm going, and at risk of to be cautious, I'm going to make this a public hearing. It should not have much effect on us, except for that if we wanted to exclude anybody, it would not likely be granted. I see a few people in the waiting room who look like employees of the PRC, and I'm going to admit them, even though they're not counsel or witnesses. I also see a few phone numbers, which I don't recognize the phone numbers. So I'm going to ask you guys if you recognize who these people are before I click admit. Ms. Maggiore, can you hear me? Would you unmute yourself, please? Ann? Okay. So let me see. Maybe
I get a lot of distortions. So the 250-4339 is my phone. And if you admit that, I will take it off the computer audio, and I think it'll give us less problems with bandwidth.
Can you state that number once more, please?
Yes, sir. It's 250-4339.
Okay, thank you. You just been admitted. Does anybody know who this number is?
Okay, then I'm going to take myself off of the computer video.
Alrighty, thank you. There's a number that is...
Hear me on the phone.
Oh, that's so much better. Yeah, you sound closer, more present. Welcome.
Well, that's what I get for living in the mountains.
Well, we all kind of live in the mountains up here around Santa Fe a bit. I think I'm at 7,300 feet here. I'm a little higher than the plaza, which is about four blocks away. Anyhow, there's another number here I don't recognize, 566-5832. Does anybody know who that is?
Mr. Hearing Examiner,
yes.
This is the stenographer. That's my backup.
Okay, do you want me to admit that number right now or leave it?
Yes,
okay.
Would you please? Thank you.
You got it. And then there's 5331. Anybody know who 5331 is? Oh, who's that? Well, we're going to find out in a minute, because I'm going to admit them and ask them. Hello, I've just admitted phone number ending in 5331. Could you please identify yourself? You need to unmute first and then tell me who you are. Phone number ending in 5331, please.
I'm not sure if it's me. This is Chris Archuleta with Superior Ambulance.
Hi, good to meet you and good to see you. Good to see the face behind the name. There is a muted number, and I'm going to ask that person to identify themselves. The phone number ends in 5331. Okay, I've even pressed the ask to unmute button and see if that gets any action from them. It's about 9:01. I do like to start promptly, and that's what we are going to do. Start with whoever.
Hi, I apologize.
It's okay. Who's
This
this?
is Greg Kelmanson. This is the number 5331.
Thank
This
you.
is Greg Kelmanson. I'm in-house counsel for American Medical Response.
American Medical Response, AMS.
Yes.
Can you give me your name again, please?
Greg Kelmanson.
All right. Thank you, Mr. Kelmanson. We are, before we go on the record, I just want to state we are on the YouTube. So this is going to be a public meeting. I have a few things I want to get started before the testimony, so we will do that. Let me make sure we've got everybody who should be here. Is Ray Padilla online? No. George Smith? No. Scott Casper? No. Randy Bartel? No. Brad Borman? No. And Jason Montoya? I don't see them. These are all kind of essential cast of characters that should be here. Out of deference, I'm going to, rather than start on the record, I'm going to wait about 5 or so minutes and see if they check in.
Mr. Rich,
Yes, sir.
do you have Mr. Rich Erskine in the waiting room anywhere?
I do. There he is. I see him. And there's Jason and Ray Padilla. Let me let them all in. Okay, here they come. Hello, everyone. Hi, Brad. How are you? And hello to everybody who's just been admitted. You were in the waiting room for a while there. I actually got online and had some small talk with whoever was admitted a little bit earlier. Mr. Marks, would you agree that nothing of substance was discussed before I've just admitted a whole bunch of people here?
Unfortunately, I would.
Okay. Unfortunately, you would. We are still off the record. You know, I actually joke a lot too, and I have to sometimes bite my tongue. And once we go on the record, there will be less joking, hopefully. Let me see someone. I'm looking at my emails simultaneously because sometimes I get relevant emails, like I'm in my car and I'm on the way and things like that. Nope, that wasn't one of those calls. Let me see if I can understand everyone's who's here and if there's anybody missing. Who is 5832? Please unmute and tell me who you are.
Mr. Hearing Examiner, that's my backup.
Oh, I've already, sorry.
That's all right.
Ask you that already. Is there something to be said for redundancy?
Absolutely.
And 5331, who was that? Did I ask already? Someone who is unmuted.
Yes, that's Greg Kelmanson, in-house counsel for American Medical Response.
Okay.
Want some water?
All right, so I don't need any water, and it is a courtesy to the other participants to keep yourself muted until you are talking, and it creates a little problem when I need to talk to someone right away, but it solves a lot of problem by not having errant, if you will, noises and dog barks and children crying and glasses clinking, coffee cups pounding on the desk while we're all trying to hear the audio. All right, but I will ask anybody at this point Is there anyone else we need to be present before we start this hearing? Which it's now 9:06. You may unmute and tell me, please. Okay. Mr. Borman, I note that Casey Dunn is present. Will she be testifying today?
Ms. Dunn will not be testifying. Staff's only witnesses, Mr. Montoya.
Okay. Is she participating as an observant?
She will be observing. She is working on a similar case that we have going as well. And so she will be seeing how the process goes. And hopefully that'll help inform her testimony that she writes later this month.
Okay.
Mr. Hearing Officer, this is Fred Maurer. I don't know if you can hear me. I don't see Miss Majori, nor do I see Randy Bartel.
Okay. I do see them both.
Oh, okay. Because I don't have them.
Hi, Fred.
Good morning, Randy.
You might try
Good morning,
scrolling.
Fred. How are you?
Good morning. Just checking.
Sometimes, we're all learning after all these months still how to run Zoom. And sometimes there's a scrolling function of the little postage stamp faces, and they could be scrolled off of your screen because they're certainly on my screen.
Yeah, I don't see them.
Try clicking that speaker view thing at the top. And speaker view.
Huh. And I don't have that. And I have to
Okay.
warn you, I am illiterate when it comes to working this, but that's okay. Just so everybody's here.
Well, I'm conscious of the various levels of literacy of the various participants, including myself. And I am learning all the time, and you guys are teaching me all the time, and I appreciate all the lessons. But it's now 9:09, and I've waited the New Mexico 10 minutes or so, and I think we're going to start this hearing. Ms. Hoyman, you're ready to go on the record? Excellent. Okay, on the record. Good morning, everyone. My name is Robert Lennon. I am a hearing examiner. I'm employed by the state of New Mexico, the PRC, and I am the designated hearing officer for the case of 20-00135 in the matter of the application of Helios EMS LLC for a certificate to provide ambulance service. I'm reading off of the caption. We also call this a certificate of public convenience and necessity. This is an official hearing. We're here to take testimony. This is the evidentiary hearing. Most of the direct testimony has been admitted in writing. However, this is an opportunity to cross-examine witnesses who have previously presented their testimony. We are broadcasting this hearing publicly on YouTube for anyone that takes the effort to tune in. There is a question of whether it's necessary, but to be cautious, I've decided to broadcast it even if it's not necessary. It seems to be advantageous to do so. So that's what I've decided to do. This is on the record. We have Ms. Hoyman, who is our court reporter today.
I know.
So someone please mute your microphone because I hear someone talking in the background. It's particularly important for Ms. Hoyman that there be only one person speaking at a time. I try to speak as slowly as possible. If I speak too quickly, Ms. Hoyman, hopefully you will tell me because I'd like you to record what is said. And the same goes for all witnesses and counsel. As for our schedule today, first of all, thank you all for being here. Welcome to the new world, the Zoom world that we live in. Because this transcript may be read sometime in the future. I don't mean a year, I mean years into the future. I think it's important that I make a preliminary opening statement of setting, if you will. The reason we are conducting this hearing by Zoom, which is an electronic communication system is there is currently a what has been known as the COVID pandemic, which is a virus. And since about March of this year, 2020, there's been restrictions, and they are government mandated, specifically state government mandated through governor's orders, that there not be in-person meetings, and that there be groups of 5 or less currently. At one point it was 10 or less. At one point it was something else. Anyhow, we cannot have in-person meetings, and thus these meetings are being held by Zoom. Let me think if there's anything else I should mention. No, I believe that's sufficient. So to set the stage. Anyhow, the proceeding today, hopefully we will complete today. And frankly, my hope is that we complete by 3 o'clock, because I have another meeting at 3 o'clock. We will likely take something of a lunch break. I'll confer with council before we do that, if necessary. If we can push through and complete this before any type of lunch break, that would also be beneficial. I'll try to talk as less as possible to keep the meeting as short as possible. The way I'd like to proceed is as follows. I'd like to have, well, I'm already doing it, an introduction by me, and then have everyone introduce themselves for each other, beginning with the applicant's counsel and then the intervener's counsel. This is traditional in any type of legal proceeding, as we would be in a courtroom. And it's also good for the sake of the record and for the general public who might be tuning in to hear this, as well as any observance. After we introduce, I would grant counsel the opportunity, not necessary, but to do an opening statement. In this type of case, it would be a very brief opening statement, perhaps 1 or 2 sentences, namely what relief is being sought or objected to, and what that party intends to prove through the evidence, which is mostly cross-examination at today's hearing, or the evidence which is presented in the pre-filed written testimony. So what do you intend to prove, which is normal in any type of a hearing? At that point, we can move on to anything which is open. And in this case, I note that there is the preliminary proceedings. One preliminary matter is that there is an open motion which needs to be disposed of, if you will. And that is what was entitled an unopposed motion for extension of time to file direct testimony. And that motion has to be disposed of before we proceed to testimony. So we will have a brief, hopefully, motions hearing. And then we will proceed to the testimony. As far as an order, Mr. Marks was gracious and submitted a suggested order. I have no problem with his suggested order. However, I would rather we do it slightly differently. And my suggested order of testimony would be that with which the PRC Records Department noted the intervention. So I noticed that the Records Department noted the intervention of, let's see here, Albuquerque Ambulance, and then, no, pardon me, excuse me. Yeah, notice Superior Ambulance first, then Running Bear, and then, then AMR, then Running Bear, then ABQ Ambulance, and then finally we would have staff. So it's slightly out of order from what Mr. Marks had suggested. Let me ask counsel as we go along, is there any reason we should not proceed in that following order? First Helios, of course, the Helios testimony, then Superior, then perhaps AMR, then Running Bear, then Albuquerque Ambulance, and then staff. Mr. Marks, any objection to proceeding in that order?
No objection, Mr. Lennon. I thought, I actually didn't check the dates. I went to commission's order, and I just assumed that the order that was in, that they mentioned the interventions was the date order, but apparently you've got it more correct. And we certainly have no objection to any order, and I think that's your prerogative, Mr. Lennon, so we'll work with that.
I think it is my prerogative, but I do like to confer with counsel. I heard someone else's voice. Does anybody else have any opinion about the order in which we should proceed with the testimony? No. Okay, and I'll state once again, I'm holding it up. I simply looked at the docket entries, and you know, when it's such there's an ambiguity, I look for some sort of sense when making any kind of decision, even a minor decision as to the order of testimony. And I don't know, perhaps it would be substantive. Maybe it would be some importance to the order of testimony. Anyhow, we'll have the applicant first, then the interveners, and with respect to Mr. Borman, I will proceed with the staff witness finally. Mr. Borman, is that fine with you?
Absolutely, Your Honor.
Thank you. And I know Mr. Montoya is online, and hopefully he doesn't mind waiting through the entire hearing to testify. That's just the way it goes.
He was warned.
Okay. All right, let's see what else we got here.
Examiner.
Yes, sir. Mr. Bartel?
I just wanted to mention, I don't know that this really bears specifically on the order of presentation issue, but my witness, Scott Casper, does have a hard stop at 3 p.m. He's got a COVID related meeting that is mandatory for him to attend at 3 p.m. So if the testimony is proceeding such that it looks like he is not going to be able to testify in the order that you have indicated in time to leave by 3 p.m., I may ask later that the order be revised to accommodate that.
Absolutely. A normal request, and it's fine. And I'm sure the other counsel and other witnesses would be grateful if you extended the same courtesy to them. And who knows, it may actually happen. Let's see, I try to talk less, but I do need to cover a few things I have on my notes. I have received a large quantity of what I call potential exhibits and potential evidence. And I want to make it clear that evidence is not evidence until it's evidence. And I do not review things which are not evidence. This case is just going to be decided on the evidence and on the evidence only, and until it's admitted, it's not evidence. So I did receive, I can hold up graphical representation, evidence through email or potential exhibits. I have them. I have not reviewed them. Of course, as they came out of my printer, I glanced at what they are. It appeared to be some pleadings, even pleadings from other cases and things. None of this is evidence yet until it's admitted. I have not reviewed any of it. There also has been some discovery done. I have not reviewed any of the discovery. I don't review the discovery responses in advance, and I did not review the discovery interrogatories or whatever other discovery devices might have been used. So unless it's admitted into evidence, it's not evidence. And what I have, however, I would like to reveal for the record, I have reviewed the pre-filed direct testimony of the witnesses. In fact, I spent most of the day yesterday reviewing the file, the afternoon anyhow, reviewing the file and the pre-filed testimony. So I'm somewhat familiar with it. I expect that there will be cross-examination today for each witness who has filed pre-filed testimony, and that will take up the bulk of our morning and whatever part of the afternoon we might need. I have perhaps some questions of each of these witnesses. Very often, my thunder is stolen, if you will, that's a legal lawyer's terminology, by the cross-examining attorneys, and I don't get to ask my questions because they've already been asked. I hope you all will do that for me, and I hope there'll be some good cross-examination. Let's see, what else have I noted here? breaks. I like to take a break, you know, maybe 5 minutes, and I do mean a real 5 minute, not a 10-minute 5 minute, every hour or so. But the reality of it is it's gonna, if there's gonna be breaks, they'll be at the end of a testimony, not interrupting any type of testimony. If there's some reason someone needs to take a break or there's some other procedural interruption, you know, raise your hand. There's the actual hand, or you have these little hands built into Zoom. Last alternative is to turn off your mute and interrupt the testimony. That's the least favorable option. Okay, I occasionally in hearings have sworn in all witnesses in the beginning of a hearing. It saves time. However, in this type of hearing, it's my choice to swear in the witnesses each right before they testify. I just think it's more appropriate for this type of a hearing, especially one on Zoom. So if I forget to swear you in when you're about to testify, please tell me. That does happen. I have sworn in witnesses after they've testified. It's still appropriate. Just the slightly different language is used when they're sworn in. Okay, anyhow, let's move on to the hearing and have counsel introduce themselves. I'll ask counsel for the applicant, Mr. Marks, please, for the record.
Yes, Mr. Lennon, this is Jason Marks, representing the applicant, Helios EMS LLC. We're joined by Marcus Priestkop, who is our witness and a co-owner of applicant. And then also present in this hearing is Rich Erskine, who is the other owner of Helios. He is not a witness, he's just observing the proceeding.
Thank you, sir. And in my order of presentation, I next have Superior. Counsel for Superior, please.
May it please the hearing officer, this is Fred Maurer on behalf of Superior, and with me today, I believe, is Mr. Chris Archuleta, who is president of Superior Ambulance Inc.
Thank you. Counsel for AMR. I believe you're online and you're on one of those telephone lines, sir. Please.
How's that? Is that better?
Counsel for AMR?
Can you hear me on the telephone line?
Yes, I can. Please identify yourself.
All right. Ann Mazziori, and I'm here for American Medical Response. With me is Joaquin Graham. He's the regional director for AMR, and Greg Kelmanson, in-house counsel.
Welcome. And before we go to counsel for Running Bear, once again, of course we know each other, and you guys know each other better even than I know you, but we're creating a record for the future. Next, counsel for what I affectionately know as Running Bear. I love the name. Please.
Ray Padilla for Running Bear Rescue. With me is George Smith, who's the authorized representative of Running Bear in this particular matter. And I have one thing that I wanted to mention, Mr. Hearing Officer. You have not mentioned thus far public comment, and I'm assuming that's because nobody has requested to be allowed to make public comment, but I just wanted to make sure that we covered that area.
Thank you, Mr. Padilla. Is that your witness hand I see on the right-hand side there? Is that Mr. Smith?
It is.
Okay, thank you. Hi, Mr. Smith. You're a little bit out of the camera frame. You guys might want to point the camera a little the other direction so he's in the camera frame. Looks like you've got plenty of extra seats there in that boardroom. Concerning public comment, I normally make that announcement immediately prior to the testimony, and we will do it at that point. And thank you for the reminder. And next, Albuquerque Ambulance, please.
Yes, this is Randy Bartel on behalf of Intervenor Bernalillo County Healthcare Corporation, doing business as Albuquerque Ambulance Service. And with me today in the meeting is our witness, the Chief of Albuquerque Ambulance Service, Scott Casper.
Thank you, sir. And finally, last but not least, Council Borman, please, for the record, identify yourself.
Thank you, Mr. Hearing Examiner. My name is Bradford A. Borman, appearing on behalf of Transportation Division staff. I'm joined today by our witness, Jason Montoya, who will be testifying later in the day, and Mrs. Casey Dunn is here to observe the proceedings.
Thank you, and welcome, Mr. Montoya and Ms. Dunn. Okay, let's have just a brief opening statement, and I do mean brief. You can elect not to do an opening statement if you wish. I'd like to hear what you intend to prove with your testimony you intend to offer today, and then we will move on to the motion hearing, and then we'll announce the public comment opportunity, and then we will move on to testimony. So, Mr. Marks, what do you intend to prove today?
Thank you, Mr. Lennon, and good morning to all council and witnesses. It's good to see everyone again, even if we can't be present in person. Helios EMS has applied for a certificate for ambulance services, statewide authority, so points and places in each from and to each county in the state of New Mexico, with equipment to be stationed in Santa Fe County. But Helios is not seeking to be certificated for all ambulance services. They're seeking to be certificated only to provide interfacility transport. And as our file testimony indicates, Helios would also like its certificate to indicate that it could provide pre-hospital services, but only subject to a mutual aid agreement with a pre-hospital or 911 provider. So that what we've more colloquially talked about is backup service. And it will be our case that Helios has satisfied the statutory requirements to be granted that certificate, and we look forward to putting on our witness and to arguing that in whatever form of post-hearing briefing that the hearing examiner may determine.
Thank you, Mr. Marks. Mr. Maurer, please.
If it may please the hearing examiner, parties who are present, this is Fred Maurer. Superior's position will be as follows. One, that there is no need for the requested service in Santa Fe or Santa Fe County, that Superior, as an example, has more than available equipment and ability to provide the needs of which we have primarily seen in the testimony of St. Vincent's, now Christus. Secondly, that we do not believe from the evidence which has been provided by the applicant, Helios, and if I mispronounce Helios and or the spokesperson, I apologize, that they are not in a position to provide the requested service, both on availability of equipment, financially, and through their projections of how this process would work. And that our relief would be that the request for a certificate be denied.
Thank you, sir. And Ms. Maggiore, counsel for AMR, please.
Subject to your ruling on our motion.
Exactly.
Our position. I'm sorry?
Yes, ma'am, please.
Subject to your ruling on our motion, AMR's position would be, we do agree that there is a need for additional service, but we disagree with just about everything else, that Helios is fit and able and ready to provide service to meet the need. As most everyone here knows, AMR has also applied for a certificate. That hearing will be held in a few weeks, but our position right now is that there is need and that we would like to be the ones to fulfill that need. Thank you.
Thank you. And counsel for Running Bear, please, sir. Mr. Padilla.
Yes, sir. Rocky Mountain agrees with Mr. Maurer and Ms. Maggiore that Helios is not in a position where it can provide the services. We also believe that Helios has not proven through its testimony and the testimony that's going to take place here today that it can't be proven that there's a need. What's happening here is Helios is focusing on Christus St. Vincent Hospital and Santa Fe County, but then says that it wants statewide authority. It's the position of Rocky Mountain that under the statute, statewide authority is not allowed under the Motor Carrier Act. And there are 2 carriers or ambulance services in New Mexico that have it, but that was before the Motor Carrier Act was passed and they were grandfathered in, to my knowledge. So Helios, I don't think can seek statewide authority or be granted statewide authority. And in addition, in some pleadings, it's indicated that Helios wants to transport deceased patients, and we don't believe that the PRC can grant the authority for any ambulance service to transport deceased persons. Deceased persons, in our opinion, are to be transported by funeral homes. So that aspect of any licensing that should be considered, that might be considered, should not be granted.
Thank you, sir. Mr. Bartel, brief opening.
Thank you, Mr. Hearing Examiner. The position of Albuquerque Ambulance Service is pretty simple. We do not believe there has been an adequate showing of need either in Santa Fe County or statewide. And we think that the applicant has failed to show that the existing authorized ambulance providers, both in Santa Fe County as well as in the rest of the state, are not providing continuous and adequate service at this time. So we believe that this application should be denied for a failure by the applicant to even have made a prima facie showing under the statute.
Thank you, sir. And Mr. Borman, please.
Thank you, Mr. Hearing Examiner. Staff doesn't feel the need to make an opening statement. I think our position, as the positions of all the other parties, are well set forth in the testimony.
Thank you, sir. Appreciate that. And thank you all, council. I want to remind everyone that all direct testimony was to have been submitted in writing. And there will be no direct testimony today. The testimony today shall be cross-examination of the witnesses who have presented direct testimony. And today is an opportunity to cross-examine. I just wanted to make that clear, lest there be any confusion from the opening statements. Anyhow, moving along, we have that motion to deal with, and unless there's something else, I'm going to move to the motion, and then we'll announce the public comment and begin the testimony. Is there anything else we should address before the motion? Council, anybody? Okay.
Mr. Hearing Examiner,
Yes,
I do
sir.
have one issue that I guess we should deal with at least before we go into taking the testimony. And the issue is that of the application.
Yes, sir.
And I guess it's not clear to me how the application is going to be treated in this case. I mean, is it going to be made automatically a part of the record? Or does a party, I guess I would imagine Helios, need to move the application into the record?
Well, it would be more clear if they did move that it be admitted into record, and that I grant that motion that it be admitted into the record. It's my opinion that it was filed, so it's part of the public record, if not part of the hearing record as we speak. And it could be acted upon even if it's not admitted in this hearing. But to cross the T's and dot the I's, I welcome Helios to move its admission. And thank you, Mr. Borman, for bringing that up. The time to do it would be when they're presenting their case, including the pre-filed testimony. I think. Okay.
Mr. Hearing Examiner, this is Ray Padilla.
Mr.
It's my
Padilla.
understanding that Mr. Priosk specifically adopted the petition or the application as part of his testimony. So I think it actually is part of the direct testimony of Mr. Priosk in any event.
Thank you, sir. I saw that, and I also saw that many other documents were mentioned as in several of the testimonies. Many other documents were referred to, and frankly, I have just a small problem with generally incorporating by reference documents and testimony, and whether or not they become evidence just because they are referred to by the testifying witness. In fact, I believe to the contrary, a document referred to, even if it's identified as an exhibit, even if it's identified as an attachment, even if it's identified as a filed pleading, does not become evidence simply because it's referred to by the witness in the direct testimony. And that concept, a foundation would need to be laid for any such document before it would be admitted as evidence. And that's a very similar concept to simply referring to anything else in the direct testimony. It does not become evidence just because it's referred to in the direct testimony. There would still have to be a foundation, at least a minimal foundation, as to relevancy before I would admit a document into evidence, and before it would be considered when I write a recommended decision. I hope that addresses your concern, and that gives you an insight as into how I rule and how I perceive these things, and what is not evidence. So that's something I'd intended to address with each witness in particular, particularly the ones that had referred to attachments to their testimony. So that being said, are there any other concerns from council? I welcome this. This is a time to get these things into the daylight. Anything else before we move to the motion? Yes, ma'am. Hi.
Hi. Just with respect to the application, if it is moved that it's going to be made part of the record, there are two unverified statements that were presented as part of the application. They're essentially short letters of support, and it's always been my understanding that supporting affidavits are what is required within the application. So I would move to strike those two letters as being inappropriate because they're not verified.
Well, I'm not going to roll on that motion now, but it's good that you brought that up. When there's the motion to admit, we'll address what's attached to the application and whether or not it should be admitted. And you're welcome to object at that point and raise that issue, and we'll roll on it at that time. Thank you for bringing it up. And that was Ms. Maggiore. And for the record, is there any other? I see Mr. Preskop is talking, even though I can't hear him. Are you talking on the record, Mr. Preskop?
Mr. Lennon, he is not. We were conferring about some matters, and
okay, I'm sure he doesn't.
We will unmute and seek your attention if we wish to put something into the record.
That's fine, and I'm also I actually have a callus on my side from clients pushing their elbow into my side at the trial table. Most lawyers understand that, and there's a long tradition of clients whispering into the ears of lawyers at the trial table. However, I would ask you, it dissuades you from doing so and not taking advantage of our electronic system here, because it's a bit disorientated when I'm looking at my faces here and I see people talking and I don't hear what they're saying. So thank you very much. There's some idiosyncrasies of this Zoom system, and that's one of them. Okay, before we do testimony and public comment, let's talk about the pending motion. Pending motion could be resolved in several ways. One would be withdrawal of the motion, and I'm not suggesting that it be withdrawn, but I open this this proceeding at this point for a brief hearing on the motion. And let me make sure I got this clear. The motion is entitled Unimposed Motion for Extension of Time to File Direct Testimony. It's filed by Ms. Maggiore, and it was received by myself at 5:16 p.m. on Friday, November 6th. And I looked at the docket entries on the PRC record, and I do not see where it was actually filed with the records department. So that may be something you might want to address if you intend to argue this motion, and also whether or not the motion is now moot or not. And I would ask you also to argue the nature of the motion, whether or not it was in fact unimposed, and any factual basis for the allegation that it was unimposed. Anyhow, that's quite a bit of telegraphing going on there, Ms. Maggiore. It's all yours, please.
Obviously, if you are inclined to allow me to file the pre-filed testimony, I agree the motion is moot. So if that's the case, then we can stop there.
Well, frankly, I'm not at this point inclined, and I don't know that the testimony has been pre-filed, and I'm having a little trouble finding out what the testimony is, because I have never received a copy of the testimony. I don't mind having this conversation at this point so that we can properly frame your motion, but I want to let you know that the only thing I received, so that you can properly argue your motion, is a final page, and I don't mind holding it up. I received what appears to be the final page, the affirmation part of Joaquin Graham, also dated November 6th, and I didn't receive the body of the document, so it has not been filed with me, and it has not been filed with the PRC that I know of, according to the docket entries. I did, lest I be unclear, I did, however, receive a document at 4:13 p.m. The thing I just described was received at 4:29, and it was received by me, not directly. It was received by me because I was included in a long list of recipients in the CC portion of an email sent from Delight Rylance to Jason Marks. So I received it somewhat sideways, if you will. And then that was 4:29. At 4:13, I had received, that's 13 or 16 minutes prior to that, I'd received a Word document. And I'm very fond of Word documents, by the way, because I can use the language in them without retyping it. But that's an aside. I received also as a CC recipient, not as a direct recipient, of an email from Delight Rylance to Jason Marks. I received something that's not captioned at all, rather. I don't know if you can see that, but maybe you recognize it. And it's the questions that, and the answers that might have been in the testimony, but it was not the testimony. So I received that. And I received these as CCs to someone else, and it would have to be a stretch for me to construct them into something which is testimony, to consider that it was filed by sending two portions as CCs to me, which I need to construct. And furthermore, they were not, as I said, filed with the commission, according to the commission's records, anyhow, that I can obtain through the online InfoShare e-docket. So those were my concerns. And like I said, I don't know if you know this, I don't hide the football. That's what I want you to address and tell me about. why, I guess the question is, why should I accept these things, two things which are not even a pleading, and accept them as pre-filed testimony? Thank you. And I'm not trying to pick on you. I'm quite the contrary. I'm trying to give you the benefit of my concerns so that you can address them. Please proceed.
Sure. Let me explain what I know, and I'm also going to explain what I don't know. I discovered last Friday, as I was starting to prepare for this hearing, that the pre-filed testimony had not, in fact, been filed. It was drafted, it was in my computer, and due to inadvertence on both my part and that of my staff, it never actually got filed. So needless to say, that set off a scramble on my part to get things done. I was out of the office. I was in various and sundry hearings, depositions, and whatever that day. I asked my paralegal, Delight Rylance, to pull everything together. The testimony needed to be formatted and notarized. We got that accomplished, and I asked her to file, to first contact all other counsel regarding the proposed motion. By the time that I did not ask her to file it as an unopposed motion, I do understand that subsequent to it being filed, there was opposition from staff as well as from Helios, which I do understand. And the motion should not have been filed as an unopposed motion because there was opposition. The other parties who responded had no opposition. My intent was that the proposed pre-filed testimony be sent to all counsel so that they at least had it. I did not feel I should file it or attach it to the motion without I didn't feel that I should make it part of the record without having permission to do that. So that's kind of where we stand, and that's what I know and what I don't know. By way of an excuse, the day that it was due was the day we had that horrible snowstorm. Nobody was in my office. Second day, my staff didn't show up, and things just kind of went downhill from there. I wish I had a better or a more eloquent excuse, but I don't, and that's where we stand. I attempted to rectify everything the second I was notified of it. We've just had a lot of people in and out of the office given the restrictions from COVID, and things are not proceeding at all the way I would like them to.
Alrighty.
So essentially, I'm just asking for everyone's patience and asking you to allow me to file that testimony. If you decline to allow me to file the testimony and allow my client to testify, then I would ask that my client be allowed to testify during the comments period.
All right, thank you. I have a question. You referred to that testimony. Could you tell me which testimony you are referring to?
Yes, we drafted direct testimony of Joaquin Graham from AMR. And that testimony was supposed to go to all counsel and was supposed to be filed with the PRC.
Was that the Word doc which I received at 4:13 p.m. on the 6th?
It is possible that that is what I received. Unfortunately, again, I was out of the office and unable to give one-on-one direction to my staff. What I asked them to do was to file the motion and to send the Word document containing the direct testimony to yourself and all counsel.
All right. Well, it was sent to me only as a CC, but that's a distinction without a difference at this point. My concern is it's not executed, and I haven't been in law school for about 36 years or so. But when documents aren't executed, I call them paper. So my question is whether someone is unmuted out there. So my question is whether this paper, is your contention that this unexecuted paper received by me as a CC recipient, 413, is the testimony?
Well, what you should have received is an executed version.
Okay.
Can you hear me?
Yes, ma'am.
What you should have received is an executed version of Mr. Graham's testimony.
Okay, well, I didn't.
It should be. Okay.
What I received is an unexecuted and a very rough copy. So I'm not going to, I haven't done the final ruling of the motion yet because I haven't heard from the other parties. But I just want to make sure I'm clear that whether or not you're contending that the unexecuted paper was actually testimony. So my next question is the document that I received as a CC recipient 16 minutes later, which is looks to me like the final page of testimony, but only the final page. Is it your contention that this document is the testimony? I didn't hear you. Sorry. Yeah, that's what I received. Only a one page. It's like the final page. It's the final page, the signature page of testimony. But there's nothing. It actually begins mid-paragraph and mid-sentence. Indicates at the bottom that it's page 6 of 6, but page 1, 2, 3, 4, and 5 were not sent with this signature. And while I'm at it, I'll mention that the other thing that was sent 16 minutes later was not 5 pages long. So my question, I'm doing this as methodically as possible, is it your contention that this page is the testimony?
My contention is that the page should consist of a cover page.
Yes, ma'am.
Indicating what it is. It should say before the New Mexico Public Regulation Commission. It should have the case caption. It should be titled Direct Testimony of Intervenor Joaquin Graham, American Medical Response. And it should be 6 pages long, with the final page, I believe, being the one that you did receive.
Okay, but that's what it should be. Are you contending that number 1 you sent and number 2 that I received something other than that's in fact what I did receive and what you did send?
I can't see well enough what you did receive other than the last page.
Well, that's why
my contention is that there should be a full packet, and it seems as though there's not. What I can offer to do is to attempt to get the entire packet sent to you and to all council and see if we can start over.
Okay. Next thing, I want to, I'm not trying to make life difficult. I'm trying to cross the T's and dot the I's as I speak and create a full record because complete full record. We've lost somebody, and let's see if, okay, I don't see Mr. Marks. Maybe he dropped off. Let's give him a minute to get back on. You know, that's the nature of these Zoom hearings. Sometimes the internet drops out on us and we lose each other. It's nice that we can all work together and work with each other while we're struggling with this technology. Mr. Marks, are you online here?
We appear to have some internet issues here.
Oh, I see.
And I'm piggybacking on Mr. Prieskop. I'm back now.
Okay, great. Did anyone else drop offline? I don't think so. I just heard some binging off of my computer while I was looking down. Okay. All right. Thank you, Ms. Maggiore. Is there anything else you'd like to argue in support of your motion before let's hear from council in opposition thereto?
Mr. Lennon, I missed probably about a minute of what Ms. Maggiore was saying, but I think I got the gist of it earlier, and I don't need it to be reprised. We object on 2 or 3 different grounds. And first is just the, I'm going to say form, and it's more than form though. It's the issues that you've been going back and forth with Ms. Maggiore on, which is that there is no motion that's actually filed in the docket. The motion that's been circulated improperly states that it's unopposed when both myself and Mr. Borman informed them that we were opposing it. I did. Ms. Maggiore asked us to reconsider, and I told her I would, and that if we changed our mind, we would let her know. And that was before the 5 o'clock time, I think. We did not change our mind. But more critically, as you identified, there's no testimony that has been filed or has even been served in a form that's meaningful. I received the Word document. And I took that to be a draft of the testimony to give us an idea of what we'd be seeing if we consented to the motion. It did not appear to me to be final testimony just because it, what wasn't formatted. It looks like what I typically work, my typical work product, not testimony. And at this point, there is no testimony that we could effectively cross-examine with page numbers, line numbers, with Q&As. And so just on that basis, and I will point the commission to Rule 1.2.2.35 I2 in the code, which is the specifications for pre-filed testimony, which require them to have page numbers and have case numbers and witness numbers and so forth. So that, I'm not sure what we would do if you were to grant the motion. But secondly, we also opposed it. We anticipated that there would be some testimony that AMR would put forward in connection with the formal filing motion. They did not, but staff and Helios responded in a filed response that on the merits, which is essentially that it's ordinarily, I make these mistakes all the time, and as Mr. Borman pointed out, I just remembered about a few minutes before he mentioned it that we need to introduce the application. We make mistakes all the time, but this came, and if it was Mr. Pat asked for time because of the snowstorm, not an issue. In this case, it just came too late. If the testimony had been provided to us when I expected it to have been, it would have been this week. It would have been after we'd already filed our rebuttal. It would have been when we were doing other things to prepare for the hearing. And for those reasons, even if the forum had been proper, we objected to granting leave just because it came so late and made it hard for, certainly we could not have filed rebuttal at that point, and it just made it hard. And so for both those reasons, that it's too late, and because there really is nothing before the commission, we would ask that you just dispose of this motion and not grant it.
Thank you, sir. And since Mr. Borman and his client joined in the motion, I'll go slightly out of order and ask to hear from Mr. Borman if he cares to add anything to Mr. Marks' comments.
Thank you, Mr. Hearing Examiner. Yes, we take the same position basically as outlined by Mr. Marks. I would just add a few comments. I guess first, we're hearing from AMR about all the things that they were intending to do and they thought they were doing, but the fact of the matter is, we have to deal with the information that was actually provided and what they actually did do. And what they did do was not file testimony and not seek to file testimony until well after the rebuttal testimony was due. I mean, as Mr. Marks pointed out, we all make mistakes. I've made them. He's made them. If a deadline slips and somebody needs an extra day or an extra couple days, I try not to be too technical and say, oh no, you missed your deadline and that's it. This happens, and this is administrative proceedings, and we try to work with everybody. But that's not really what happened here. In fact, Mr. Padilla, he knew that he was going to miss the deadline or was likely to miss the deadline because of that same storm, asked for time up front. And I think all the parties, I know staff agreed to an extension of 24 hours. I think everybody felt that was a reasonable approach. And so he was able to file his direct testimony, after the deadline. And we had no problem with that. But seeking to do so after rebuttal testimony was due, I mean, to me, that kind of goes beyond the just simple error and missing a deadline. I mean, that's changing the whole scope of the proceeding. And I think at this stage, it would just be too late to grant the relief that AMR is seeking.
Thank you, Mr. Borman. And at this point, any of the other counsel for any other interveners are welcome to argue in favor or against the motion. I presumed against, but perhaps in favor as well, not to be presumptuous. So I'd like to hear from Mr. Maurer first. If you have any argument you'd like to make, you need not, though. Mr. Maurer?
Yes, sir. I'm hoping you can hear me.
Yes.
I have taken a position and have announced as such that I did not oppose the relief sought within the motion. I understand what Ms. Majori's explanation of what happened here is. And as indicated by Mr. Borman, mistakes are happened. There isn't anyone in this proceeding to include counsel for the applicant who is not sufficiently trained and knowledgeable of the rules in these proceedings to be able to handle this particular issue. I got a copy of the testimony. I don't think it's prejudicial. Pretty much takes a consistent position with the rest of the interveners. And I would argue that you should allow it to be introduced and allow Ms. Majori to present her witness.
Thank you, sir. Counsel for Running Bear, please. Mr. Padilla, your position?
Yes, sir. As if I'm understanding what Ms. Maggiore said correctly, she's kind of caught between a rock and a hard place. She forgot, or she didn't realize that the testimony hadn't been filed. So she prepared the motion, but then she didn't go forward and actually file the testimony because the motion hadn't been heard and she hadn't been granted. So in essence, she tried to comply with the rules and not file the testimony. I think I heard her say that she didn't want to make the testimony public until she had a ruling. I think the strongest argument that's being made by staff and by Helios is that the time for rebuttal has passed. Well, I've seen the PRC in the past admit testimony such as this and then simply allowed the rebuttal to be part of the cross-examination or allow the witness, in this case, Helios witness, to provide rebuttal. And I would assume that the hearing examiner would give them a little bit of time to prepare the witness to provide that rebuttal, but I think that the fact that rebuttal is past due can be cured by taking that approach. So I would support granting the motion.
Thank you, sir. And Mr. Bartel, you have an opinion? You have any argument?
Mr. Hearing Examiner, we did not oppose the motion. We have not changed our position on that. I am concerned that it is only now being addressed because it does seem that from a due process standpoint, adequately allowing everyone to address the testimony would be difficult at this point, but we're not going to oppose the motion.
Thank you, sir. All right, I think that covers all the parties, and you all had an opportunity to argue in favor or against. I am in an unusual position, and it's my job. And my job is to rule on these types of things. And I'm always conscious of being reversed on appeal, frankly. And when I was an attorney, I did quite a bit of administrative proceeding appeals, judicial reviews of administrative proceedings. And I would always look for rulings on motions in particular, such as this, to use as the grounds for reversal on appeal. So I'm very conscious of making this type of ruling, lest it be reversed on appeal. So I do take it very seriously. And my position is that I am not a slave to the formal regulation if it does not reflect reality. And I'll tell you what I mean by that. In this particular factual scenario, I did receive that informal, what looks like worksheets internally, and I suspect that that's what the witness would have testified to. I did also receive his signature with the final page, and that's probably would have been the signature. So the question becomes, can I make a stretch that that's what the testimony is? The next thing, the answer is not so much whether I can make that stretch. There becomes another question, is whether it had ever been filed. And I believe the answer is clear that the answer is no. However, I would look at the reality of the situation and see if all the interested parties had received the equivalent of filing, which means received the same documents I had received. They're in the same position as me. Experienced counsel, and can put the two papers together and if, in effect, create one, the document that would have been filed had it been filed. So my question becomes whether or not the underlying facts as they exist in this case, in this scenario, if you will, were prejudicial to the parties. Now we have 1, 2, 3, a majority of the parties, not that a majority would rule, but a majority of parties have no objection to granting of the motion. However, we have 2 of the parties who object to the motion, and I think they object for multiple reasons. One, the mischaracterization that there was in the motion that there was no opposition. And I take, frankly, a particular interest in that because, be honest with you, I rely upon the characterization in motions of whether or not they are opposed or unopposed. And I treat motions that are unopposed quite differently than motions that are opposed. So it came in as an unopposed motion, and then it turned into an opposed motion. So I take that argument and that perception of the 2 parties that oppose quite significantly. Mr. Borman argued that the whole nature of the proceeding has changed when even if we arguendo considered what has been received by me and presumptively all the other parties as the testimony, the whole nature has been changed because it arrived after the rebuttal period. In other words, it's just not only too late pursuant to the rules of the commission and pursuant to the procedural order, it's just too late, period. Too late to be useful for the purposes that the deadlines and the procedural order deadline exist. It's just simply too late. And therefore it becomes prejudicial. So the question is whether I agree that it has become prejudicial. So as to the question of whether the motion has been filed, I'm going to find that in effect, despite the fact that it's not may or may not have been filed at the commission, it's effectively filed because I received the motion, and there was a response to the motion, and the other parties had an opportunity to, if not respond in writing, to state their position at this point. So I think there is a motion. I'm going to rule on the motion. I've heard from all the parties. My ruling is to not grant the motion. My ruling is to exclude or to not consider as the testimony the one-page, final page, signature page, and the looks like attorney work product Word document, internal document as testimony. I will not accept that as testimony. That's frankly too much of a leap for me to make. I don't think it's prudent as the trier of fact to find that and consider as testimony. Secondly, I believe if I were to do so, it may be prejudicial because of the late filing, late nature of it, even if it's considered a filing. And I'm not adverse to an informal filing, as I said, if there's no prejudice. However, there has been argument that this is prejudicial. I tend to agree that it could be prejudicial. And I want to make one more thing, a few more things clear. Number one, because MR is a intervener, and even without testimony, they remain an intervener. I believe they have every opportunity to cross-examine the witnesses whose testimony I presume will be introduced into evidence, all the pre-filed testimony. So she certainly has an opportunity on behalf of her client to cross-examine. And that's what this hearing is about today, cross-examining, mostly about cross-examining the witnesses in addition to, of course, formally admitting documentation. So that opportunity is certainly still there, and that's certainly a valuable opportunity. I will not allow, however, direct testimony in the guise of cross-examination. So I'm conscious of the distinction and will strike such things. So I'd ask that not occur. And finally, I've already ruled on it, lest I be too clear, Mr. Borman raised something involving Mr. Padilla and the motion that he had filed. And I want to state that each motion stands on its own. I'm not going to rule on this motion differently or the same because of any ruling on that motion. And furthermore, each case stands on its own. We are deciding this case, no other case, even if there are similar parties or similar issues. This case stands on its own. And finally, I want to soften my statements with Ms. Maggiore. I want to tell you that how do I put this? I too have problems with things like this, and things happen, and I understand that things happen. And as Mr. Borman states, this is only, he didn't say only, but he said administrative hearing, and we are all members of this local regulation bar, and we'll try to work with each other because we will be working with each other in the future. You may find it interesting that I was out of town for 10 days, and I was without internet service or even phone service for most of those 10 days. And of course, when I came back from being away for 10 days, I had a stack of emails and a stack of things to deal with. And I was very concerned that no party be prejudiced from myself being out of town and incommunicado for most of that time period. I was actually camping in Death Valley, if you were wondering how a person can be incommunicado these days, but it is possible. So anyhow, I identify with the issues of the problem with the snowstorm, which I actually missed, and I identified your problems with staff, and I identify with the communication problem. Unfortunately, although I take all that into consideration, and I actually feel your pain, if you will, I feel that I have no alternative but to rule as I have, and I'm going to deny the motion. And so we're going to, I believe at this point, take a 5-minute break. And when we come back, we'll have the opportunity for public comment, and then we'll move on. Are there any other questions or any topics before we take a 5-minute break? I see somebody's lighting up. 4339 lit up. Okay, you're not muted. Who's that?
Oh, that's me, but I didn't press anything that I'm aware of.
Okay, all right. Anyhow, all right, so we're going to take a 5-minute break. It is now 10:18, and we will return in 5 minutes. Time to get your coffee and use the facilities. See you in 5 minutes. I'm going to let the recording continue to run.
Ms. Maggiore?
Yes.
This is the stenographer. Could you please spell the first and last name of your paralegal?
Yes, the first name is Delight.
I'm sorry, you're breaking up. Could you perhaps put it in the chat?
Could I perhaps do what?
You're breaking up. Could you put it into the chat? Click the chat button.
Oh, the chat. Yes, I can do that.
Thank you.
All right, 5 minutes have gone by and I'm ready to proceed. The next thing I'd like to do is open this hearing for Ms. Hoyman. Are we on the record again?
Yes, we are.
Thank you, Ms. Hoyman. Back on the record after a short break. We're ready to proceed with the public comment phase. This is a public hearing. I have not received in writing any requests for comment by the public. I've received no public comment either in writing. So that at this point, there is no public comment, although the public in theory could testify at the hearing without having requested, even though I asked that they not do so. There is a procedural order which states forth the procedure for requesting the comment and sending in comment. Nevertheless, are there any members of the public present who would like to comment? All right, I will, I heard.
Sir, this is Ann Mazziori. I would ask that my client be allowed to comment as a member of the public.
Okay, well, that's interesting, and I knew that topic was coming. I want to make this clear, and I'm stating this for the record, to avoid being arbitrary and capricious, which is that other type of appeal argument, that I don't let things come in through the back door when they can't come in through the front door. And I'm certainly not going to let his testimony come in through public comment if it couldn't come in as testimony. But he is welcome as a member of the public to comment as he wishes, and we're going to allow that. But I want to make it perfectly clear that public comment is not evidence. And the second prong of that fork is that the case is decided only on evidence. And I need not be more clear. So yes, I believe he's the only one we have for public comment, and he's welcome to identify himself and comment publicly at this time. Sir, the floor is yours.
Mr. Lennon.
Yes, sir.
This is Mr. Marks for Helios, and I just want to preserve an objection on the record that under the procedural rules, Commission's procedural rules, it's clear that a commenter, a party cannot be a commenter. It's very clear, and I assume you're aware of that, and that you're allowing this gentleman to comment in his private capacity. But we would still object that he's actually, as you put it, he's coming in through the back door, and he doesn't have a private interest in this. His interest is as an employee of AMR, and because that's contrary to the rules, we object. And I want that noted for the record.
Thank you, Mr. Marks, and it is noted for the record. And I might comment that there is a concept of real party and interest. I believe there's a corporate entity involved here, and we could get into piercing the corporate veil and all that, those types of arguments. But this gentleman, whether or not this gentleman is in fact the party is another issue, which I need not address at this point. But you know, it might come up in any type of legal brief, in any type of appeal. Should you try to argue that me allowing him to testify would be prejudicial? I want to state once again that his testimony, public comment, not his testimony, to strike that. Public comment is not evidence, and the case will not be decided on anything but the evidence. So thank you, Mr. Marks, and I thought it was necessary for me to respond to your comment. Now that I've responded, and is there any other parties, and including Mr. Marks, who would like to further comment or preserve any objection for the record?
Mr. Lennon, this is Ray Padilla. I don't
Yes,
have
sir.
a comment. I don't have a comment on the subject matter, but For some reason, I cannot see you. I can hear you. I don't know if the other parties can see you or not.
No, I can't.
There you go. I can
Thank
see,
you.
I've got Mr. Marks, but I do not have the hearing officer.
I can see the hearing officer now.
All righty. I'm sorry about that. That's all I've got. It's just me. You know, yeah, a little levity is sometimes nice. I was thinking during our break that one of the nice things about Zoom hearings, and Ms. Hoyman, you can use your discretion whether to include this in the transcript, is that I don't run into the witnesses and litigants and counsel in the men's room during the breaks, which is always an unfortunate and difficult position when you're trying cases. Anyhow, with that comment, somewhat off the record, to lighten the air in the courtroom, the Zoom hearing room, I'll once again allow any other argument concerning whether or not this gentleman should be allowed to comment as a member of the public. There being none, I'm going to hear from him not as a party, because he's commenting as an individual. Yes, sir. Please identify yourself for the record, and I'm going to ask you to comment as an individual.
Well, good morning, everybody. My name is Joaquin Graham. I am the Regional Director for American Medical Response in New Mexico. I'm here to comment as a member of the public and a citizen of New Mexico.
May I ask you, are you an owner of that company?
I am not an owner.
Okay, you're an employee with a fiduciary obligation to their best interest, though. Is that correct?
I am an employee of the company, yes.
Okay. I'm going to caution you to please not dictate or attempt to enter into the record what you had. I'm presuming, because I don't really know, but what you had offered to your counsel as your testimony, because this is not the time to offer your testimony. With that caveat, please proceed, sir.
Understood. So then I think I would limit my public comment to say that it seems to me, as a member of the public and somebody who's familiar with ambulance services, that the granting of a statewide certificate to Helios is unprecedented and potentially puts all ambulance services in the possibility or the realm of being able to really kind of cherry pick or cream skim calls that are not in their jurisdiction. It's hard to justify or understand how a service could provide adequate coverage to an area that is 200, 300 miles away from where their closest ambulance could be. And really, I guess I don't want to drag this on. I want to also preserve our rights as an intervener. So with that, I'll say nothing more. Thank you for the time.
Thank you, sir. I appreciate it. Okay, I have not received notification of any other person wanting to comment. Is any other council aware of any requests for public comment? No. All right, let's move on to our first witness, and the first witness would be the Helios witness, and at that point I'd ask council to move for admission of the application. Council for Helios, are you ready to proceed?
Yes, I am, Mr. Lennon, and I would call Marcus Prieskop as our witness and ask that he be sworn in.
Thank you. Mr. Prieskop, can you hear me?
I can, sir.
Okay, this is a bit unusual, but it's the way I do it. Would you mind standing up and raising your right hand?
Okay.
And I'm going to do the same because that's the traditional way it's done. Do you swear or affirm under the penalty of perjury that testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do, sir.
Thank you. Please be seated. Okay, Counselor.
Thank you. Mr. Lennon, my intention, and I circulated exhibits with numbers, and to keep those numbering, what I would propose is we'll make the application Helios Exhibit 9. I think that was where I ran out. So if that's acceptable to you and the court reporter, we won't use the sequential numbers of what order they're going to come into the record, because we're doing this by Zoom and we don't have the ability to stick the little stickers on the papers, if that's okay with you.
Well, my application isn't even labeled 9, so you're not saying that there's a label on it, right?
No, what I'm saying is that I circulated some exhibits and I gave the PDF files numbers up to 8. I did not include the application, so I'd like to call that one number 9. And I was stating that if we were doing a pre-COVID hearing, none of this would be necessary. I would mark the numbers as I was asking them to be admitted, but because of the circumstances, I think we'll keep things clearer if we keep the numbers on the PDF files. And I just start with 9.
All righty. For the convenience of the parties, we're going to label as applicant's number 9 the application for the certificate. And let me just make sure we're all clear about what that consists of. Like you said, because this is a COVID world, Zoom world we live in, and we can't hand across the table or the room or to the bailiff or to the court clerk what we are introducing, and I'm not personally handed the document. Let's make sure we understand what that consists of, the application. I have how many pages? I'm labeling it as it's number 9, evidence number 9. Mine starts out with page 7 of 12 entitled application fees. What do you have, Mr. Marks? I want to make sure we all have the same thing.
Mr. Lennon, I have a 518-page document that was, I think, retrieved from the from eDocket, and it's dated. It's the 7/20/20 July 20, 2020 version. That I believe was attached to the notice of application or circulated by staff. And it says application redacted. It's 518 pages. It would be the same as what you have if you have, I guess it would be 512 pages. The first few pages are the pre-printed forms from the Transportation Division, pages 1 through 6, that do not have anything that was filled in, don't have any places to fill anything in from the applicant.
Okay. For the record, since we have video, for the record, I'm holding up in my hand a 5-inch thick file, which is the papers which are filed with the application. This is frankly an enormous application. You're moving this into evidence. I'm not in a position to read 500 pages of evidence unless during testimony specific pages, relevant pages, are important to the decision in the case. Are you alleging that all 500 pages are substantive information necessary to make a decision on this case?
First of all, Your Honor, under the circumstances, I will suggest that you could. I will email everyone the document I'm working with. You could hold the admission of this under advisement until you had the opportunity to look at the document. In terms of the substance, the bulk of the pages in the application are things such as the Helios's policies and procedures. I would contend that the policies and procedures, for the most part, are not substantive matters at issue in this case. What was at issue is, do they have them? And the interveners certainly had access to this. This was part of the notice that everyone got. They were attached to the notice that everyone on the transportation list got. And if they wanted to take issue that Helios did not have acceptable policies and procedures, they could have done so in their file testimony. They have not. So I would say it's possibly analogous to a utility case, utility rate case for one of the larger utilities. There's going to be a box of schedules, and truly that collection that you just held up, Mr. Lennon, would be but a fraction, maybe a fifth or a tenth of what might be in the record in a utility case of just exhibits, which are printouts from spreadsheets. And it's typically addressed by, did the utility meet the filing requirements? Yes. And then parties place specific things at issue if they choose to. And I would say that analogy holds here. Transportation Division stated that there was a complete application in their notice, and that started this case. And to my knowledge, the interveners have certainly contest many facts. I don't think anyone contested the procedure manual, for example. I think we heard Ms. Maggiore contesting some of the other attachments, and I think I think we should discuss those as to what comes in. But I'm just looking at it here, and the procedure manual starts on, let's see, sorry, roughly on page 53 of the PDF, and is running through it's the end, except for the check. So it runs through from 83 through 517 are the applicant's procedures for its medical services. And the material that's probably in dispute is the material that's in advance of that.
Okay, thank you, sir. I'm going to allow opposing counsel, or not opposing counsel, but interveners to an opportunity to object to the admission of this evidence. Let's see, I had a particular order in mind just to keep track of everything. So we'll start with Mr. Maurer. You have any objection to the admission?
Can you hear me?
Now we can.
Sorry, computer challenged. Yes, sir. On behalf of Superior, I would object to as I'm going to go ahead and take Mr. Marks for his word, of the application that was submitted to the commission for consideration to start this proceeding, page 83 through 517 of that particular document. I would object to the admission of those documents into this proceeding simply because they were filed and attached to the application. Mr. Marks chose to do that. That's fine, but they have not been submitted as an exhibit. I have not been able to look at them and consider them as exhibits. I would have had he submitted them as such. Therefore, I object. I do not think they should just be given carte blanche and given ability to be considered by you, quote unquote, as evidence. They're part of an application that was filed. They clearly should not be considered for today's hearing as exhibits. If that was Mr. Marks's intention, to support an argument that they have proper policies and procedures to support this application, he should have done so independent to give us a chance to review them and object. Thank you.
Thank you, sir. Next, Ms. Maggiore. Any objection? Ann, are you there?
Yes, sir. I'm just trying to unmute myself. I don't have page numbers either, but within the application, there are four, I don't really know what to call them. They're not on letterhead. They're four documents that start out with to whom it may concern. And they are from various nurses and other employees of Christus. There's a need, and climb between a rock and a hard spot, because we don't disagree with these individuals that there's a need, but I object to the fact that they are not in a format that's appropriate for acceptance into evidence, because they're not verified, and because we have no way to cross-examine them.
Thank you, ma'am. Mr. Padilla, any comment?
I agree with Mr. Maurer that all of the portion of the application, which is just policies and procedures, really is not a factual issue in this particular matter, and that's the vast majority of the documents. But I did hear you say that your document that you currently have starts at page 7. The document that I currently have starts at page 1 of 12. And actually what page 1 through 6 is there the instructions as to how to complete page 7 through 12. And they're very specific, and they make reference to statutes. And I intend to use those in my cross-examination. So I would insist that the entirety of the documents and the actual exhibits that are referred to in these pages 1 through 6, and I think the exhibits go through exhibit J, but some of those might be these procedures, which I don't think are necessary in this particular matter. But I do want pages 1 through 6. I want from page 1 up to where the procedures start. And I don't have numbering just like Ms. Maggiore and other people.
Thank you, sir. Mr. Bartel, argument?
Hearing examiner, I object to the admission of the application per se as an exhibit. I view that as analogous to a complaint opening any litigated matter. There are many issues in that application which are unsworn and are not admissible evidence. And frankly, there's not an adequate foundation for much of the remaining material in the application. I think that if the applicant intends to rely on the contents of the application or any part of it, they need to have made them separate exhibits, offered them in advance, told everybody what they intended to do, and in connection with the filing of the direct testimony, laid an adequate foundation. That has not happened here. So I think it is inappropriate to admit this application.
Thank you, Mr. Bartel. And Mr. Borman, please. Unmute, please.
Thank you. I thought I had, but thank you. without this application, we obviously don't even have a case here. And I guess this issue arises from my raising it prior to the hearing, and maybe I should apologize for that. But the fact of the matter is, I mean, the application is an integral part of this case, and the parts that have been objected to are all essential parts of this case. The operations plan that Mr. Maurer objects to is required under 18.3.14.10 of the commission's rules. And if we were to go forth and deny admission of this application, which I guess to me, I kind of figured was a formality. I mean, then I guess we'd have to do that in every case. And pretty much all of these people who have applications here should have their applications dismissed, because, there's just no point to this process anymore.
Thank you, Mr. Borman. Okay.
Unbelievable.
Who said unbelievable?
I'm sorry. It's me. Sorry.
Well, who said unbelievable?
It's Fred Maurer. I thought I was muted.
Okay, well, that's okay. Thank you, Mr. Maurer. Mr. Marks, comment?
If I could briefly respond, I agree with Mr. Padilla that the document that should be introduced into the record should be the full one that starts with page 1 of 6. And I'm looking at eDocket right now, and it is the document that's filed on July 20th. It says application for certificate to provide ambulance service dash redacted. I was going to email it to everyone, but it's about 30 megabytes, so it's not going to email very well. But I think before this argument began, I actually did not move its admission, and if I would like to do that for the record before you rule. I would respond to Ms. Maggiore that the letters that she points to, indeed, I'll acknowledge, appear to be hearsay to me. They are statements made outside of court for the truth of the matter asserted. I think the fact that they're not sworn is probably not as significant, but I would remind the commission that the commission does not strictly follow the hearsay rule and can admit hearsay and give it the appropriate weight, and I would ask that you do so in this case. And then lastly, if I could, there was an argument against the foundation, and as Mr. Padilla pointed out, Mr. Prieskop did in fact lay a foundation. He adopted the application by reference, which we now know that you disfavor, but nevertheless, he did state that he prepared the application. He did state, and when I admit his testimony, he will be swearing in the testing that the contents of the application that are prepared by him are true and accurate to the best of his knowledge, which would obviously mean that these, for example, the statements Ms. Maggiore put at issue are not included in that. And lastly, I would just reiterate what I said earlier, which I think Mr. Borman said better. I don't do that many transportation cases. I do a lot of utility cases. And on the utility side, the application, the utility's first witness adopts the application. provides the foundation for the application and it's admitted, it's not admitted it's not ever made an exhibit to somebody's testimony. It is a separate document that the first witness traditionally provides a foundation for, and there's a motion for admission, and that's what I had intended to do. And I was speaking more to the numbering when I brought this up. I was hoping now that Mr. Priestkopf is in to admit his testimony as the first two exhibits and then move the admission of the application and have him provide a foundation. And with that, I'll rest.
Thank you, sir. In response to Mr. Marks' second argument, Mr. Bartel, I understand you want to speak. Please.
Thank you. The application, if we want to split it up, the form that the commission requires be filled out and submitted is a pleading, and it need not become an exhibit in this hearing. It is simply the document that initiates the proceeding. The problem are all the attachments for which there is no foundation. This witness has not gone through each one of those exhibits and said, where they came from, who prepared them, and authenticate them in accordance with the rules of evidence. So I'm sorry, even in a utility case, there are many, many schedules or many, many exhibits, but there are also competent witnesses who lay the foundation, explain how the exhibits that they are sponsoring were created, and in pre-file testimony, establish the foundation requirements for each of the exhibits that they are sponsoring. That has not happened here. So I believe that it's inappropriate to scoop the whole thing in and say he adopts it by reference. That's not a foundation.
Thank you, sir. Mr. Maurer?
Yeah, and sir, if you can hear me, I would like to join with Mr. Bartel. I think that's accurate. The application form itself sits. That document is part of the record, like a complaint would be. The rest of it that has been identified, page 83 through 517, if I understood what you were talking about, is not been identified as an exhibit previous to this. There is nothing in the pre-filed or rebuttal that identifies that or attempts to lay a foundational basis for it. I was unaware that was what he was going to attempt to do, and I don't think it's fair. I think it's prejudicial to us because we do not now have an opportunity to cross-examine his client with regard to his positions as with regard to those policies. I join with Mr. Bartel.
Thank you, Mr. Maurer. Is there anything else from any other council? All right, thank you. And Mr. Maurer, Mr. Bartel, and Mr. Marks, all your arguments are well taken. And I tend to concur somewhat with all of your arguments. I also treat the application as an initial pleading, similar to a complaint and not evidence. There are certain averments in an initial pleading to satisfy statutory requirements. For example, such averments are not evidence in a typical civil case. And I consider the contents of the application averments rather than introduction of evidence. So with that said, and I'm trying to be clear to preserve a record, I am going to admit the entire 5-inch thick application. However, I want to be perfectly clear that the portion which is, I believe, been identified as pages 83 through 517, but I'm going to more generalize that. I'm going to give particularly that portion of the application the weight which is appropriate, and the weight is, that's my job. My job is to weigh evidence. I'm going to give it the appropriate weight, and if there's a sufficient foundation that was laid, for lack of a better term, in the direct testimony, which is yet to be admitted, filed but not quite admitted yet, then I'm going to refer to the document because there's been a foundation. If the document happens to be on page 472 of those 500 and such pages, I'm going to consider it as evidence. If the witness has not referred to other pages, say 400 through 500 or 200 through 300, I'm not going to give much weight, as you can imagine, to those admitted, those parts of the application. Anyhow, I just wanted to make that perfectly clear. I will admit the entire application, but it's going to be given the weight which is appropriate based on the foundation through the direct, not the cross, but the direct testimony. That being said, we're ready to move forward. Next, call your witness, Mr. Marks.
Okay. Thank you, Mr. Lennon.
Oh, he's already been sworn. Apology.
Mr. Priestkop, you recognize the document that's titled Pre-Filed Direct Testimony of Marcus Priestkop on behalf of Helios EMS?
I do.
And was that prepared by you or under your direction?
It was.
Do you have any corrections to make to it?
I do have one correction. On page 6, line 4, I incorrectly cite the case number as ending with the suffix UT as opposed to TREN, which is the correct citation.
And with that one change, is the contents of this document true and accurate to the best of your knowledge?
It is.
If I asked you the same questions today under oath, would your answers be the same?
They would.
Okay. Your Honor, I've marked this in the PDF file as Exhibit 1. I would move that Helios Exhibit 1 be admitted.
So that's applicants Exhibit 1. I have, lest you don't see it, I've labeled mine. And
excuse me, Your Honor. And yeah. If I could lay one more piece of foundation.
Sure, please.
Give it. And the exhibits to that are attached to this pre-filed direct testimony, were they prepared by you or under your direction?
They were.
And are they true and accurate?
They are.
Okay. Thank you, Mr. Lennon.
Before I rule on it, I have a question for the witness. Did you prepare the affidavit from Miss Lillian Montoya?
I
can't hear you.
I apologize. I should have specified that exception. I did not prepare that affidavit nor any of the other. That's the exhibit.
I don't think that's.
Exhibit MP-R-01, affidavit of Christus St. Vincent, Lillian Montoya. That's what I have.
Mr. Lennon, that's not attached to his direct. That's part of his rebuttal.
Not. Okay. Well, then we need to make sure what is and what isn't. Sorry, this is the nature of the Zoom hearing. I have page 1 through 10. Completing on page 10, it says, does this conclude your rebuttal testimony? Yes. Mid-page. I have at the end a verification of Marcus Priestkop, dated November 4th, 2020. And there's a COS, a certificate of service, on the page after his verification. And in between the verification and page 10, where he says it concludes his rebuttal testimony, I have 1, and I'm stating this for the record, 1, 2, 3, 4, 5, 6, 7, 8 pages consisting of what I just mentioned, MP-R-01 and MP-R-02. -02 appears to be sales forecast for year 1, and Exhibit 1 appears to be an affidavit of Christus St. Vincent. Is there an error in what I've printed out?
Mr. Lennon, I think the error is that you're looking at his rebuttal testimony, which is our Exhibit 2, and
You know what? You're absolutely right. That is the error. I'm looking at his rebuttal testimony, not at his pre-filed direct. My apologies. Note it for the record. My mistake. Let me get the correct document in my hand. Thank you, and I apologize to all. All right, so anyhow, the direct, and let me unmark the rebuttal and mark as applicants one, the direct. Those little words matter, don't they? Okay. So I have, it's just since I've unclarified things, let's clarify. I have pages 1 through, oh my, 1 through 13. And it also ends with, does this conclude your direct testimony? Yes. And then I have exhibit MP01, attachment to the direct pre-filed direct testimony of Marcus Priscop. It looks like it's his resume, and I recall that it was referred to within his testimony. The next thing looks like minimum employee requirement verification, which was, I believe, also referred to. Then we have payroll year 1 projections and second year sales forecast projections, sales forecast projections for years 1 through 3, additional inputs, operating expenses year 1, operating expenses year 1 through 3, cash flow year 1, cash flow forecast years 1 and 3, income statements. These are pro forma, I presume, because it hasn't happened yet. Cash flow, oh, it says forecast, cash flow forecast for years 1 through 3. And then we have income statements years 1 through 3 and balance sheets. I'm sure that's pro forma for years 1 through 3. Finally, the verification and a certificate of service. Thus corrected. Do I now have the correct number 1?
Yes, we do.
I do. Yes, great. I do believe these exhibits attached to the testimony were referred to in the testimony. As I mentioned earlier, I give them the weight which is appropriate based on the foundation presented by Mr. Priscop. Having read the testimony of the other parties, the interveners, I recognize that they may have raised an issue as to some of those forecasts. With that being said, I just wanted to, like I said, I don't hide the football. I will admit into evidence the pre-filed direct testimony of Marcus Priscop, marked applicants number 1, and I apologize to all for my verbosity. Let's move forward, hopefully a little bit more quickly.
And then Mr. Priscop, I've marked as Exhibit 2, Helios Exhibit 2, the pre-filed rebuttal testimony of Marcus Priscop on behalf of Helios EMS. Are you looking at that, sir?
I am not, but if you'll give me just a moment.
Mr. Hearing Examiner, could I just ask that we go exhibit by exhibit as to admissions? Because I have objections to the rec beyond what we've discussed.
Mr. Marks, will there be only 2 exhibits from this witness?
This, and there'll be these 2 and the application, which has already been ruled upon.
Well, then it's only 2 exhibits. Well, Mr. Bartel, if you would bear with me, let's let him move to admit it, and then we'll have our argument on it. I apologize. I should have given an opportunity to object. My mistake. I stand corrected. I strike the admission of number 1 until we hear argument from any interveners. Thank you. Proceed, Mr. Marks, with your exhibit marked as number 2.
All right.
The rebuttal testimony.
So just so I understand, Your Honor.
I'm going to hear argument from opposing counsel as to the admission before it's admitted.
On Exhibit 1?
On Exhibit 1, I'll hear argument as well. I've stricken its admission with apologies. We'll hear argument, and then we'll either admit it or not admit it.
Okay. So are you looking at Mr. Priscop, do you have Exhibit 2, which is your pre-filed rebuttal testimony?
I do.
Was it prepared by you or under your direction?
It was.
And with respect to the exhibits there too, Can you look at exhibit NPR01?
I can.
Okay. Was that prepared by you?
It was not.
Okay. Would you agree that it was referred to by you in your rebuttal testimony?
It was.
And would that be at page 3 of your rebuttal, line 18 through?
It was.
Okay. And does that state your knowledge and information with respect to that particular document?
It does.
Okay. And then exhibit NPR02 attached to our exhibit 2. Do you see that?
I do.
And was that prepared by you?
It was.
And is that referenced in your testimony?
It is.
Okay. Is all the information in your testimony true and accurate to the best of your knowledge in your rebuttal? And if I was to ask you today the questions that are in your pre-filed rebuttal testimony, would your answers be the same?
They would.
I move the admission of Helios Exhibit 2, the pre-filed rebuttal testimony of Mr. Prescott.
Okay, thank you. Before ruling on the motion, I'm going to allow any other counsel to comment, argue against, and perhaps even examine the witness only on the issue of admission at this point. I'm always conscious to be conscious of the concept of due process and the opportunity to be heard, recognizing that it is also possible grounds for an appeal. And I apologize for not allowing it before. I had erroneously admitted now stricken applicants number 1. And Mr. Bartel, since you spoke up, I'm going to go slightly out of order, my personal order for the parties. You have some comment, please?
Thank you. Yes, I object to a portion of Exhibit 1, specifically testimony that's found on page 7, lines 5 to 6. This is hearsay. He is reporting comments by unidentified other members of the Christus St. Vincent staff. This is being offered for the truth of the matter. This is just plain hearsay and is inadmissible.
Mr. Bartel, if it were not hearsay, would it be admissible as relevant?
It may or may not be relevant because I don't know what they actually said. This is it's a brief summary about that they feel there is a need. I don't know that it is particularly relevant, but it certainly is a hearsay statement.
Within your cross-examination of Mr. Prescott, you may wish to examine him concerning that. Any other counsel like to comment regarding objecting to the admission of applicants number 1?
Yes, Your Honor, I would like to object to Exhibit NPR01. This is an affidavit that was poached directly out of AMR's application for authority. I'm not sure what it's doing in this case. I think it's completely irrelevant because if you actually read it, the final paragraph of that exhibit indicates, it is an affidavit from Lillian Montoya, who is the president and CEO of Christus St. Vincent, that she has met with representatives of AMR and that they fully support AMR's application for temporary authority to provide services in Santa Fe County. I think it's beyond wrong for this to have been poached out of our application without the knowledge or consent of the affiant, who is not a part of this proceeding and cannot be cross-examined here. In addition to that, I would like to join Mr. Bartel's hearsay objections. I'd also like to add a relevant objection to Exhibit NMPR 01, which has nothing to do with this case.
Thank you, Ms. Maggiore. If you could in the future, if all counsel would identify themselves for the record, and literally for the record, because the transcript is going to look a little different than our little pictures on the Zoom screen looking at each other. And all right, as you might have suspected when I reviewed the testimony, I also was quite, well, I found it interesting. I found MP-R-01 interesting for exactly the reasons that Ms. Maggiore raised. And I thought it would be prudent to notify counsel that I would give it the weight which I feel is appropriate. And when I saw that it was related to another case and another party, and you know, the weight was not significant in that it was not prepared for this case. And you might have noticed how I jumped right to it with Mr. Prescott when a few moments ago. So I thought it was quite noteworthy. The question whether it's relevant is a question, quite another question. I mean, it's difficult to quantify relevance. I mean, something can be relatively insignificant, 1 out of 100 of relevance. It's only 1/100th relevant. Is it relevant? If it is, it can be admitted. What weight is it accorded? 1/100th of the weight had it been completely relevant rather than only 1% relevant. So with respect to Ms. Maggiore and with the way I assess the weight based on the relevance, partially based upon simply the relevance, using the relevance and perhaps a different definition, I'm going to admit the entire number 2, and I'm going to admit the entire exhibit number 1. And like I said previously, it's my job to determine the weight of the evidence. And hearsay, I also weigh the value of hearsay evidence. You can imagine that I typically would attach less weight, if you will, to hearsay evidence. And Mr. Bartel, I've done it many times myself. I bring it to the trier of fact's attention, the nature of the testimony as hearsay, even knowing that I'm going to be overruled. And I appreciate you doing the same. And I'm going to attach the appropriate weight to hearsay testimony, all other things being equal. That being said, those 2 documents, applicants number 1, Helios number 1 and Helios number 2, testimony, direct testimony and rebuttal testimony of Martin Prescott are admitted. Next.
And Your Honor, I believe we've admitted Exhibit 9, which is the application.
Thank you. We've already done that.
And so I would pass the witness for cross.
All righty. Cross-examination. I thought we should go in my order, and just because the filing order of the motions for intervention. So the first would be Helios. Mr. Maurer, you're up. You can cross-examine the applicant's witness, please.
Can you hear me?
Yes, sir.
Okay, good, because like I said, I'm challenged. I just want to make sure for purposes, 2 things. One, I waved my hand, but I understand how we're trying to do this. I wanted to join with Mr. Bartel and also Ms. Maggiore with regard to their objections, just so it's in the record, with regard to exhibits 1 and 2. And then I just want to clarify. So with regard to the testimony that's now been offered and admitted, you have admitted exhibit 1 in entirety, admitted exhibit 2 in entirety, and exhibit 9 in entirety. Is that correct?
Well, I don't like being examined when I'm hearing a case, number 1. But, you know, this is an administrative hearing and we all need to work together. So to help you with clarification, that is true. And you might recall that I indicated my job as a trier of fact is to try the facts. And my job is to attach the appropriate weight to various admitted evidence. And I will do just that, including any part of the 5 inches of the application and any part of the other exhibits, including the testimony and rebuttal testimony. It's my job to assess the weight, and very often I'll do it on the foundation, as well as the effective or less than effective cross-examination relative to the foundation, related to the foundation of any admitted evidence. So that's why we come to you to cross-examine this witness and to perhaps attack any foundation. And you have the floor, sir.
Thank you. I'm just making sure I understood where we were. And Mr. Prieskov, my name is Fred Maurer. I'm an attorney that represents Superior Ambulance. And if I mispronounced your name or do mispronounce it during this period of time where I am asking you some questions about the pre-filed testimony that has been admitted, I apologize. It's not intentional. First question I have. I'm sorry?
I understand. It's a difficult name.
Yeah, and I apologize. I'm apologizing in advance. Mr. Prieskov, with regard to your testimony, as I understand it, is it true that what the basis of this application is that you believe that there is a need for additional transportation services for inter-facility transportation in Santa Fe and Santa Fe County because of a lack of service by Rocky Mountain? Is that true?
Objection to the form of question. Mr. Prieskov can't answer as to how Mr. Maurer understands it. If you could ask the question without that preface.
Sustained, please, Mr. Maurer, just rephrase it a little bit. Thank you.
Mr. Prieskov, is one of the basis of your belief of additional need for transportation services that Rocky Mountain has failed to provide service to St. Vincent's Hospital?
That is, in fact, one of them.
Okay. And I want to know, what is the basis of that belief?
Basis of that belief are statements that have been made to my partner, as well as complaints that have been filed with the PRC regarding Rocky Mountain, as well as my knowledge of Rocky Mountain as a former employee.
Okay. And the statements that have been made by people who work at St. Vincent's, none of those statements are part of your pre-filed or rebuttal evidence. Is that correct?
That is correct.
All right. So this is based simply on your interpretation of comments made by employees of St. Vincent.
That is correct.
Okay. Now, with
respect,
I'm sorry.
As well as statements of employees of other facilities throughout northern New Mexico.
Okay. And with regard to that comment, none of those statements by other employees of other facilities are part or are referenced or identified in your pre-filed or rebuttal testimony. Is that correct?
I believe they are referenced.
But the actual statements you're talking about are not attached nor identified. Is that correct?
That is correct.
So once again, we're relying upon your interpretation of comments made outside this hearing.
Objection, he gave other bases. But
hold on just a second. I'm going to overrule the objection. I heard something slightly different. You can continue. Sir, Mr. Prieskov, you can answer the question.
I'm sorry, could you repeat the question?
The reference to other statements made by employees from other facilities in northern New Mexico. It's true, isn't it, that none of those statements are contained within your pre-filed or rebuttal testimony?
That is correct.
And once again, we are having to rely upon your interpretation of those comments instead of the actual comments. True?
True.
Now, with respect to the claim of need, do you have any evidence that St. Vincent's contacted other carriers who are operating in Santa Fe to seek provision of transportation?
Sorry, can you clarify evidence for me?
Okay. Do you have any documentation that employees of St. Vincent's or the hospital itself contacted other carriers who are operating in Santa Fe to provide this kind of service?
Just to be clear, that's other than Rocky Mountain?
I'm talking about any of the carriers. Do you have any evidence that St. Vincent's contacted any of the carriers currently authorized to operate in Santa Fe to provide this service?
I apologize. I want to be kind of delicate about this because I think I'm the only person in this Zoom meeting that's not a lawyer. So I want to make sure I don't misstate something. In the discovery presented by AMR, their response to our discovery request, they listed several transportations that they performed from St. Vincent's. I don't know if that qualifies as evidence to this question.
I object to comments about what was contained in discovery that's not in evidence in this particular matter.
I would join that objection. Move to strike it.
Mr. Ryan,
Any other argument?
This
Mr. Marks,
is,
please.
This is Mr. Marks. It's responsive to the question he was asked. Do you have any evidence as to whether other carriers are doing service? We have the, he referred to discovery. It's the admission of a party opponent to him. Since AMR does not have a witness now, we were going to admit it. It won't be come in, but it's the other parties have it.
Well, there's also a distinction between evidence and knowledge, and the question was evidence, and evidence is a legal concept, and Mr. Prescott is cautious not to opine on whether there is evidence or not. I think the question could be whether he has any knowledge of any, and he testified that he did. So I'm going to interpret his comment as referring to knowledge rather than evidence. He stated that his knowledge is based upon discovery, and I'm going to overrule the objection and allow him to continue to testify. Thank you.
Mr. Prescott, with regard to this case, do you know how many ambulances are available to provide the services you're seeking in Santa Fe and Santa Fe County currently?
I would again want to be very cautious about answering that question. The best number that I could provide would be in response to various, again, referencing discovery answers provided by other parties. I don't know, again, if that qualifies as knowledge, because this is their statements that I have no direct knowledge of.
Okay. So the answer to my question is you don't know how many specific units are available from other carriers operating in Santa Fe or Santa Fe County, do you?
Well, again, that's where I want to be cautious that whether or not discovery counts as knowledge.
Do you want to confer with your client, Mr. Marks, perhaps privately or openly? You're welcome to instruct him or whatever. I don't want him to be left hanging out there during his cross-examination. In this particular instance, he's having problems with legal terminology.
Well, Mr. Hearing Officer, I'd like to object. I think he should have been prepped before we started this cross-examination, and I don't think it's appropriate now for Mr. Marks unless he wants to take a break.
Sir, I just want to move things forward as Mr. Maurer. I want to move things forward as best as possible. And if we're going to run into the same issue with this witness, I don't have a problem with counsel instructing him. But if not, Mr. Marks, we can just continue. Do you want to meet with you?
Mr. Lennon, thinking about the objective of moving things along, I'll take advantage of your offer. I was intending to redirect, get this clarified, but at that point, Mr. Maurer is going to want to do recross, and it's probably easier just to do it now and instruct. I would instruct my witness that he can answer based on what he knows, based on reviewing the documents relevant to this case, including discovery responses, and what he knows based on other information he's come upon. He's been in this business for decades. He's been in the market for quite some time. He knows all these people.
So I don't need you testifying, Mr. Marks, but
okay,
that's fine. I was reluctant to personally instruct him on how he should testify.
Okay.
And that's why I wanted to afford you the opportunity to help him understand that it's to the best of his knowledge, period. He need not do any legal analysis of whether his knowledge is or is not evidence. So let's move along.
Mr. Lennon, what I was
Yes,
getting at is that we haven't made this distinction, but he's arguably an expert on the matters he's testifying to, and so if he has
He'd be entitled to opinion, but we're not into opinion questions even at this point. And this is an administrative hearing, and the rules of evidence as to expert testimony may not even apply here, and even though we would rely upon them if necessary. So I'm perhaps should not have interrupted, but let's try to move the testimony along. Mr. Prieskop, just testify as to what you know. If you don't know, you say you don't know. If you don't remember, you don't remember, and you tell it like it is. And I would appreciate if you would do that. Thank you, sir.
Thank you, sir. I apologize for the inconvenience.
Continue with the cross-examination, sir.
Mr. Prieskop, with regard to your testimony that's been offered, tell me how many complaints have been filed by other facilities besides St. Vincent's with regard to lack of ALS, BLS scheduled transportation?
Filed complaints, none that I'm aware of.
Okay. Are you aware of any facilities other than St. Vincent's which have made statements that the services that are currently being provided have been inadequate or not timely?
I am.
And what facility would that be, sir?
Los Alamos Medical Center.
Okay. And is there anywhere documented in the testimony you've provided, both pre-filed and rebuttal, of an individual you've discussed and information he's provided about Los Alamos County and the quality of service?
There is not.
Thank you. Other than Los Alamos County, are you aware of any other facility?
Any other facility which is not receiving adequate service?
Yes, sir.
Several.
I'm sorry, I didn't hear you.
Several.
Okay, and once again, the several that you're identifying, have they been identified and discussed in your pre-filed or rebuttal testimony?
I believe they are discussed.
But that's the question is, were they identified and discussed?
I apologize, I heard or. They were not identified and discussed, no.
Thank you. Now, with regard to the authority that you're asking for, if I understand it, you're asking for ALS services in Santa Fe County and northern New Mexico. Is that right?
I believe we're asking for authority to perform interfacility transportation throughout the state.
Okay. With regard to the equipment that you're going to have available, is that equipment going to be stationed in Santa Fe?
It will.
Okay. And the primary area with the one ambulance and the one van you have available at this time, your concentration will, isn't it true, be in the city of Santa Fe?
Objection as to facts and evidence. I don't know what he means by one ambulance and one van. The application states two ambulances.
Well, this is a cross-examination, and I allow counsel quite a bit of leeway, but I have to limit that at the point of what could be called trick questions. In other words, erroneously statement of facts within a trick question. And I would caution Mr. Maurer, perhaps Mr. Marks is correct. I don't recall whether the application had one van and one ambulance or two ambulances, so I'm going to ask you to be careful with that type of questioning. Objection is sustained.
Mr. Prescott, I understand your testimony in your pre-filed and rebuttal. You identified a Chevrolet vehicle as one of the units that you plan on using in this application. Is that correct?
That is correct.
And I believe it was a 2013 Chevy.
I believe it was a 2015 Chevy.
Sorry. And then the second vehicle, isn't it true? The second vehicle I saw you identify, and I think you even attached a receipt for its purchase, was a Ford Econoline van. Is that true?
While it's identified as a Ford Econoline van, that is how the DMV identifies it. It is in fact a Ford E450 cutaway vehicle, which has then been mounted with a ambulance box produced by Road Rescue in that case.
Okay, so the two pieces of equipment that you have identified in your testimony are the Chevy and the Ford, as you've identified it, are the two pieces of equipment you have available to provide the proposed services. Is that correct?
That is correct.
Okay. Now, is it back to my question then? With the two pieces of equipment that you have just identified, is it your intent to primarily provide services for 24/7 ALS in the city of Santa Fe?
It is our intention to provide services throughout northern New Mexico with those two ambulances, yes.
All right.
We intend to station in Santa Fe.
With regard to that intent, have you got any projections as to the number of calls for service that occur in northern New Mexico on a daily basis?
In that they are rolled into my projections for the service as a whole, yes. As an individual projection of breakdown, I do not.
Okay. So there is no individual breakdown. What is the total number of calls for service you believe that you could be subject to in northern New Mexico?
Am I allowed to reference my projections here?
Counselor,
I'm not
Marks.
sure.
He's asking if he can look at his pre-file testimony and exhibits.
Yeah, sir. If you don't understand the question, say you don't understand the question. You're allowed to refresh your recollection by looking at documents for sure. So you're welcome to do so.
Thank you. And if you'd allow me just a moment to.
So rather than reading the
I'm
document,
not sure. I'm sorry.
It's better to close the document and then your reflection, your recollection thus reflected. I'd like you to then testify from your refreshed recollection, sir.
I'm not sure that I can put a number to a specific question.
Okay, that's
Thank
the
you,
answer.
sir.
Next question.
Thank you, sir. Now, is it also your intent, as I understand from the application, to be available certain hours of the day for BLS services?
It is our intention to be available for BLS services 24 hours a day.
Thank you. And with regard to the distinction between ALS and BLS, have you done or have you provided any testimony as to the numbers of calls between the two categories that come up daily?
I have not provided any testimony to that distinction.
Okay, thank you. And I want to make sure I understand, you're defining northern New Mexico as Santa Fe County, Rio Arriba County, Los Alamos County, Taos, San Miguel, and San Juan. Is that correct?
That is roughly correct as we are understanding, yes.
And have you done an analysis that you've provided in your testimony as to how many companies are currently working in those counties?
I have not
Ambulance
provided
companies.
that in my testimony.
Okay. And same question, have you done an analysis or provided any kind of numbers of the availability of ambulances by those companies operating in those counties?
I have not.
All right.
Excuse me.
Is that an objection, Counselor? Oh,
No,
Ms. Hoyman.
it's the stenographer. They were speaking over each other, and I did not get the answer to the question, have you done an analysis that you have provided in your testimony as to how many companies are currently working in those counties, ambulances? And he sounds like he's in a tunnel, so perhaps during a break, he can mic up.
Was your answer no, I did not, I believe, Mr. Prescott?
I believe my answer was I did not include that in my testimony.
Thank you.
Thank you.
My apologies. I will correct that.
And thank you, Ms. Hoyman. Glad to know you're there.
And I'll try and slow down a little so that we don't speak over each other. Now, Mr. Prescott, with regard to the application and the authority you're seeking, you're not seeking emergency 911 authority except by mutual aid. Is that correct?
That is correct.
Do you know, Mr. Prescott, how many carriers are actually working in Santa Fe County right now to provide these kinds of proposed services?
Objection, former question. I don't know if he's asking about the emergency 911 services or the interfacility services.
Well, he said these kinds of services, and I thought he meant the kind that are being applied for. That's the presumption I raised. Mr. Maurer, could you be more specific, sustained? Go ahead.
With regard to the non-emergency services currently being provided in Santa Fe County, do you know how many carriers are currently operating in Santa Fe County?
There are 3 services that are primarily focused on interfacility transportation that are certificated in Santa Fe County. There are an additional 2 services in Santa Fe County. I may have to walk that back. I don't want to state the number of primarily 911 services that also will perform interfacility services. I don't want to misstate that.
So the answer to my question is then you really don't know. True?
No, the answer to your question, which I shouldn't have tried to be more complete then, is that there are 3 services certificated for Santa Fe County that are providing interfacility services as a primary for their business.
Does the city of Santa Fe provide transportation services for non-emergency care?
Irregularly.
Does the county of Santa Fe provide services for non-emergency care?
Irregularly.
So as I understood your testimony, then there would be potentially 5 carriers currently working in Santa Fe County providing ambulance services, correct?
The question, as it's stated, is services in Santa Fe County, and there are far more than that. But if you were intending to ask about providing facility services, that is roughly correct.
Thank you. Now, Mr. Prescott, do you have any proof that St. Vincent's has contacted Albuquerque Ambulance for services and been told we don't have any equipment?
I do not.
Do you have any proof that St. Vincent's has contacted Superior Ambulance and been told we don't have any equipment to help you?
I do not.
Have you been told that St. Vincent's has contacted, as an example, one of the interveners here, AMR, and been told we don't have any equipment that we can provide you?
If not. I'm sorry, would you repeat the question specifically?
I think you've answered it, but
I apologize.
and do you have any proof that you have provided in your pre-filed or your rebuttal testimony that any of the other facilities in the 5 counties, and I think I counted that right, 1, 2, 3, 4, 5, 6, 7, I'm sorry, 7 counties that you define as northern New Mexico, have contacted any of the other carriers who've intervened in this case and been told, sorry, we don't have any equipment available?
I have not.
Thank you. And I want to make sure I understood your testimony. Is your estimate that the number of calls that are arising from St. Vincent's is approximately, what you're relying on is approximately 2,100 a year?
From St. Vincent's in particular, that does not seem right, but if you allow me a moment to reference my sheet.
Sure.
No, that is not what I'm stating.
Okay. What is the number of calls that you've testified to that you estimate that is coming just from St. Vincent's?
I did not testify to any estimate for the number for St. Vincent's in any of my pre-filed testimony.
It was my understanding, Mr. Priescoff, that you used the figure of 1,912 calls for service as the number of calls that would be fulfilled by this potential application. Isn't that true?
Can you tell me where you picked that particular number from?
Sorry. No, I can't. Which of the 2 documents it would be? I'm sorry. All right. Now, with respect to the application and what you're requesting, do you know how many calls per day that St. Vincent's is exercising to get service?
I believe St. Vincent's is sending between 5 and 7 patients per day.
All right. And besides, as I understand your testimony, Rocky Mountain, is there any other service that's available in the city of Santa Fe or the county that is providing services to St. Vincent's right now?
I can't testify to available. I can testify that there are other certificated services for Santa Fe County.
Okay. My question is, do you have any evidence that St. Vincent's has called any other carrier currently working in Santa Fe or Santa Fe County to provide transportation services for this approximately 5 to 7 calls a day?
Mr. Lennon?
Yes, sir. Is there an objection?
I'm going to object to form a question. I think Mr. Maurer keeps throwing the witness off by saying evidence, and if you could just ask him, do you have any knowledge? I think the witness would understand the questions, and he's asking keeps asking for proof and evidence, the witness is perceiving that as a legal question of what the weight is. And that's your job, Mr. Lennon, not his. And so my objection is to the repeated form of questions asking for proof and evidence and for knowledge.
Objection is sustained, and I want to comment. Mr. Maurer, I understand you use the word evidence because evidence is important to me, and you interrogating this witness on cross-examination is for me to hear. So I understand the whole concept, but I don't believe this witness understands the concept when you use that word evidence. I understand Mr. Marks objecting and protecting his witness, and I understand him breaking up the continuation of the cross-examination, which is effective trial work. But I'm going to sustain it and ask Mr. Maurer to ask if he has any knowledge, if this witness has any knowledge. And Mr. Prescott, what I would tell my witnesses when I prep them was listen to the question, answer only the question. Take a second or two between each of those processes. Thank you. And Mr. Maurer, you're free to continue. Thank you, sir.
Thank you, sir. Mr. Examiner, first of all, I would object to counsel's speaking objection. And number two, I'm trying to use that term, Your Honor, so you're Mr. Hearing Officer. So it's clear I do not want him to speculate and guess or rely upon quote unquote hearsay. That's why I'm doing that. I'll move on. Now, as I understand your testimony, Mr. Peacock, you understand at this particular point in time that St. Vincent's is seeking a contract with a carrier to provide motor transportation services for its hospital. Is that correct?
Objection form of question. He started out with that preface, as I understand, and then it's just complicated.
Who's talking? I can't tell who is objecting.
This is Marks, and form of question. It's a compound question. If you could just ask him about his knowledge of this instead of there are just too many parts to the question.
Thank you, Mr. Marks. You know what happened is your video had froze on my side while you were speaking, and your face wasn't moving even though I was hearing your voice. So I apologize for that. And Mr. Maurer, I'll sustain the objection and ask you perhaps to break up your question in a couple little ones to make it more clear for Mr. Prescott. And I'd ask you also to rely upon me to wait whether the evidence is hearsay and to evaluate whether the evidence he might answer is hearsay, and for me to attach appropriate weight to it. Thank you, sir.
Thank you,
Please
sir.
proceed.
Mr. Prescott, it's true, isn't it, that you understand St. Vincent's is seeking a contract with other carriers to provide motor carrier services to its facility?
That is true.
In fact, you have in your testimony estimated that if that occurs, your figures with regard to transportation services available or needed would be greatly reduced. Isn't that true?
They would be altered. It would be reduced to a degree. I'm not sure I would say that they were greatly reduced.
Okay. But you would agree that it would have an impact on your projection.
It would.
In fact, the figure you used in your testimony was that you thought it would be down to approximately 10% what you were estimating. True?
10% of the call volume from St. Vincent's, that is correct.
Right. And what proof have you given us that 10% exists?
Objection, form of question.
I only heard the word exist. Oh, that was the question, whether what proof whether the 10% exists.
My objection is to the preface, what proof?
What proof?
It's the same objections previously.
Yeah, well, what is, Mr. Prescott, I'll ask the question. What is the basis for your knowledge that that figure would be 10% rather than 12 or 15 or 50?
It is an approximation based on my experience of providing services as a primary carrier to St. Vincent's when I was working for Rocky Mountain EMS. Approximately 10% of the time, the vehicles that were available from Rocky Mountain were not able to immediately provide a response to a requested transport, and another carrier was asked to provide that transport instead.
Thank you, sir. Mr. Maurer, please proceed.
Thank you, sir. With regard to that testimony, the 10%, what facility are you identifying that that 10% or facilities arose from?
From St. Vincent's.
So it's from the same facility?
I'm perhaps not understanding the question at this point.
I understood it completely, and I heard.
He answered it. Now, you've also, in your rebuttal testimony, used the figure of a 25% call volume from northern New Mexico to support your projections. Isn't that true?
Please allow me to.
Could you give us a page reference? Because I also would like to refer to the direct testimony, Mr. Maurer. Page and line would be helpful if you've got it.
Yes, sir. Just a second.
If it's helpful to the hearing examiner, I believe it's on page 4, line 20 of the rebuttal testimony.
That's correct. It would be page 4 of the rebuttal testimony where he identifies the 10% and the 25% in calls originating.
Thank you.
Okay, and could I ask you to repeat the specific question again?
The question is that in your testimony, you have stated that you are making an assumption that you would have a 25% increase in calls originating outside of northern and central New Mexico. Isn't that true?
That is what I stated.
What facilities did you study that you used that information to form that assumption or basis?
That is again based on my experience as a provider of interfacility transportation in New Mexico, I should say, in the reference to the specific question. And that is based on an estimate of the availability of calls that we would not have been able to provide if we were providing services to St. Vincent's that we would then be able to provide to facilities in places such as Artesia, Santa Rosa.
Mr. Prescott, with regard to these figures, what specific facilities did you obtain data from that supports those estimates?
In that the data is my experience, several of them.
Those
Artesia General Hospital. I apologize, I cannot remember the name of the facility in Santa Rosa. I believe it's Guadalupe County Hospital, but I could be mistaken about that. There is Colfax County with Raton. And then, again, I apologize, I cannot recall the name of the facility in Grants.
Now, with respect to those 4 areas you've just identified, what specific facilities did you contact or did you get information with regard to call volume?
Objection asked and answered.
Overruled, please answer.
I did not specifically contact any of those facilities in the process of preparing this testimony to obtain data.
Okay. So your testimony, as I understand it, then is based upon your experience working with Rocky Mountain and the call volume you experienced there?
That is correct.
You have not been employed by Rocky Mountain since 2017. Isn't that correct?
That is correct.
So the data you have is based upon your employment up until the time of 2017.
as well as conversations with my partner who was employed through 2020, yes.
All right. But he's not testifying here today, is he?
He is not, but his estimates go to my understanding.
Thank you. And is it your testimony that with regard to the ability to provide a 24/7 ALS truck, one staff truck, and an on-call staff truck for 20 hours a week, that you could meet this supposed 25% increase bulk call volume?
Under that contingency,
I'm sorry.
under that contingency plan, yes.
Okay, thank you. Now, Mr. Prescott, I want to understand, there are, as I understand it, 2 members of the LLC.
There are.
And who has contributed the money to the LLC to purchase the equipment?
We have both contributed money.
Okay, and how much money have you contributed?
Specifically to purchase equipment?
Yes, sir.
Somewhere in the vicinity of $2,000.
And with regard to the other partner, how much has he contributed?
Specifically to contribute to purchase equipment?
Yes, sir. I'm talking about motor vehicle equipment.
Oh, yeah, we're going to be more specific. Motor vehicles. I apologize. He's contributed approximately $18,000.
And you?
Approximately $2,000.
Okay. And who owns the 2 pieces of motor vehicle equipment that we've previously talked about?
The LLC owns them.
When were the titles transferred?
I'm sorry, I don't recall offhand.
But they have been transferred?
I know that one of them has. I'm not sure that the other one has.
Okay. So, all right. Thank you. Now, with regard to the rent on the location at 11 Calais Medico, Suite 3, who's been paying the rent?
It's been primarily contributed from the other members' funds.
When you say the other member, meaning your partner?
Correct.
All right. And is there any kind of note or documentation between the LLC and your partner concerning the money that he's paying for rent?
Objection, relevance.
Sustained. I'm struggling to determine the relevance of the entire line of question concerning the contributions to the LLC funds. So I'll sustain it.
Mr. Hearing Examiner.
Yes, sir.
The applicant in this case is an LLC.
I understand
If
that.
the LLC has no money and they're relying on outside funds from the partners, legally, the LLC has to enter into business relationships with the people it's borrowing money from to sustain its operations. And that's what I'm trying to get to the basis of. Is this just flying by the seat of one's pants, or have they actually entered into such agreements where the LLC now owes money for the debt that's being created?
Thank you, Mr. Maurer. I understand that. I even understand there are tax advantages to doing so with such agreements and loans to your own LLC, if you will. But I'm trying to find out, in this case in general, the benefit to the public, the necessity of having this, and whether or not this gentleman contributed $2,000, $3,000, or $18,000 is the absolute figure is not relevant to me. So I would, in terms of whether there's a substantial contribution, perhaps, but the absolute number is not as important to me. I'm to continue, as I sustain the objection already, even though you're arguing after sustaining, ask you to move to the next question. Thank you.
With regard to the two debts we've just discussed, have formal documents been created between the LLC and the parties lending the money?
Objection, relevance, same.
I think it's, isn't Mr. Maurer, I believe that's the same question.
No,
you had
sir.
asked.
I'll move
Well,
on.
I'm going to sustain that objection as well.
Mr. Prescott, you've indicated in your testimony that additional monies could be borrowed by the LLC from equity in real estate held by yourself and your partner. Is that true?
Objection, form a question. Is he asking?
Well, he's asking whether he testified to that. And Mr. Maurer, could you refer to the testimony? Could you cite where you find that testimony you're referring to? You ask whether, I guess you're presuming that the answer is going to be yes. It's the first of several questions. I hear them coming. Where are you referring? I'd just like to follow along. And objections
Hearing
overruled.
examiner, this is Ray Padilla again. I think it's on page 5 of the pre-filed rebuttal testimony.
Okay.
It's contained between lines 8 and 17, I believe.
Thank you, Mr. Padilla.
Thank you, sir. And thank you, Mr. Padilla. Let's move along. I don't recall, but it's overruled. So continue the questioning with that reference.
With regard to additional monies available to the LLC, if there is a reduction in number of calls, you've indicated, isn't it true, that you and your partner could borrow money, lending it to the LLC from equity in real estate that you and your partner own? Isn't that true?
That is true.
All right. Can you tell me how much equity you're representing is available to help finance this company?
Objection.
I was waiting for that
question.
one. Mr. Maurer, would you care to proffer to me the relevance of the absolute number value? I understand more would be better than less, perhaps, but why is the exact number important?
The key to this is, Mr. Hearing Examiner, that they have made numerous representations, which I'm going to get to, concerning profitability, cash flow, cost of doing business,
liquidity.
Estimate. They spent pages and pages making those estimates. He indicates that if there is a reduction in the services they can provide because of St. Vincent's deciding to hire a carrier, that they can finance continuing operations with additional equity. It goes to financial ability to provide the services proposed. It is a key element of their proof that they can do this. And just to say we got equity, if the equity is $1 versus $100,000, is huge. These are all projections.
Thank you, sir. I call that leverage and I call it liquidity. Those might be just my terms. I'm going to overrule the objection. You can answer the question, sir. How much?
In my house, I have approximately $75,000 worth of equity. In my partner's house, I believe he has, I'm sorry, I can't remember if it was $150,000 or $250,000 worth of equity.
Thank you. Next question.
Now, with obtaining that kind of equity in the real estate we've just discussed, have you projected how long it will take to obtain those funds?
How long it would take us to obtain loans?
Yes, sir.
We're estimating between 1 and 2 months to obtain a HELOC.
Okay. Now, you've also indicated that there is a line of credit available for you to help finance this company. Is that correct?
That is not correct.
Okay. So your testimony concerning a line of credit is evidenced in the documents attached to your testimony. There is no such line of credit?
Could Mr. Maurer point to the testimony he's referencing?
Yeah, please, Mr. Maurer. Thank you, Mr. Marks. Mr. Maurer, we'd appreciate it so we could follow along with your line of questioning better, if you would refer to it.
All right, this would be on MP03. You've indicated under financing activities that there is a line of credit. And as an example, in April of your forecast, that there would be a payment due on interest in the amount of $185. Isn't that true?
What page number of NPO3?
Mine is just identified as MP03 cash flow forecast. Year one.
Yeah, I'm sorry. Now that I've seen the specific reference, would you repeat the specific question for me?
The line of credit referenced. How much is in the line of credit that you're referencing?
That line of credit is the result of limitations of this template that I was using. I was presuming that to be member contributions.
So the line of credit that you've identified is not from some type of lending agency. It has to do with the contributions I was asking you about from the members?
Correct.
Okay. So is there, just so we're clear, a commercial line of credit you have accessed?
There is not.
And with regard to loan payments, that is being addressed in what you are calling now your line of credit.
I'm sorry, I do not understand the question.
Loan payments. Do you have any loans that you will be making payments on other than the line of credit you just identified?
I didn't identify a line of credit.
Let's start back. With regard to MP03, you have identified that with regard to payments that you will forecast, there is a line of credit interest. Isn't that true?
That is identified in that document.
Okay. And you've just testified, if I'm not mistaken, that that is identifying the loans that the members have made to the LLC. Is that correct?
That is not correct. That is not what I have testified.
Okay. So the line of credit identified where there's going to be some type of interest paid back, do you have a commercial line of credit available?
Objection asked and answered.
No, it's not been. In fact, he's gone
I
back
wasn't
now.
clear with the answer, so it's overruled. Please answer the question, sir. Maybe we can ask, is there a line of credit you have access to?
We do not currently have access to a line of credit.
Okay, thank you. I think that was what we were getting at, despite the figures on the flow chart, on the chart.
Now, with regard to your testimony, you've indicated that you're thinking that there could be an SBA loan available. Is that true?
We believe so.
And have you actually contacted the Small Business Administration to make such a determination?
I have not contacted the Small Business Administration. However, I've contacted Small Business Administration associated lenders.
I didn't hear the last part. I'm sorry.
I have contacted lenders associated with the Small Business Association.
Okay.
Of office.
Have you filed such an application?
I have not filed applications, no.
Do you or have you determined how long it would take to get such a loan?
It would depend on the specific type of loan we applied for.
And what was that? What specific loan did you apply for?
I did not apply for a loan. It would depend on which loan we did apply for.
I'm sorry, I'm losing you in your last part of your answer. So my question is, let me just make sure we're clear. Have you applied with the SBA for a loan?
I have not.
Have you applied with any commercial lending organization for a loan?
I have not.
And do you know how long it would take to obtain such a loan?
It would depend on the loan.
And have you determined how much you would be eligible to receive for such loan?
It would depend on the loan.
And when you say depend on the loan, what do you mean?
There are multiple loan products we could apply for. Each of them have different terms.
Okay, but I'm asking about not the terms, how much?
The term, this may be a legal term of art. I apologize if it is. When I meant terms, I meant the overall conditions of the loan, what availability there might be, how much there might be available, how long it might take to obtain.
Okay.
The overall, I believe, package is the word.
So with regard to the things you just broke out specifically, how much have you looked at could be available? Have you determined that?
Could be available.
Yes.
Potentially, we could apply
Yes.
for a 7A and be available up to 5 million. I don't believe that's a route we would take, but we could get 5 million.
And what collateral would you be using from the LLC to secure a loan of that size?
I apologize. I believe I misspoke. There is a collateralization requirement of the 7A. We would not be eligible to set 5 million for a 7A.
All right. In your application, as I understood it, during your employment with Rocky Mountain, you were the deputy director of operations. Is that correct?
For a portion of my employment, yes.
Okay. In your application, you've indicated that the service that you would be providing would use a answering service to receive calls. Is that correct?
That's not correct.
How would you receive calls for service?
They would be answered by employees.
Okay. Employees located at?
Most likely our Santa Fe base of operations.
All right. And with regard to your employees, that would mean people in addition to yourself and your partner?
Potentially.
With regard to adding additional employees, how many employees can you hire before you're required to provide workers' comp insurance?
My understanding is that the minute we hire an employee beyond myself and my partner, we are required to provide workers' comp.
And where in the documentation that you have provided us, is it identified the cost of such insurance? I was unable to find it.
Pardon me, I see general insurance expenses other than health in the operating expenses projected, NPR-02. Are you referring to those, Mr. Maurer?
I was looking at, payroll year one, MP03, under payroll taxes and benefits. There is a provision in the document that provides for workers' comp insurance, but there is no indication of evidence of the cost of such insurance, even though projecting that there could be as many as 13 employees, part and full-time?
Thank you, sir. You may answer, Mr. Prescott.
That is correct. I failed to include that.
And did you also fail to include employee health insurance?
We were not planning to offer employee health insurance at the commencement of our operations.
I'm sorry, I didn't hear the first part. You're not offering it, or you're going to offer it?
We are not planning to offer it immediately.
So with regard to your payroll cost in operations, you don't know the cost of what it's going to be for workers' compensation, do you?
That is correct.
All right. All right. Now, as I understand the documentation provided, you have indicated that there has been a figure of $20,000 spent on ambulances. Is that correct?
That is correct.
There has been $4,000 spent on equipment.
That is correct.
There has been $7,000, and I may be mistaken. Is that included in the 20 for the van, or is that separate?
I'm sorry, $7,000 for what?
A van? You provided a receipt for a van. Is that the same? Is that also considered to be an ambulance that's in the 20, or is that separate?
That is an ambulance that's in the 20.
All right, thank you. And also $4,000 for the formation of the LLC. Is that correct?
I'm sorry, where are you seeing that?
Let's see. Oh, I'll move on. I don't see the available. Of the monies that we've identified, are those the monies that we've already discussed that you and your partner have lent to the LLC?
In part.
Where is the other source of those monies besides you two?
We are the sole providers of monies to the LLC.
Okay, so the monies we just discussed came from your partner and yourself.
It sounds like that's what he just said, Mr. Maurer.
Making sure.
Sustained.
Now, Mr. Prescott, with regard to some of your cost estimate, you've indicated that you used a 12% rate of uncollectability. Where did you get that figure? What did you base it on?
I base that figure on conversations with an out-of-state ambulance provider as well as research.
Okay. And who's the out-of-state ambulance provider?
They are called Physician Ambulance Service. They're based in Indianapolis, Indiana.
Okay. And with regard to this company, are they in any way related to your company by size or operation?
They are, in that they are an inter-facility transport provider.
But how big are they compared to what you're projecting?
They are larger than we are projecting.
Okay. And so you're relying on that figure from somebody who's operating outside the state of New Mexico, not in the state, correct?
Correct.
All right. Now, with regard to, you used a figure of fuel usage of approximately 40,500 gallons of gas over a 2-year period. Is that correct?
Is this in my discovery responses to Superior?
Mr. Prescott, it's not the witness's place to be asking questions. So I'd caution you to please don't ask questions in response to the interrogation. If you don't understand the question or it's not adequate, you could respond that I don't understand your question or something to that effect. But I'd rather you not be asking questions of counsel.
I apologize.
Yeah, I let them go for 3 or 4, 5, 6, 7 times, and on the 8th time or so, I don't want to hear that again.
I definitely need my chain yanked sometimes. I apologize.
Mr. Maurer, that being said, could you perhaps be a little more clear? Thank you.
Mr. Prescott, you've estimated that there would be over 2 years, approximately 40,000 gallons of gas used to provide this service. Is that true or false?
That sounds roughly like what I had projected, but I can't swear to the specific numbers you provided.
Where did you get that figure from?
I estimate fuel usage based on anticipated mileage by the anticipated fuel economy of the vehicles we purchase.
Okay, all right. And where in your operating cost is that figure contained?
That is contained in the cost per unit of the mileages. There's an indicated cost per unit of $1.2 per mile, which is 60 cents per mile, which was what I estimated our variable cost of fuel, tires, repair, and maintenance doubled to indicate both the empty and loaded mileage.
Okay, so as an example on MP3, operating expenses for 1 through 3, where in that document do you contain that just the gasoline figure?
I did not break it down by just the gasoline figure.
Okay.
The diesel figure.
Where did you put that figure in MP3? If it wasn't identified as gasoline, where is it contained?
It is contained on the page labeled Sales Forecast Year 1. Under both Medicare, Medicaid, and free miles, the cost per unit.
So that figure is contained in your sales forecast in cost per unit?
Correct.
All right. And does that also include the maintenance for the vehicle?
It does.
All right. Does in your cost, or let's put it this way, with regard to your medical director and your pharmacist that you're proposing would come on staff, where is their cost demonstrated in your cost estimates for business?
Under operating expenses, year 1, as well as other operating expenses, it's indicated under legal and professional services.
All right. So inside that figure of 24,000, you are including the cost for legal and those 2 professionals?
Correct.
Okay. Now, you've indicated in your testimony that you believe that within 3 months of beginning operations, this company will be profitable. Is that correct?
That's what I've indicated.
Where did you get the source? What's the source of that project or profitability? And how did you come to that analysis?
Analysis was based on the spreadsheet presented.
Okay. But what I'm asking is, so you sat down and what you're doing is making projections, but with regard to the reliability of this figure, did you do any research? Did you do any analysis to determine whether or not you think you can be profitable within 3 months?
I did.
All right. And who did you contact or what did you research?
I researched most figures, if not all figures, that occurred in the spreadsheet. I made best guess estimates based on my experience and accepted the results of the spreadsheet.
Okay, so the 3rd month profitability then is based totally on your analysis and nothing from outside comparisons, correct?
I'm not sure I understand the question.
The 3-month profitability that you're estimating is based 100% on your analysis and not on any kind of outside information you're relying on. Correct?
There's a great deal of outside information that went into my analysis.
That's what I'm asking. What outside information were you relying on to get that?
almost every figure that I couldn't provide a reasonable estimate on based on my experience, I would research until I found an answer that I felt adequately represented the figure needed.
Now, with regard to your testimony, if I'm not mistaken, you indicated that you, with regard to your accounting and cost recovery for accounts, you're going to hire a company. Is that correct?
That is correct.
Where in your cost analysis is that figure of the cost of hiring that company provided?
That is provided under legal and professional services.
So that figure, along with your professional hiring of people and your legal services, is all inclusive,
That is.
right? And how much are you going to pay to have your accounts receivable managed and collected each month?
That will depend on the number of runs we perform.
I'm sorry, you don't have a number?
That will depend on the number of runs we perform.
Okay, so at best, that's an estimate. That the 24,000 is an
There are
estimate.
pro forma projections. It's all estimates.
Okay, you've estimated a growth rate of 20%. What source did you obtain that from?
I'm sorry, I don't understand the question.
You've estimated a growth rate of 20%. Is that correct?
Of growth. I apologize. Yes.
Okay, and I'm asking what source did that figure come from?
That is my best guess for the growth over the first 3 years.
Did you say best guesstimate?
Yes.
No, I apologize. Best guess of our growth over the first 3 years.
Best guess is the answer. The horse is dying. I don't know how long we need to kick it. So,
Mr. Hearing Officer, I'm not quite sure what you meant by that comment.
okay, well, that's a metaphor for you don't, kick a dead horse. I think the point is being made that you have that Mr. Prescott's data is soft, if you will. And the point is being made, and I'm just wondering how much more you need to make the point. I don't want to cut you off. I just, that point has been made with your cross-examination.
All right. I noticed, Mr. Prescott, that the two figures you primarily relied upon with regard to services were Medicare and Medicaid. Did you include anywhere in this documentation private customers?
As I stated in my testimony, due to the limitations of the spreadsheet I was using, I rolled in all private insurance as being part of Medicare, under a belief that the private insurance pays at a higher rate than Medicare does. However, I would be conservative in my estimates.
But with regard to cash flow, I didn't see anywhere in your analysis private recovery. Where did you provide that other than the sales volume for Medicare and Medicaid? I didn't see those figures. Where are they?
Objection, asked and answered. He said that he included the private insurance data is included in the Medicare line.
Yeah, that was his answer, sustained. Next question.
Once again, I have one more question in this line.
Yes, sir.
You've estimated a cash sales of between $20,000 and $35,000 a month. Is that correct? I didn't hear an answer.
I'm sorry, I'm looking through my documentation.
I don't know where you're looking, Mr. Prescott, and I don't know where you're looking, Mr. Maurer. Like I've said before, I'd like to know so I can follow the interrogation. Where are you getting that figure, Mr. Maurer? Where did he state that?
Sales forecast. If you look at MP3 sales forecast,
Okay.
total sales, you're looking at approximately $20,000 a month. And I'm asking where you got that figure from, how you came up with that figure.
I'm sorry, I don't see $20,000 per month by total sales.
Okay, there's the answer. He
Okay.
doesn't see that figure.
If you look at M,
I also don't see that figure for what it's worth.
all right, if you look at these figures that you provided in MB3 sales forecast, years 1 through 3, you're evidencing under total sales, as I read this, of $20,000 a month. Is that correct?
That is not correct.
Okay, so if you look at Medicare pickups sold, total sales, if I go across to the third box, it says 20,000 for April, 25 for May, 25 for June. Do you see those figures?
Specifically for Medicare pickups, yes.
Yes. Okay. And what I'm asking is, what is the source of that figure? What did you do to divide or ascertain that you think you could do that in a sales forecast? That's what I'm asking.
That number is developed by taking the average number, the number of Medicare pickups I anticipate providing in any given month, and multiplying it by the a calculated average of the call mix that I anticipate, the call service level type, that is to say BLS, BLS emergency, ALS, ALS emergency, ALS 1, ALS 2, etc.
Okay.
I'm
sorry, go ahead.
I referenced the 2020 Medicare reimbursement scale. I calculated what the average Medicare reimbursement would be given the expected mix of service levels, and then multiplied that by the anticipated number of calls, and then reduced that by expecting that I would never receive any patient contribution.
And then you rounded it off, correct? Because using math like that's not going to give you such a round number so consistently, correct?
As far as the consistent number, I averaged my annual expectations across 12 months.
Thank you, sir. Mr. Maurer, is that a sufficient answer for your question?
Yes, sir. I don't have any further questions at this time.
Thank you, Mr. Maurer. And we're now at 12:35. Frankly, we've got a bunch more. That's a big number of witnesses, and we haven't even continued with the other interveners' cross-examination of this witness, not to mention the redirect. My hope to complete this today is slowly disappearing into the sunset. Not to mention my hope to finish this by 3. We haven't taken a break for a while. It's time for a men's room break and perhaps a coffee break. It's also possibly time for lunch. I haven't asked council their opinion on lunch. Sometimes I just plow through. It looks like we're all in our offices or our homes. We could take a short lunch break, perhaps a half an hour, and then continue with the other interveners' cross-examination. Is there a concurrence on say a half hour's lunch break? Mr. Marks, I saw your head bob up and down. How's it sound to you?
Yes, we concur. And on the positive side, Mr. Lennon, I'd note that according to my notes that the cross-examination's gone for about an hour and 20 minutes, so it hasn't been quite as long and grueling as it feels.
Well, and
thank you, Mr. Marks.
You guys are all buddies.
Mr. Lennon, if I could say something else, that we probably should accommodate, I think it's Mr. Casper, when we come back from lunch.
Well, we're going to finish cross-examination this witness, and then your redirect, and then we may accommodate him. Okay. That's a good idea.
I would like to still shoot for getting it done today is where I'm going.
And I'm also hoping that we're going to move a little more quickly. I will disclose that Mr. Maurer actually asked many of the questions that I had for this witness. And that's kind of interesting. And I hope that he had also asked many of the questions that the other cross-examining parties may have asked, so that their cross-examination is going to be markedly shorter. And I'm hoping that'll be the case. The first guy up seems to get all the shots in. Anyhow, Mr. Borman, are you okay with taking half an hour? You can nod.
Yes, I'm sorry. I was just checking to see if I was muted. Yes, a half an hour is fine.
Mr. Bartel, you good with a half hour?
Yes, that's.
Mr. Batia?
That's fine.
Ms. Maggiore?
Yes, sir.
Half hour. Okay, my watch says 12:40. So we'll be back at 10 after 1. I'm going to let everything continue. I recommend you guys don't talk on the Zoom while we're on our 1 hour lunch break. Thank you all. See you in a half an hour. Bye-bye. Seemed like a short half hour to me. Yeah. They seem to be putting less minutes in those half hours. Well, the reason I take only a half hour is because about 5:30 or 6 o'clock in the evening, people wonder why we took such a long lunch break. So that's why I take short lunch breaks. Hold on, people are calling me. Okay, I know who that is. Ms. Hoyman, I understand there's some agreement for an additional fee over and above your normal fee after 5 p.m. Okay, so I've just conferred with Anna about that, and I'm aware of that. If we can push this case to finish it today rather than have to go to a second day by going to 6 or something like that, I'm all for that. Of course, I confer with counsel and make sure it's okay with everyone. Time out. Mr. Marks, unmute. And Mr. Padilla, we've got another, I'm not hearing anybody.
It's just Mr. Padilla. I'm
Mr. Padilla.
just wondering, you mentioned something about you had something at 3 o'clock. If we continue beyond that, are you going to break at 3 and do what you got to do, or did you cancel?
Can anyone hear me?
I can hear you. And I'm going to answer Mr. Padilla first. Mr. Padilla, I've already worked that out during the ever so short lunch break. What I had scheduled was a Zoom meeting with all the hearing examiners. And they understand that I can't be there.
You are unmuted.
Somebody is now
Can
unmuted.
anyone hear me?
Yes. We hear you. Hi. So the sooner we get rolling again, the sooner we can conclude the entire case, and perhaps today. Hopefully the next witnesses will go quicker, and hope that the cross-examination will also go quicker, which is what I anticipate.
Pardon me, Mr. Marks still having some problems with his audio.
Okay. While he's doing that, we have that is it Mr. Casper that had a hard, what we call it a hard limit of 3 p.m.?
Yes, Mr. Hearing Examiner. Mr. Casper is available only until 3 today.
Well, I don't mind taking witnesses out of order, but cutting up the cross-examination of this witness, I'm not too fond of. So it looks like this case could realistically continue to a second day. Would he be available tomorrow? Do you know?
No, I've checked on that. That's not a good alternative.
Okay.
Monday or next Friday would be possible.
Getting all kind of weird space noises right now.
Yeah.
Yeah, okay.
So I'm looking at my calendar here to see what I'm available on Monday. I hear a feedback going on. Somebody might be logged into YouTube as well as the Zoom. That'll cause it. It's not me. All right, well, I like I said, I'm not inclined to cut up the cross-examination and redirect of this witness, so we're going to continue. I'm sorry, it's unlikely we can guarantee that he'll leave at 3, so he probably would have to be the first witness on the continuation day, and we can agree on the continuation day at the conclusion of today, which I had scheduled till 5 p.m. I don't have anything better to offer you, Mr. Bartel. So sorry about that. All righty, so let's get rolling and continue on. We have, who are we missing? We got Mr. Maurer there. You know, it's funny, all of your boxes have moved around on my screen, so I have to find you again. There you are, Mr. Pricecop. You're down in the lower left now, and you were on the upper right. Okay, our next cross-examiner following my would be Ms. Maggiore from on behalf of AMR, are you prepared to cross-examine, or do you wish to cross-examine Mr. Prescott, Ms. Maggiore, on the telephone?
I do, sir. I didn't hear if Mr. Mauer was finished.
I thought he had concluded. Mr. Mauer, have you concluded your cross?
Yes, sir.
Thank you, sir. So there's the answer. He had concluded. That's why I took the break right at that point. I was waiting for him to conclude. So you're on base, or up the bat, as they say, if you're ready to cross-examine this witness. You need not. You know, you have no obligation to, but that's kind of why we're here.
Did we lose her?
I'm not hearing anything at all, Miss Prescott. Miss Prescott.
I'm sorry, am I here now?
You are there, Mr. Prescott. I'm sorry, I'm not hearing Miss Maggiore. Pardon me. You know, we should all learn sign language. Does anybody here speak sign language? No communication? Nobody does?
Not any phrases that are usable in polite society.
I wonder what happened to her.
I don't know, but she had her video through Zoom computer, and she had her audio through, there she is again on video, and her audio through the phone. So she's probably reconnecting. Because she has low bandwidth, and it's a problem that I suffered from. And by the way, I hope you're not writing all this down, Miss Hoyman. You are writing it down.
When in doubt, keep writing, but I can take it out.
Yeah, I know you have a certain discretion on what is and what is not included, and this should not be included. Anyhow, the state supplied me with a fancy cell phone, which I've didn't want for about 11 years or 10 years. And it has a better than my home bandwidth. And since I've got this fancy cell phone, I don't have any problem with it. Okay, Miss Maggiore, are you back?
So just let me know when you want to be on the record, sir.
Okay, thank you, ma'am. I'm waiting for our counsel there. You're not unmuted, Miss Maggiore, but I guess that's your computer mute and you're calling on the phone. Can you nod your head if you can hear me? No, she doesn't hear us either. So maybe all her audio is through the phone. Okay, I can stall for just so long here.
Mr. Lennon?
Yes, sir.
In this, Mr. Erskine says that he disconnected and he'd like to get back on the Zoom.
Well, okay. Oh, is he in the, let me see if he's in the waiting list, in the waiting room. I don't see him. So he's welcome to do that. I don't see him in the waiting room.
Okay.
I don't see anybody in any waiting rooms.
Mr. Lennon?
Yes, sir. Oh, yes, he is.
Miss Maggiore is saying, I guess you have to unmute her physically.
Okay, I'll try that. This is the world we live in. Hold on a second, guys. Weird. I don't think I have to unmute her. Miss Maggiore, could you try to unmute yourself by, in your bottom left corner, there's a microphone. Could you press that and try to unmute yourself? There. Okay, there you are. Now you're unmuted.
Okay, there you are. Now you're unmuted.
Well, what we're hearing is.
Okay, but I'm still on the
telephone.
Phone, so let me kill that.
Yeah, kill the mic. There we go. All right.
Yeah, kill the mic. There we go. All right.
Okay.
What an echo.
Okay. What an echo.
Okay, I think I can fix it.
I think I can fix it.
You guys, if you have, like, did you see the note from Jason? If you've got the YouTube lit up, turn it off. Make sure you don't have any other windows with YouTube running.
Also, if you have your phone and your computer going, you'll get feedback.
All right, can everyone hear me?
Absolutely.
Yes, ma'am.
You're not moving on my
No.
picture, but I can hear you.
You're not moving on the picture, but I can hear you. You're not moving on the picture, but I can hear you. You're not moving on the picture, but I can hear you. You're not moving on the picture, but I can hear you. You're not moving on the picture, but I can hear you.
In the meantime, while this is going on, can I ask if this makes me more comprehensible for the stenographer?
You're talking about the Echo or your headset?
My headset, and we rearranged things how we were working it here.
Great. All right. Shall we try again? Ann, you have the floor. Counselor, Ms. Maggiore, I don't know the answer, but you might try. The video takes a lot more bandwidth than the audio. So one thing you could do is disable your video and then continue just with the computer audio. We got a nod from Ms. Hoyman. She's a pro. And I've become kind of a pro over the last few months. Unintentionally. So there you go. So unmute yourself now on your computer and see if we can hear you, and you'll participate audio only. Not optimal, but it is what it is.
Okay, I think that's going to work.
Alrighty. So are you
okay? Let's
just identify yourself for the record, and then you continue with the and start your cross-examination, if any.
All right. Good afternoon, Mr. Prescott.
Good afternoon.
My name is Ann Maggiore. Mr. Prescott, are you able to hear me?
Not really. I forgot that, but you cut out for a long time there, I'm afraid.
Okay. How about now? Is that any better?
It seems to be pretty clear on my end.
Okay, just let me know if you start to lose it, and we'll try to take some steps here to fix that.
Will do.
Mr. Prescott, you worked for 5 years for...
I'm sorry, I lost you again.
You worked for 5 years, sir, at Rocky Mountain EMS from 9 of 2012 to 7 of 2017. Is that correct?
That is correct.
I'm going to try to go back on the phone.
Thank you, Ms. Maggiore. Yeah, it wasn't working. I don't know. I have no explanation, no solution.
All right, let me go try the phone again.
Have you ever tried, I'm not suggesting it, but hotspotting your internet through your phone? Because that's how I'm running right now. Are you familiar with that hotspot?
I have tried that. I haven't had great luck with it, though, but let me try this one more time because it usually works.
Well, you've been fine all day so far.
Yeah,
it happened eventually. We're just saving it up.
The same thing here.
Enter your meeting ID followed by pound.
So while we're waiting for that, can I make one
comment.
Rather you're not. Who is that? Marcus?
Sorry, this is Scott Casper.
Oh.
Participant ID followed by
Scott Castle, what's your comment?
pound. Otherwise, just press
You're
pound.
not testifying at this point, and you typically would speak to your lawyer or speak through your lawyer.
You are in the meeting now. There are 16 participants in the meeting. You are muted. You can mute or unmute yourself by pressing *6. Yourself. You are unmuted.
All right, can you hear me now?
Wonderfully clearly.
Well, let's roll with that.
And then you started breaking up almost immediately.
All right, Mr. Prescott.
Ms. Maggiore, you're not there. What we're going to do is go to the next party. If you could play with your system there, maybe try something different, maybe put the phone closer to the window at an upper floor, something like that. I don't know what. Get closer to your internet router. That sometimes works if you're doing Wi-Fi.
Does
also,
that work?
Well, it does now, but in a second it may not. That's the problem we're having. You're going in and out. Sometime you're there, sometime you're not. Are you there now? You also could try to hook an Ethernet cord to your computer rather than using Wi-Fi so that you're hardwired into your router. That sometimes works as well. What we're going to do while you might play with that is move on to, with your permission, I don't mean to be pushy. With your permission, we'll move to Mr. Padilla. So Mr. Padilla can cross-examine. Maybe he'll ask some of your questions or answer some of the questions you have. Mr. Padilla, would you be willing to cross-examine at this point now?
Certainly.
Okay.
Can I ask a question first, Mr. Hearing Officer?
Mr. Maurer, yes, sir.
Can she at least hear the questions that are being asked by counsel so that she's keeping up?
I certainly hope so. Ms. Maggiore, can you hear us?
Yes.
That sounded like a yes.
Thank you, sir. I can hear you. Can you hear me?
Well, you're in and out. Even that statement, can you hear me, was chopped up a little bit.
The phone number isn't coming up on the screen, and that could be part of the problem.
Okay, well, let me check that because I'm kind of the host of this meeting. Ms. Maggiore, can you hear me? Say it looks like she can't.
It looks like she can't.
Okay, whatever you
just did, I think.
Change the phone.
Change
I think
the
you let
phone.
me
I
in
think
on
you
the
let me
audio.
in on the audio.
Mute your computer.
Just did.
Just did.
We're still getting all kind of echo there. Mr. Padilla, if you could stand by just one more moment. Let's see if we can get Ms. Maggiore.
Mr. Padilla, if you could stand by just one moment.
And please try it again. See if you can start your question.
Please try again. See if you can start your question.
Go ahead. Ann, can you hear me? Well, obviously she's not hearing.
I am hearing you on the phone.
Okay, why don't you try to begin your cross-examination of Mr. Prescott just once more using the phone, and we'll see what happens. Go ahead.
See what happens.
Mr. Prescott, can you hear me now?
Mr. Prescott, can you hear me now? Mr. Prescott, can Can you hear me now? Can you hear me now? Can you hear me now?
Mr. Lennon, I think Ms. Maggiore needs to turn the volume off on her computer. So the only audio she has on either microphone or speakers is the phone.
Agree with you, and I'm all the way off on my computer speaker.
Okay, I think maybe we're ready to try this one more time.
Mr. Lennon, you're muted.
Okay, thank you, Mr. Prescott. Ann, are you ready? All right, I've reached the limit of my tolerance of this kind of stuff. So we're going to go with Mr. Padilla, and we'll see what happens after that. Mr. Padilla, I'm sorry to put you to call you to bat and then ask you to get standing aside. Are you ready to go? On mute.
You're talking to me? This is Mr. Padilla.
Well, that's a great line from a movie, Mr. Padilla, and the answer is yes. Let's do your cross-examination of Mr. Prescott at this point.
And Mr. Hearing Officer, this is Fred Mauer again. In fairness to Miss Maggiore and AMR, can she at least hear what's going on so that she's not prejudiced by us moving forward on cross-examination of the key witness here and not able to participate?
I understand that, and it's good that you preserve that for the record.
And I would join in that just for the record.
Miss Maggiore, can you hear us? I'm not getting any response whatsoever from her. No one's moved to continue it, and I really don't want to.
I will. This is Fred Mauer on behalf of Superior. And I will move to continue this in fairness to AMR and Ms. Maggiore, because while I understand difficult times in trying to do this hearing, it's not fair to them and will definitely create grounds for objection and continuation if she cannot at least even hear what's happening to the one witness of the applicant. So I move to continue.
All right. Is there any concurrence or objection? Mr. Marks?
Mr. Lennon, I'm not sure what's being moved for. We don't object to a few minutes delay for her to get her technology going, but we do object to continuing this hearing to another day. And every attorney on this call, this is not our first group hearing with a district court or appellate court or what have you. And or appellate court, we were.
Excuse me, you're getting interference.
Right.
So I'm having a difficult time hearing you. I think it may be coming from Miss Maggiore. Now you're muted.
So.
Thank you, Ms. Hoyman.
I'll leave this to the hearing examiner. We do object to continuing this to another day. That's prejudicial to my client.
I understood. Mr. Bartel, any position on the motion? And I understand it as a continuation to another day. Well, I shouldn't comment before you comment. So do you have any position?
This is a artifact of the problem we're having right now with doing everything by Zoom. And I have to say, I think it is important for a party to be able to participate in a realistic manner. So
you're joining the motion?
Yes.
Okay, thank you. Mr. Borman, position?
I'm not going to join the motion, but I'm not going to oppose it either. My main concern is that if we do adjourn for today and continue it to another day, trying to find another day that we can get everybody together becomes, increasingly problematic as we go on.
Understood. Let me go back to Ms. Maggiore. I'm sorry if I'm mispronouncing that, but are you online at this point? Please unmute yourself or talk into your phone. Okay, we see you looking at your phone, but do not hear you.
Okay, I just took myself off computer mute.
Okay. Well, if you're online, the
I
motion is.
can see everyone and I can hear everyone. So if you want to continue with someone else, I'm okay with that.
All right. Well, that's the evidence I was looking for. Mr. Maurer, I'm going to deny the motion to continue at this point. You're welcome to renew your motion or make another similar motion should we get to that point. But a motion to continue is denied. So we're going to continue with Mr. Padilla. And who knows, the gods of the internet may correct just as she has created the issue.
Now I'm losing you. I'm losing you now. I'm hearing multiple voices.
Okay. Mr. Padilla?
I'm getting a lot of interference as well, Mr. Hearing Examiner. So I'm willing to proceed, of course, if that's your order. But I am concerned that Ms. Maggiore might again fall off, and I'm concerned with that creating an issue for a potential appeal with regard to her inability to fully participate in this matter. As far as the comment from Mr. Borman that where we're going to find another day, I set aside today and tomorrow because it was my understanding that your ruling was we would go till tomorrow. Now I understand that Mr. Casper might not be available tomorrow, but if we're forced to continue this matter, then I would think we should be able to at least hopefully do everything else tomorrow except for Mr. Casper, and then find a short period of time in which to deal with his testimony. But obviously you're the hearing examiner, and whatever you decide, I'll go with.
Well, the aggrieved party concerning access would be Ms. Maggiore, and she just essentially consented to going forward. So I don't believe there's not exactly a waiver of due process, but she agreed to go forward even though she's having these issues at this point. So my point is to go forward as much as we can. These are difficult times, and in difficult times we suffer difficulties. Let's see if we can get as much done as we can. Like I said, I'm anticipating subsequent cross-examination to be much quicker because lots was covered. Frank, thank you to Mr. Maurer. And we're just going to do with what we got. Ms. Maggiore, if you can hear me, and I hope you can, if you somehow drop off and can't participate by listening, you can use the chat. Let's see, the chat, and I will monitor the chat to see if you are no longer listening through your phone. Mr. Padilla recommended that you log out of Zoom and restart. There's another option, but right now you seem to be receiving audio, and you are transponding video, so we see that. So let's just continue as we can. Mr. Padilla, sorry to interrupt you. I think that's the fourth time, and I'm going to make it the last. The floor is yours.
All right, thank you. All right, Mr. Prias. I'm going to have a number of questions with regard to the application itself, which is Exhibit 9 for the applicant. Do you have the application in front of you? Because I'm going to be making reference to specific portions of the application. Am I on?
Unmute.
I do.
Am I on or not? Okay, Mr. Prias, you do have it?
I do, yes.
Okay. Let's start with this, Mr. Prias. If you look on page 9 of 12, item number 4, you see that?
I do.
Okay. That talks about, it says description of transportation services to be provided. And then it basically quotes from section 65-2A-3B of the Motor Carrier Act. And it talks about what ambulance service means. You see that?
I do.
Okay. Now, the notice of application for a certificate in this matter that was sent out on July 17th described what Helios is applying for to be an ambulance service transporting patients and or deceased persons between points and places in the state of New Mexico over regular routes under scheduled service with equipment stationed in Santa Fe, New Mexico. My question to you, sir, those two are inconsistent because the application doesn't mention deceased persons. And by the way, I apologize. I need to tell you that I represent Rocky Mountain EMS in this particular matter. But anyway, is Helios in fact requesting certification to transport deceased persons?
I did not write the notice of application, and we are not requesting certification to transport the deceased persons.
That's good with me. That clears it up for me. Okay. Now, looking at Exhibit B to the, it's about, I think if I counted correctly, about 17 pages in. There's a page that just says Exhibit B, affidavits of fitness, ability, and utility to public interest. You see that?
I do.
Okay. And do you have the instructions portion of the form itself? It would be on page 4 of 12. There's instructions for Exhibit B. Do you have that?
I do.
Okay. So the instructions for Exhibit B say two things. The first thing it says that you need to provide, that the applicant needs to provide an affidavits or other evidence upon which the applicant intends to rely to show that the applicant's fit and able. The second says the same thing, starts out the same way. You need to provide affidavits or other evidence upon which the applicant intends to rely to show that the proposed service will serve a useful public purpose and that the ambulance service that currently exists in the territory is inadequate, and you need to submit affidavits or other evidence to the effect that issuance of the certificate would have on the existing ambulance service. You see that?
I do.
Okay. Now, do I understand correctly that you prepared this application?
I did.
Okay. And in preparing the application, did you familiarize yourself, at least basically, with the Motor Carrier Act and with the rules and regulations of the PRC as they apply to ambulance services?
At least basically.
Okay, I understand you're not an attorney, so I'm not going to be asking you to give me legal interpretations, but you have a generalized knowledge, correct?
Generalized, correct.
Okay. And if you get this certificate and Helios is allowed to be to operate as an ambulance service, then Helios is going to have to comply with the statute and with the rules and regulations, correct?
Correct.
Do you agree that it would be logical then that Helios is going to have to be at least somewhat familiar with the statute and the rules and regulations?
At least somewhat.
Okay. Do you think that Helios would have to be more knowledgeable about the rules and regulations after certification, or are they equal?
I would imagine that different proportions would apply.
I'm just asking in terms of your knowledge with regard to the application. Are you comfortable with that you know enough about the Motor Carrier Act and the rules and regulations to understand what you filled in?
I believe so.
And to understand what your responsibilities were?
I believe so.
Okay. So let's look at Exhibit B itself. There are 6 letters there, okay? The first 2 are signed by you, correct?
Correct.
Okay. If the first letter itself, the first one that's signed by you, has some generalized description, but it ends up saying that Helios has no intention of competing with existing EMS agencies throughout New Mexico. Does EMS, do I interpret that correctly to mean emergency medical services?
That is the acronym, yes.
Okay. So is there anything else in that first letter that's of importance, of particular importance to the application other than your general description of your understanding of interfacility transport?
Objection, he's calling for a legal conclusion.
I'm asking for his understanding, not for a legal conclusion.
Mr. Lannon, I believe you're muted.
I'm sorry, I didn't hear your entire.
Thank you. Overruled, please answer. And thank you.
Mr. Prias?
Pardon me, it's been quite a while since I wrote that letter. I wanted to review it to make sure I could answer correct.
Okay, what is the answer to my question, sir?
Having reviewed the letter, could I ask you to repeat the question?
Sure. What I'm interested in is whether or not the primary purpose of that first letter signed by you is to state that Helios has no intention of competing with existing EMS services, or whether or not there's something else that's particularly important that this letter is intended to convey.
Letters, I believe it's also important to note that we are developing a focus on long distance transfers.
And could you please define that for me as best as possible? What do you consider to be long distance transport?
Generally speaking, anything that is not within a municipality or an adjacent municipality.
So would you consider, for example, transport from St. Vincent's Hospital in Santa Fe to Presbyterian Hospital in Albuquerque to be a long distance transport?
I would.
Okay. So anything outside the county then, would that be correct?
More or less, however, not exclusively. There are some large counties out there.
Is it the intent of Helios to focus on long distance transport in order to maximize profit because of the mileage?
It is our intention to focus on long distance transport because it is a need that needs to be met.
So I take it there's no need that needs to be met for interfacility transports within the county of Santa Fe then, correct?
That is not correct.
Okay, explain to me, please. What is the need for interfacility transport within the county of Santa Fe? The existing need that's being unmet.
It is my understanding that one of the primary providers within Santa Fe County is providing unsafe services and is thus not meeting the need for safe transports.
And when you say one of the primary providers, I take it you're talking about Rocky Mountain EMS, correct?
I am.
So would it be fair to say then that essentially the entirety or the majority of the focus for Helios is to take over the business of Rocky Mountain EMS, based on the presumption that Rocky Mountain EMS isn't going to be around for much longer?
That's not the focus, no.
What is the focus with regard to Rocky Mountain EMS? What business of Rocky Mountain EMS does Helios intend to absorb?
Could you clarify its business?
It's transports. How many of Rocky?
It's getting broken up.
Yeah, I couldn't hear what he said either.
I couldn't either, and now he's muted. Now he's unmuted. He might be pressing his space bar.
It's really broken up.
I'm sorry, is this clear?
Well, we can hear you now. We couldn't for a few moments there.
I apologize. We do anticipate absorbing some of the business of Rocky Mountain EMS.
What portion do you anticipate absorbing?
That's not really able to be determined.
Okay, earlier in your cross-examination, there was a figure used of from 5 to 7 runs per day that Rocky Mountain EMS does. How many of those runs do you anticipate that Helios is going to pick up?
That figure did not appear in my cross-examination.
Excuse me?
That figure did not appear in my cross-examination.
This is your cross-examination, sir. I think you mean your direct examination, and that's okay. This is cross-examination, and cross-examination is different than direct examination. Mr. Preiskop, these lawyers are trying to impeach your veracity or to impeach the veracity of the evidence you've presented in your direct. So they're not supposed to use trick questions or state the wrong factual scenario within the question, but they are allowed to ask you questions that you might not like. So I'm going to ask you to answer them the best you can.
I apologize.
Go ahead, Mr. Padilla.
So assuming that the figures that Rocky Mountain is doing from 5 to 7 transports a day, how many of those does Helios anticipate that it's going to absorb?
The 5 to 7 transports a day question was in reference to transports being sent by Chris St. Vincent, not transports being performed by Rocky Mountain EMS, which was what I was trying to state earlier.
Okay. Thank you. So you worked for Rocky Mountain EMS for 5 years, correct?
Approximately, yes.
Okay, and you left in 2017, correct?
Correct.
Your partner worked for them for approximately 15 years, correct?
Approximately.
And he was fired by Rocky Mountain EMS on January 30th of 2020, correct?
They separated on that date, yes.
Okay. So are you basing your figures as to what business is available on your experience as an EMT with Rocky Mountain and on your partner's experience?
Largely.
Okay. And what facts do you have to support that Rocky Mountain EMS will not continue to be in business? Not may not, will not.
It is my belief that Rocky Mountain EMS is non-sustainable under its current direction.
So that's just a belief on your part, correct?
It is.
You don't have any specific facts to support that, correct?
There is the issue of the 2 enforcement actions being undertaken against Rocky Mountain EMS by the PRC at the moment.
There's 2 enforcement actions. I'm aware of one. Could you tell me what both of those are?
I apologize. I may need to walk that back a little bit. I got in trouble for this before. The difference between an enforcement action and other actions, but I am referencing PRC case numbers 20-00181-TREN and apologize, the site that was in my direct, which I will pull up for you here in just a second. 19-00298-TREN.
Okay. Now, are both of those PRC enforcement actions to your knowledge?
And this is where I wish to slightly walk back my earlier testimony that I may have misstated that the first one I cited, the one starting with 20, is not an enforcement action. I do know, however, that the one starting with 19 is an enforcement action.
Okay. And wouldn't you agree that that enforcement action is still pending and you don't know how that's going to turn out?
Not with certainty.
Not with certainty, you don't know how it's going to turn out?
Correct.
Is that what you're saying?
That is.
You believe that that enforcement action is going to result in some sort of penalty being imposed upon Rocky Mountain, whether it be revocation, suspension, or fine, correct?
Correct.
Do you know the specifics of that case?
In that I've reviewed the documents that are posted.
Do you know that the PRC has already found that Rocky Mountain is in compliance as of November of 2019, reinstated Rocky Mountain and said that they would continue to operate until they make a final decision in that case?
I'm aware.
So the PRC has found Rocky Mountain to be in compliance, correct?
I don't know that I can state that.
Okay. Rather than continue to ask this witness questions about that, I would just ask that the hearing examiner take judicial notice of the proceedings that are being discussed, which is a proceeding against pertaining to the licensure of Rocky Mountain EMS that will be going to hearing on the week of January 4th through January 8th of 2021.
Mr. Padilla, I can take administrative notice that those 2 cases exist, and I am aware of them. I am not aware of the specifics or any details of the current status of those cases. And just as this case won't control those won't control this case. So, but I take administrative notice of the existence of 20181 TREN and 19298 TREN. Next question, if any.
Do you know, have you reviewed all the documents in the case that pertains to the potential revocation or suspension of Rocky Mountain EMS's licensure, Mr. Priest?
Not all of them now.
What have you reviewed?
Would you like an exhaustive list?
No, let's
Sir,
do it
please.
this way.
I'd rather you not ask questions of the council when they ask you a question. So, you know,
I apologize. I know you've already warned me. I'll try to be good, I swear.
I believe you. And this is not, I know that you don't do this every day, but there's a certain way we do things, and the lawyers ask the questions, and they don't always get the answers they like, but they are not accustomed to being asked questions during cross-examination. Sorry to interrupt you, Mr. Padilla. Please proceed.
Mr. Priest, are you aware that that case began as a result of an anonymous complaint?
I am.
Are you aware of the fact that the case progressed because there were 12 more anonymous complaints?
So we're getting into irrelevant territory here. I haven't heard an objection, but I'm not going to try that case during this hearing. With that, like I said, I haven't heard an objection, but go ahead, Mr. Padilla.
Mr. Hearing Examiner, this witness has already testified that he believes that Rocky Mountain's license is going to be affected in that case. If it's simply a belief, a wishful belief, that's one thing, and I'm willing to move forward. But if he has a factual basis for his belief, then I want to explore that factual basis.
And you're hoping there is none, am I correct?
My guess is there is none, but I don't know. I'm not the witness.
Okay, well, let's just make sure we don't move into trying another case other than this one. Thank you. You're welcome to proceed. There was no objection for me to rule upon. Go ahead, sir.
Are you aware of an additional 12 anonymous complaints in that case?
I'm aware there were additional complaints.
You're aware that they were anonymous?
I do not recall that.
Okay. Are you aware of the fact that during the middle of that investigation, the PRC issued Rocky Mountain EMS a letter of compliance?
I was not aware that a letter of compliance had been issued.
Do you know what a letter of compliance is?
I do not.
Okay, why don't you take a look at that second letter that has your signature in Exhibit B, please? If you need a moment to take a look at it, just let me know.
Sorry, give me just a second.
Sure.
Okay, I'm ready to proceed.
Okay. That letter talks about 24/7, 24 hours a day, 7 days a week services, primarily to Northeast New Mexico, correct?
It does.
Okay, and it says limited service availability throughout the state, correct?
It does.
What do you mean by limited service? You mean one time a year, one time a day? What is limited service as you set forth in this letter?
As requested by the facilities throughout the state.
Okay. Have you contacted facilities throughout the state of New Mexico and asked and made them aware that you're available for them to request your services, or will be available?
We did not feel that was advisable without a certificate.
Okay. Have you contacted facilities other than perhaps talking to people at Christus St. Vincent with regard to them requesting your services in northern New Mexico, northeast New Mexico?
We have.
Okay. Who have you talked to? Did you just go and talk to some nurses, or did you talk to the director of operations for these facilities?
I can't speak to that. I was not involved in those conversations.
I'm sorry, could you repeat that?
I can't speak to who was in those conversations.
Were you personally involved in those conversations?
I was not. My partner was.
Okay. Now your letter, let's look at the third paragraph there. Okay, it says that you have current EMS protocol approved by your medical director, correct?
Correct?
Who's your medical director?
Dr. Kurt Casterdale.
Isn't that the same medical director that Rocky Mountain EMS uses?
My understanding is he is no longer employed by Rocky Mountain.
And how do you come to that understanding?
I can't recall exactly how I came to that understanding.
Do you know for a fact that he's no longer employed by Rocky Mountain EMS?
No, but it is my understanding.
Okay. Now, in the second paragraph, you say you own 2 ambulances and that they'll be stocked at the ALS level. So those 2 ambulances are all the ambulances that Helios has right now, correct?
Correct.
And it's the total number of ambulances that Helios would anticipate for the immediate future, correct?
Correct.
Okay. Would I be correct in concluding that Helios is unlikely to add additional ambulances until it becomes profitable?
I don't know.
Okay. You just don't have any idea at all?
I think that was a pretty clear answer, Mr. Padilla, so I think it'll stand with his previous answer. Next question.
Let's look at the 4 other letters that are contained in your Exhibit B. Just take a quick look at all 4 of them, if you would, please.
Okay.
Am I correct in stating that all 4 of those letters come from people who are somehow or other associated with Christus St. Vincent Hospital?
I'm sorry, you would?
Did they all come from somebody at Christus St. Vincent as opposed to a hospital in Taos or somewhere else?
They did.
Okay. Where did these letters come from? How did you come into possession of these letters?
My partner made contact and requested letters.
So you didn't get the letters?
Not me personally, no.
Do you know whether one or all of these people is authorized to speak for Christus St. Vincent?
I do not know.
And none of these letters are signed, correct?
That is incorrect.
Please point me to a signature on any of these letters, sir.
The 3rd letter is signed by Melissa Ortega.
I apologize, you're correct. So 3 out of the 4 are unsigned, correct?
Objection to the documents speak to themselves, and at the proper time, I'd argue that they're what standard has become for electronic signature these days.
They do speak for themselves, and unfortunately, you're correct about electronic signatures, but I do not see electronic signatures. I simply see they speak for themselves, and what they're saying to me is that they are unsigned. I don't see indication that there are electronic signatures. But, you know, I'm going to give them the weight which is appropriate, and, you know, that's the way that's going to go. But that's enough about the signatures, and I believe that was an objection, so I'm going to overrule the objection.
Mr. Prias, you're not presenting either of these 4 letters as affidavits, are you?
That's kind of a legal distinction that laypersons might not understand, the distinction between an affidavit and a letter. So I'd rather you rephrase that question, sir, or educate him as to what you mean by affidavit, as in sworn under oath.
With all due respect, Mr. Hearing Examiner, and I do mean this with all due respect, Mr. Priask is represented by an attorney in this matter. And if Mr. Priask's attorney chooses to object, then the hearing examiner obviously can can rule on that objection, but it appears to me that the hearing examiner is attempting to help the witness.
Well, your observation is noted for the record. If you want to take an exception for it's noted, you can use it as for an appeal. That's your prerogative. I can assure you I have no interest in helping this witness, and certainly no interest in helping any witness regarding Mr. Marks in particular. I do want to move the case forward without delay, and that's for the best interest of all parties, including yourself, Mr. Padilla. I'm sorry you feel that way, but I think when you ask a layperson a question about whether it's the document rises to the level of an affidavit, you need to first know whether or not the layperson understands the distinction between an affidavit and a letter. Okay. So with that, I'll remain silent and allow you to continue your cross-examination respectfully.
Okay, thank you, sir. Mr. Prios, do you understand the distinction between an affidavit and a letter?
I do not.
Okay. Let's move on to your Exhibit E, please. It says driver information. Let me know when you're there, please, Mr. Prios.
I'm there. I appreciate your patience.
No problem. Takes time to do these things. Okay. There's several pages in Exhibit E. The first is just, it says driver's list. That would be you and your partner, Mr. Erskine, correct?
Correct.
Right now, Helios has no other employees whatsoever, correct?
Correct.
Do you have any documents of any nature signed by any employee who says that if Helios is certified, they are coming to work for Helios?
I do not.
Now, if I understand your testimony, your direct testimony, you have had some conversations with people, correct?
We have.
And it's your belief that those people would be inclined to go work for Helios, correct?
Correct.
But you have no absolute commitments at this point, correct?
Correct.
Okay. Let's look at the DOT medical cards. There's two of them, one for you and one for Mr. Erskine. You see those?
I do.
Okay, now I'm just going to direct you to yours for a second because yours is a little more easy for me to read. But do you see on the right-hand side, about a third of the way down, where yours says expiration date? And it says 5/9/2021?
I do.
Okay, look at Mr. Erskine's on the same, it's the same form. Do you see where his expiration date is?
I do.
Okay, it's really hard to read. Would you take a look at that and tell me what you think, what you can see that it says?
Looks like it says 08/06/2020.
Could that be 02/06/2020?
Not on my screen.
Okay, well, regardless whether it says 08/06/2020 or 02/06/2020, that certificate is expired, is it not?
At this time, yes.
Okay. Look at Exhibit F, would you please? You there?
I am. I'm on Exhibit F.
Okay, that's a Form E that is the insurance that Helios has available, correct?
Correct.
Are you aware of how much insurance the PRC requires an ambulance service to carry?
Not off the top of my head at this time.
If I told you that the PRC requires $1.5 million in insurance, would you dispute that?
I would be unable to do so at this time.
Okay. Your insurance is only $1 million, correct?
I believe that is incorrect.
Well, show me where on Form E, it says something other than $1 million, and I would direct you to the bottom of the page where it says 1 million CSL, which I understand to mean combined single limit.
I'm sorry, I appear to have misinterpreted an earlier question.
What an asshole.
Could you explain, please, what you misinterpreted?
I do not, in fact, have a copy of my Form E in my application, as our Form E was submitted electronically to the PRC. My application just has a notice that had occurred.
Oh, so you don't have the application as actually exists in the PRC, is that correct? That was actually filed?
Pardon me, give me a second to confirm. I may be looking at the wrong file. I apologize. It does look like the application I was looking at was the version that I had submitted, but not the version that the PRC had posted.
Okay, do you have a version of the application that shows the Form E?
I'm sorry, I'm currently downloading the version that the PRC had posted. I should have it momentarily.
All right. Let me know when you've got it.
I apologize. I have it now.
Okay. Would you take a look at it, please?
I am looking at it.
Would you agree that it says that the amount of insurance Helios has is $1 million combined single limit?
I believe that is what it says.
Okay. Do you have an independent knowledge of whether or not that's correct?
I believe I apologize. I'm not sure.
Okay. Would you look at Exhibit G, please?
I'm on Exhibit G.
Okay. That exhibit, would you read the first sentence of Exhibit G, please?
Helios EMS LLC requests a temporary variance to the workers' compensation regulation of 18.3.2.13 B9 NMAC in accordance with 18.3.1.10 B NMAC.
Okay, and who's that request being made to?
To the PRC.
Okay, look at page 5 of 12, sir, on the application, the instruction part.
I'm on page 5 of 12.
Okay, look at the instruction for Exhibit G.
I see it.
Okay. Now, would I be correct in stating that that says that you either have to provide a copy of a certificate of workers' compensation insurance or a certificate of exemption from the Workers' Compensation Administration?
It does.
Did you go to the Workers' Compensation Administration and seek a certificate of exemption from the Workers' Compensation Administration?
I did not.
Okay. Having prepared this application and having read the instructions, can you explain to me where you came to the belief that the PRC could grant you a temporary variance?
I was not requesting a variance from the requirement for workers' compensation. I was requesting a variance from the requirement to provide workers' compensation to the PRC.
But my question is, why are you asking the PRC instead of going to the Workers' Compensation Administration like the instruction said you should do?
I'm going to object on relevance. There's a workers' comp law that's on the books, and it does not require a company with 2 employees to have workers' comp. So this is a legal question. It's not something that's going to be determined by this witness's testimony.
Mr. Hearing Examiner, my point is that in many respects, this application is incomplete or doesn't meet the requirements of the PRC. I'm simply trying to establish that this particular witness who is representing Helios did not follow the instructions. If I've made that point, then I'll move on.
Mr. Padilla, I was just about to say that, as you artfully indicated. Yeah, exactly. Just not from this particular question, but from your line of questioning, the previous questions, that was pretty clear that that was your intention. And yeah, you've made your point. You can move on.
Thank you.
The objection, however, needs to be ruled upon, overruled. Please move on, Mr. Padilla.
Mr. Prios, Helios is requesting statewide authority, correct?
Correct.
Okay. And can you explain to me the reason why Helios wants statewide authority other than it provides them with a broader area to serve?
I'm not sure there is any reason beyond that.
Okay.
I apologize. My finger slipped off my mic there.
No,
May
that's
I
fine. I
continue
heard
to
you.
answer?
I heard you. Thank you. Can Helios provide statewide coverage with only 2 ambulances?
Yes.
On an adequate and continuous basis?
We believe so.
Are you aware of the definition of adequate and continuous basis as contained in the Motor Carrier Act and the rules and regulations of the PRC?
I could not quote the chapter and verse, no.
Are you generally aware?
I am.
What is your understanding, your general awareness of what adequate and continuous service means?
It is able to provide service when taking into consideration other services available to the region.
Okay. Now, you said other services available to the region. There are many, many other ambulance services in the state of New Mexico, correct?
Correct.
Not only privately owned ambulance services, but many communities in New Mexico have city-owned ambulance services or county-owned ambulance services, correct?
Correct.
Okay. When you talk about Northeast New Mexico, you talk about, for example, Taos, New Mexico. Do you know how many ambulance services there are in Taos, New Mexico?
I believe I do.
How many?
1.
And would that be a municipal ambulance service or a private ambulance service?
I believe it's privately owned.
Is that adequately providing service in Taos, New Mexico?
I believe they provide reasonable and continuous coverage.
Okay. You talked about Raton. How many ambulance services does Raton have?
I'm not sure.
Okay. What about, you're talking about Rio Arriba County, which would essentially be Espanola. How many ambulance services does Espanola have?
I believe 2.
Okay, and what would those be?
Espanola Fire Department and Espanola Valley EMS.
Is Espanola Valley EMS associated with the Presbyterian Hospital in Espanola?
I believe it is.
It's an entity that is owned by Presbyterian, just like Albuquerque Ambulance Service, correct?
I believe so.
Okay. Are those services providing adequate care, continuous and adequate service in Rio Arriba County?
I believe they are.
Okay. What counties other than Santa Fe County are not receiving continuous and adequate service from the existing ambulance services in those counties?
I believe that many of those counties aren't in fact receiving complete coverage. They are merely receiving reasonable coverage.
Okay, what do you mean by complete coverage? You mean 100%?
Correct, that they are able to take every call as it comes in for an interfacility transport.
Okay, but you do agree, and you've said previously that there is continuous and adequate service being provided, correct?
I said that the carriers were providing continuous and adequate service, not that continuous and adequate service was being provided.
Okay. if Helios were to be granted certification in this matter, how long would it take Helios to hire the employees and do the things that are necessary to be ready to roll and be operating at full capacity?
We believe we can make that happen within 30 days.
Is that a belief, or do you have some facts to back that up?
That is my estimate based on my knowledge of the business and my knowledge of the EMS world.
Okay. What happens if it takes more than 30 days?
I'm not sure.
Could you amplify that a little bit, please? What do you mean by you're not sure?
I mean, I don't know what steps would be required if it took more than 30 days. It would depend on the circumstances that required more than 30 days.
Okay. I want you to look at, if you would please, Helios says this is discovery. And this is Helios's responses to Superior's first request for production. Can you find those?
Allow me just a moment, please.
Sure.
I'm sorry, I'm not seeing those in the docket, but if you allow me a minute, I can pull them up from elsewhere.
Sure.
Mr. Prescott, they're on that thumb drive I gave you a while back under Discovery.
10-4, thank you, sir. Okay, I have it here, thank you.
Okay. Did you provide those answers, Mr. Prescott?
I did.
Okay. And did you provide the documentation that was provided in response to request for production?
I did.
Okay. Now, the only two employees as of right now are yourself and Mr. Erskine, correct?
Correct.
And if, for example, on day one, you have been unable to hire anybody besides the two of you, will the two of you be the ones operating the ambulance service?
We would certainly be involved, yes.
If there's a call on day one and the only two people available are you and Mr. Erskine, would you and Mr. Erskine respond to that call?
In the eventuality we had no other employees, likely.
Okay, and if you can't get any employees for a week or 2 weeks, would it just be you and Mr. Erskine responding to all the calls?
Likely.
Okay. Now, would you look, please, with regard to the documentation that you provided? There's some documentation that involves the setting up of Helios as an LLC. I think the first document is entitled limited liability company, online articles of organization.
I apologize. Something went wrong with my computer. I'm trying to bring that document back up. I apologize for the delay. I've got it now.
That's all right. If we were in all together in a courtroom, I would just be handing you these things and pointing it out to you. But unfortunately, we're not in that situation right now. Have you found it?
Have.
It's Helios 0014. If that's helpful.
I'm sorry. I've got it. I've had it for a little while now. I apologize. I thought I'd made that clear.
Okay. So you've got the online articles of organization, correct?
Correct.
So those are the articles of organization with which Helios was created, correct?
Correct.
Okay. So look at the second page of that, would you please?
Okay.
You see where it says effective date?
I do.
What date is that?
1/7/2020.
Okay, so that's the day that Helios came into existence, correct?
Correct.
On 1/7/2020, your partner, Mr. Erskine, was still working for Rocky Mountain EMS, was he not?
He was?
Was it disclosed to Rocky Mountain EMS that Mr. Erskine was working on creating a competing entity?
Objection, relevance.
Yeah, please, Mr. Padilla, what's the relevance of that information?
The
How would it
relevance
be helpful
is,
to this
Your Honor,
case?
that it's the belief of Rocky Mountain EMS that Mr. Erskine was obtaining data from Rocky Mountain EMS up until the very end in order for Mr. Priosk to make these projections that he's making. And there are emails that have been provided to me in discovery, which are emails between Mr. Erskine and Mr. Priosk, where they're discussing intentionally hiding this fact from Mr. Little, who owns Rocky Mountain EMS, presumably to take advantage of Rocky Mountain EMS.
And I can see where that would certainly be relevant for a different type of case. This is a regulatory application for essentially a license, a certificate, and it's not a misconduct of employees or fiduciary responsibility of employees to their employer type of action, and it's just it seems less than relevant. So
I understand that. I'm
yeah.
sorry.
Yeah, and you understand it. I get your point. So I'd ask you to move on to a different line of questioning, please.
What I'm getting to is that the statute clearly requires that Helios provide information showing that it's not damaging, or that it's considered not doing damage to a certified entity in the area where they're going to be operated. And my point is that I should be entitled to ask these questions to demonstrate that Helios, in fact, is basing the entirety of their operation on the presumption that Rocky Mountain EMS is going to go out of business and Helios is going to pick up that business.
Well, I think that message was made clear through the filed testimony of your witness, which will likely be admitted. And I don't have any doubt that that's your client's position. I don't think you need to prove that is your client's position any further.
All right. Mr. Priosk, look at the purpose line. It's under the effective date. You see that?
I do.
What's it say?
I have non-emergency interfacility ambulance transportation throughout the state of New Mexico.
Okay, so it says non-emergency, correct?
Correct.
That doesn't even anticipate providing emergency as a backup pursuant to mutual aid agreements, does it?
That is not our purpose.
Okay. Look at the next document. It says Helios EMS LLC at the top, and then it says this operating agreement in the first paragraph. You there?
Pardon me, give me just a moment.
Sure. It's Helios 0017.
You're muted, Mr.
I've got it.
Okay. Is that document, which looks like it goes through Helios 022, is that the operating agreement for Helios?
It is.
Okay. Look at page 0021, if you would, please.
There.
Look at number 32. Read me the first sentence of 32, would you please?
Both of the members have other jobs outside the company, as stated in section 4 above, and are expected to spend most of their working time for their outside employment.
Do you have a job other than Helios, sir?
I do not.
Does Mr. Erskine have a job other than Helios?
He does not.
Why is this there then?
Objection relevance. Objection relevance. The contract between the partners is not relevant to their the service they propose to that the company is proposing to be certificated for.
Well, we tend to agree, but cross-examination can also be for veracity purposes. And I'd like to know the difference in circumstances when that document was presented and prepared and executed by the parties compared to any points relevant in this case, if for no other reasons, just for the veracity, which also lends credence or the lack thereof to other documents prepared by the parties. So I'm going to let it in and overrule the objection.
Now I would add, Mr. Hearing Examiner, for the record, that if that statement is in fact true, then these two individuals would not be able to operate on a continuous and adequate basis if they have full-time employment otherwise.
Mr. Padilla, if you could save that for legal argument, I would appreciate it. And you might want to write a note because I'm not sure I'll remember. Please bring that up during your legal argument rather than through the cross-examination. Thank you so much.
Okay. Mr. Prios, the hearing examiner has indicated that he'd like to know about the change in circumstances from the time that this operating agreement was entered into to your testimony here. Could you please fill us in?
There have been no change in circumstances. However, this operating agreement was prepared by me by altering an existing template, and I made an error by leaving that item in.
Have you not been employed at all since you left the employ of Rocky Mountain EMS in 2017?
I have been.
I'm sorry, I didn't.
I have been employed.
When was the last time you were employed, sir?
In October of 2019.
Okay. Has your partner, Mr. Erskine, been employed since he left the employ of Rocky Mountain EMS?
Not to my knowledge.
Mr. Hearing Examiner?
Yes, sir, Mr. Maurer.
I hate to say this because of my age, can we take like a 5-minute break to use the restroom? We've been going for almost 2 hours.
It seems like a great idea. How about we do that? We'll take a 5 minutes. I have 2:51, so we'll be back at 2:56. I'm not even going to turn anything off. We can just all step away for 5 minutes. Great
Thank
idea.
you very much.
And I bet you I'm older than you, Mr. Maurer. Mr. Maurer, you've been unmuted through most of this time. Every once in a while I hear noise and I can only presume it's coming, well, I don't know where it's coming from. But if you don't mind remaining muted unless you're speaking, I would appreciate it. Thank you. Okay. And Mr. Badie, I'd like to apologize for you for not consulting while you were in the middle of your cross-examination. It seemed like kind of a quiet time and a bit of a lull, and we were both, you were researching, and Mr. Maurer had a great idea. And I was not watching the time as closely as I should have. Didn't realize that 2 hours had passed without a break. So with that apology, I'd ask you to please continue.
Not a problem. Thank you. Mr. Priosk, you had quite a bit of discussion with Mr. Maurer about your projections, and I don't want to get into the specifics of your projection, but those projections indicate anticipated business you talked with Mr. Maurer about $20,000-$25,000 per month range, correct?
That is not what we were talking about, no.
So you don't anticipate, your projections don't anticipate income of $20,000 to $25,000 a month for Helios?
He was looking specifically at the Medicare pickups, not the overall income.
Okay, so tell me about the overall income. What do you project as a monthly overall income for Helios once it gets going?
We're anticipating a gross of approximately $77,000 a month.
How many runs per day does that translate to?
Approximately 6 per day.
Is all of that going to come from Santa Fe?
No.
Where's it going to come from?
Northern New Mexico, as well as throughout the state.
Do you anticipate that are you anticipating an increased need at this point in time due to the COVID situation, or do you think that there's just an increased need in general?
We believe there has existed an increased unmet need throughout the state, and we are also apologies. We are also expecting an increased need due to the COVID situation.
Are there any areas of the state where the increased need is more significant than others?
The increased need due to the COVID situation, I believe, is largely affecting western New Mexico.
Okay. Well, I don't know if you read the same newspaper I do, but I see a lot of cases down in the south, like down in Las Cruces. Would you agree?
I don't have current information on that.
Do you have plans to assist with regard to the increased need in Las Cruces with these 2 ambulances that you have?
We have plans to assist wherever our assistance is needed.
With 2 ambulances, if you're running pretty much back-to-back full time, how many runs per day can you do with 2 ambulances?
That would depend on the runs involved.
If they're long distance runs, let's say, for example, a run to Las Cruces, how long would that take? How many hours?
To Las Cruces from where? I apologize, I shouldn't say that.
From Santa Fe, where you would be stationed.
From Santa Fe to Las Cruces would take between 4 and 5 hours one way.
Okay, and then when you pick the patient up, let's say you're going down and picking up the patient in Las Cruces, and let's say you're taking that patient to UNM in Albuquerque, you got another couple hours for that one, correct?
Roughly, yes.
And then when you get to the hospital, you don't just drop the patient off and walk away, do you?
We do not.
You go in and you have certain administrative functions that you have to perform and certain functions with regard to turning the patient over from your care to the care of a physician, correct?
Hello?
Oh, is that Ann?
I guess, I don't know.
Yes.
Okay.
Can you hear
Sorry,
me?
sorry, Ann, you kind of interrupted Mr. Padilla's question there. So thank you. Glad you're online. Sorry, Mr. Padilla, please continue.
So how long typically does it take when you transport a patient, when you're dropping off a patient and you have to perform these functions of turning them over to the doctor, filling the doctor in on what the doctor needs to know, or a nurse or whoever's receiving the patient, and then going and doing the paperwork that you need to do?
I would generally anticipate that to take between 15 and 30 minutes.
Okay. So if you go to Las Cruces and you got 4 hours down, 3 hours back, and another 15 to 30 minutes, that's 7.5 hours, right?
Roughly.
Okay. I think I saw somewhere in your, it was either in discovery or in testimony, that you intend to limit the number of hours that the EMTs and paramedics are working so that they're manageable, correct?
As is required.
Okay. You can't work somebody 24 hours a day, right?
We cannot.
How many hours a day do you anticipate that the employees of Helios would be working?
We have a nominal shift length of 12 hours.
Okay. So if you had a run to Las Cruces, for example, that would take up the vast majority of that shift time, correct?
The majority.
And how likely is it, if you've used up a majority of that time, that particular ambulance is going to be available during that shift to do 1, 2, or more runs, additional runs?
That would depend on the runs.
Have you taken all these factors into consideration in making your projections?
We have.
How many runs do you anticipate from Las Cruces?
Relatively few.
Could you be more specific? 1 a day, 1 a week, 1 a month?
We're anticipating 1 to 2 a week.
Okay, how many from grants?
I do not believe we have a specific breakdown for that.
How about Gallup?
I do not believe we have a specific breakdown for that.
How about Lordsburg?
I do not believe we have a specific breakdown for that.
How about Roswell?
I believe we're anticipating less than 1 a week.
Okay. I don't want to go through every city. Tell me, please, what cities do you have specific breakdowns for that you anticipate you're going to be doing this work, transporting patients? I can't hear you, sir.
I apologize. I was in the wrong window when I pressed space bar to unmute myself.
Okay.
We have
I'll ask you to repeat yourself then.
We have a rough breakdown for the length of transport rather than for specific cities. However, we have considered specific cities.
And when you say length of transport, are you anticipating that the majority or more of your transports are going to be lengthy transports?
We're expecting the majority of our transports to be 60 miles or less.
Round trip?
Let me clarify. Approximately 60 miles, and as well as shorter distance transports as needed.
And when you say 60 miles, are you talking round trip?
No, sir, I apologize. One way.
Okay. So for example, from Santa Fe to Albuquerque?
Or Las Vegas to Santa Fe, yes.
Okay. You're familiar with Albuquerque Ambulance, are you not?
I am aware that they exist.
You aware of the fact that they have in excess of 60 ambulances?
I am aware that that has been claimed.
Are you aware of the fact that their business exceeds $20 million per year?
I was not aware of that fact.
Okay. They are authorized to station vehicles in Santa Fe, New Mexico, correct?
I believe they are.
And they're authorized statewide for transportation purposes, correct?
I believe they are.
Why would you dispute that if there's an increase in need, that Albuquerque Ambulance can pick it up with one or more of their 60 ambulances?
I do not believe that they have that stretch capability.
And what facts do you have to support that belief, sir?
It is my understanding that they have had difficulty in meeting their current obligation.
What about Superior Ambulance? Can they provide additional coverage, to your knowledge?
I do not know if they can, but I do not believe that they have been.
You mean you believe they have not been? Or you don't believe it?
I believe they have not.
Thank you, sir.
Sorry about that. I was running over my laptop cord.
Okay. In Helios's, or I'm sorry, in your rebuttal testimony, would you go to that, please?
Allow me just a moment.
Sure.
I've got it.
Okay. Go to exhibit NPR 01. MP-R-01.
I apologize. I appear to have pulled up a version that didn't include our exhibits. Allow me a moment.
Okay.
I have it.
Okay. That's the affidavit of, it says affidavit of Christus St. Vincent, and it's signed by Lillian Montoya and notarized, correct?
Correct.
That was not obtained by Helios, was it?
It was not.
That doesn't have anything to do with Christus St. Vincent supporting Helios with regard to Helios doing transporting patients from Christus St. Vincent, does it?
It does not.
Are you relying on this affidavit by having attached it to your rebuttal testimony?
Objection, form of question. It's just not clear what he means by relying.
Well, if it doesn't pertain to Helios, Mr. Hearing Examiner, I'm trying to understand why it's attached. And it looks like we lost Mr. Marks, who was making the objection.
Yeah, well, there he is.
There he is. No, he's on again.
Mr. Marks, can you hear us?
I can hear you. Yeah, for some reason my video thinks that I'm wanting to shut it off. Just maybe I'm too ugly, I guess.
It's the mask. Cannot hear you.
The document speaks for itself. It's evidence. It attests to the need. Obviously, it's in support of AMR's application, and we've acknowledged that. We're acknowledging that. And Mr. Priestkopf's rebuttal testimony addresses why it's in there and why,
Okay, I hear you. Mr. Padilla, I note that, I've read this a few times, and I was struck by it, and I was struck that it refers to a different case, frankly. And then that was tempered by seeing that the therefore clause, if you will. And the therefore clause is the important clause. And the therefore clause stated, therefore there is currently an urgent and immediate need for transport services. And it could be left there, but it was transport services to supplement Rocky Mountain EMS. And I read it as the therefore clause redeemed the document, and therefore it was relevant. And I believe that's why it should be left in. But I'm not going to put words in the mouth of Mr. Priestkopf. I think by including it with his testimony and referring to it, he is relying upon it, using that terminology, relying upon in the broadest sense, as if it's relevant to his case.
All right, Mr. Prios, do you accept?
Wait a minute. Can I make a point here, Mr. Hearing Officer? He just stated in testimony it does not support their application. So I would question its any weight being given to it.
He says nothing to do with it, and he said it does not. That I wrote down the quoted with quotes the question and the answer, and I read it. This is cross-examination. I hear what's being said. I could have a poker face and not disclose my reading of it, but I have the document in my hand, and that's how I'm interpreting that part of the document. You can continue with the cross-examination. Apologies to Mr. Maurer.
Mr. Prios, do you accept this affidavit as being accurate?
I believe it to be so.
Okay. Now the affidavit is dated November 7th of 2019, correct? Second page.
That would appear to be correct.
Okay, so it's almost a year old, correct?
That would appear to be correct.
And it states in part in paragraph 6, while we are confident that Rocky Mountain will quickly come back into compliance with regulation, we remain vulnerable without a backup service for our patients, correct?
That is correct.
Do you have any facts to support or to oppose this conclusion of confidence that Rocky Mountain would come back into compliance?
I do not. However, I do have my opinion, which I believe to be a relatively expert one as both a former employee and as someone who has read the current complaints against Rocky, that this is a devolving situation.
I understand that, sir. Mr. Prios, if I understood your testimony in Mr. Maurer's cross-examination, you said that you and Mr. Erskine had contributed approximately $4,000 towards the equipment, plus $20,000 towards purchase of 2 ambulances, correct?
Approximately.
So, and did I understand correctly that it's roughly 2,000 from you and 2,000 from Mr. Erskine as far as the equipment is concerned?
I don't have those figures directly available.
Okay. Do you think it's roughly equal, or did you provide more, or he provided more?
I believe he's provided more.
Will $4,000 fully stock 2 ambulances? And I'm talking about gurneys, oxygen, 2-way radios, everything that goes into those ambulances.
$4,000 by itself would not. However, we also contributed equipment that we had accumulated over the years.
Were those big ticket items that you accumulated over the years?
Some.
Where did they come from? If you were working for somebody else, why would you be accumulating big ticket items?
Because we're both paramedics and kind of pack rats.
So where'd they come from? Did any of that equipment come from Rocky Mountain EMS? For example, Rocky Mountain EMS perhaps discarded some of it and you ended up with it, or Mr. Erskine ended up with it?
None that I'm aware of.
I'm sorry, there were 2 people talking, so I didn't hear.
Objection on relevance that I'm expecting the witness is not going to testify that he took stuff from Rocky Mountain. I'm not trying to protect that. I'm thinking this is not a relevant area of inquiry as to where this equipment came from specifically, if they have it.
Sustained. Can we move on, please?
Do I understand correctly, Mr. Prios, that if one of your ambulances breaks down, you don't have a backup?
Not at this time.
Okay. So if an ambulance were to break down on day 1, you'd be limited to 1 ambulance, correct?
Until such time as repairs had been effected.
And if it was a major breakdown, let's say it was a blown engine, you got unlucky. So it would take not only time to fix it, but expense to fix it. Is Helios in a position to operate during that time period in the manner that's projected?
We believe we could meet that need.
Do you have any facts to support that?
We believe that should that occur, we could either, if the time frame for repair was too lengthy, we could obtain another ambulance.
Yeah, I understand you believe it. I'm asking you if you have any facts to support it.
Mr. Padilla, that's a term of the way Mr. Preiskop speaks. I've heard him say, I believe and we believe many times. And I think that's just more of rather than literal believing, rather than knowing. It's just the way he expresses himself. That's the way I've been reading his testimony. So when he says we believe, that's just the way he talks. That's the way I understand him.
Okay. So when you say you believe, Mr. Priosk, is that belief based upon independent fact?
I was about to say we believe again. It is based upon the monetary options that are available to us.
I'm sorry, I didn't catch it. Based upon the monetary options that are available, is that what you said?
Correct.
What does that mean?
That would reference borrowing opportunities for myself and my partner, both commercial and private.
Okay. You stated in response to AMR's discovery that you thought the cost of medical supplies would be minimal and you estimated them to be $75 per month. Do you recollect that?
I do.
What nature of supplies can you buy for 2 ambulances that are only going to cost $75 per month and still meet the projections that you're making?
Those supplies were estimated based on the expiring stock as well as the minimal stock that's used during interfacility transportation.
What are we talking about there? Are we just talking about Band-Aids and face masks, or are we talking about something more significant like replacing oxygen tanks?
I did, in fact, forget to include oxygen tanks into the overall thing. I believe that $75 would be a little low in that regard.
In response to interrogatory number 15, which Rocky Mountain sent to you, you stated that you do not, or Helios does not expect to fully serve all interfacility needs in Santa Fe, Rio Arriba, Los Alamos, and Taos counties with only 2 ambulances. Would that be correct?
I believe that's correct.
So if you can't fully serve them, then who's going to serve the ones that the existing entities can't serve and that would still be there?
We are there to serve.
I'm sorry, I interrupted you.
We would be there to serve the ones that the existing services can't.
I'll pass the witness. Did I not get heard?
I believe Mr. Lennon is muted.
Oh.
Mr. Padilla, you're finished with your cross-examination?
I said I pass the witness, but I don't think anybody heard me.
Okay, I did hear you. I'm sorry. And you're right, Mr. Prescott. Thanks for keeping track. I was muted there. We can move to Mr. Bartel. If you just hold on for 1 second, I need to step away from my desk. 1 second. and thank you all for that indulgence. Mr. Bartel, do you choose to cross-examine at this point?
I do. Thank
All
you.
right. Well, thank you. That sounds positive. Rather than, we don't really need a break. We just took one not too long ago. So let's continue right into Mr. Bartel's cross-examination. Mr. Pryskop.
So, Mr. Prescott, my understanding of the Helios application is that it really breaks down into two parts. One is a focus on Santa Fe County, and the other is a focus on the rest of the state. Do you agree with that?
I believe that's probably correct.
Now, you're aware, are you not, that pursuant to the Motor Carrier Act, it is Helios's burden to show that there is an unmet need in every area in which you seek to be authorized to provide service.
That is my understanding.
Okay, so let's just focus for a moment on the state other than parts of the state other than Santa Fe County. You would agree with me that you've brought no independently verifiable facts to the attention of the commission in this proceeding that there is any need that's being unmet in Rio Riva County.
Objection, form of question, specifically independently verifiable facts is not meaningful to the witness.
I'm sorry. I was trying to define exactly what it was that I wanted him to respond to.
Mr. Lennon, you muted.
Thank you, Mr. Marks. I didn't understand the question completely, and I did not understand the objection completely. So with that admission, I'd like Mr. Bartel to perhaps break down the question into smaller chunks and feed it to Mr. Prescott for answers, please.
All right. Mr. Prescott, focusing on Rio Riva County, you would agree that you've brought no independently verifiable facts to the attention of the commission in this proceeding that show that there is an existing unmet public need for additional ambulance service in that county. Isn't that right?
Objection, form of question. The term of art, independently verifiable facts, we've already established that Mr. Prescott is not going to understand that, and I respectfully request that Mr. Bartel ask him about his knowledge or what his testimony is based upon.
Would you care to argue that motion, Mr. Bartel?
Well, first of all, it has not been established that Mr. Prescott does not understand that standard English phrase, A. B, I'm not interested in his knowledge, quote unquote. What I'm interested in is what has been brought to the attention of the commission in the record of this proceeding.
Well, that's what I understood.
What my question is directed at.
I think I understood the question, and the question sounds like the ultimate issue to be decided in this entire proceeding, or at least one of the ultimate sub-issues, if you will. So I'd rather him testify. I understand cross-examination is uniquely cross-examination, and however, I'd ask you to rephrase the question respectfully, with all respect. It sounded to me like you were asking him to make a legal determination, and I don't think he's in a position to make a legal determination. Therefore, I don't think it's an appropriate question. So I'm going to sustain the objection with respect and ask you to please ask another question. Thank you, sir.
All right, Mr. Prescott, you, in the course of this application proceeding, Helios has not brought a witness representing a facility located in Rio Riva County to prove that there is a need for additional scheduled transport service, have you?
We were unable to locate a facility who was willing to involve themselves in this particular fight between ambulance services. That is correct.
And you have brought no records of any complaints filed with the commission by a facility located in Arriba County, suggesting that the need for interfacility transport is not being adequately addressed by any of the ambulance services who are authorized to operate in Arriba County, have you?
That is correct.
And you've brought no records to the attention of the commission of any calls being made for interfacility transport service originating in a facility located in Arriba County, which were not accepted and performed, have you?
We did not.
Turning to Bernalillo County, you would agree that you've brought no witness, identified no witness, and have subpoenaed no witness representing a facility located in Bernalillo County to address the question of whether or not their needs for interfacility transport are being adequately met, have you?
We have not.
And you've brought no evidence of any complaints filed by a facility located in Bernalillo County that have been filed with the commission, suggesting that the facility's need for interfacility transport service is not being adequately met, have you?
We have not.
And you have no documentary evidence in the record that would show that any calls for interfacility transport made by a facility located in Bernalillo County have not been answered. Isn't that right?
That is.
Turning to Sandoval County. You've not...
Mr. Lennon, Mr. Bartel, Helios is willing to stipulate that its direct case does not include testimony from healthcare facilities, does not include filed complaints at the PRC, and does not include documentary evidence of the type that you're stating.
Thank you. Would that stipulation satisfy your inquiry, Mr. Bartel?
Well, I would like to know whether that stipulation includes a withdrawal of an application for authority in Arriba, Bernalillo, and Sandoval counties.
Well, I don't think he said that.
That's what I'm asking.
He's just stipulated that you're questioning, elicits the response that no such evidence for each of those counties has been presented in this case, and he's stipulating that the answer is going to always be no, and it's as simple as that. And we can cut short the testimony if you were going to continue for each county and each whether it was presentations to the commission or any other evidence. So just trying to move things forward. But I can't do the stipulations. It's an offer of a stipulation, and I believe it's relevant and it's reasonable. And Mr. Bartel, it's up to you whether you want to so stipulate.
Well, I will agree to stipulate that there is no evidence on these questions as to the counties that I have examined him about,
okay,
or any other county for that matter.
Is that sufficient, Mr. Marks? Any other county? How about Santa Fe County?
Mr. Lennon,
Yes, sir.
I mean, the evidence speaks for itself. I'm stipulating that we don't have witness testimony from healthcare facilities. We did not file documentary evidence showing calls not being met. And when we get further in the case, I can explain partly why we didn't do it. And why Mr. Bartel's client prevented us from doing that. And I guess I was under the impression that if we stipulate to some facts, then that should cut off the questioning as cumulative or asked and answered, and we can just go forward with to use our time better.
Yeah, well, thank you, Mr. Marks. So, Mr. Bartel, it seems that the stipulation would negate the need for further inquiry in that line. Would you agree?
Yes, I'll move on. Thank you.
Thank you, sir. Proceed.
Mr. Prescott, let's take a look then at Exhibit MP-R-01 attached to your rebuttal testimony. This is the Lillian Montoya affidavit.
I have it.
Okay. So, as has been previously established, this affidavit was actually obtained by American Medical Response in support of its case. Is it fair for us to assume that you've personally never spoken to Ms. Montoya?
I personally have not,
And from
to my knowledge.
And from your resume, which is attached, as I recall, to your direct testimony, you've never actually worked for Christus St. Vincent Hospital, have you?
I have not.
And you do not know how they go about deciding which scheduled transport provider they're going to call for service, correct?
I believe that is incorrect.
You have never seen any procedure or process or policy from Christus St. Vincent that directs its nurses as to how they will decide which scheduled transport provider to call as they need to arrange scheduled transports, have you?
I've not seen any such policy. However, as somebody who worked in interfacility transport in Santa Fe, on any number of occasions, I've spoken with nurses and discharge planners and ER techs and ER secretaries and unit secretaries as to various things, but included was the subject of how they choose who they call.
But the fact of the matter is you've brought none of that testimony to the commission in this proceeding. Isn't that right?
I believe that is correct. So
in the case of the Montoya affidavit, turning back to that, this affidavit is focused for the most part on Ms. Montoya's observation that Rocky Mountain EMS is becoming unavailable. Would you agree with that?
Objection, the document speaks for itself.
Sustained. I think it does, and I'm not even sure that's an accurate characterization with all respect. It actually states that Rocky Mountain will quickly come back into compliance. So it seems to be contrary to that characterization. So, but it does speak for itself, and I'd ask, and objection sustained.
Well, Mr. Prescott, the observation that appears on page 2 of this affidavit at the end of paragraph 6, which states, quote, therefore there is currently an urgent and immediate need for transport services to supplement Rocky Mountain EMS, end quote, is made without any reference to whether Christus St. Vincent reached out to Albuquerque Ambulance Service. Isn't that right?
Objection, the document speaks for itself.
Sustained. It's you know, the document says what the document says. Mr. Prescott, I'll ask you, does the document state that Christus St. Vincent made any attempts to contact Albuquerque Ambulance? It does not.
Document does not.
Thank you, sir. So there's the answer to the question. Anyhow, I asked the question. Let's move along with that line of questioning, please, Mr. Bartel.
Well, just to make it clear, I mean, I've already, Ms. Maggiore already objected to the admission of this affidavit, but this is exactly the problem that we're facing, is that this is hearsay and we do not have the ability to cross-examine this witness.
And it shall get the weight which is appropriate for hearsay, not subject to cross-examination. If that. I understand completely. You know, in administrative proceedings, I'm constantly running into hearsay testimony. And I figure, you know, that's part of why they pay me, to attach the appropriate weight or lack thereof for hearsay. This document itself is in particularly unusual in that it relates to entirely different set of factual circumstances under, you know, with different players and a different case and a different time period. And it's simply not related to this case directly. It's only related in a tertiary fashion. And I will give it the appropriate weight.
Mr. Brieskop, you do not have any independent knowledge with respect to the circumstances as they existed in November of 2019 when the Montoya affidavit was executed. You don't know whether or not Christus had made any calls for service to Albuquerque Ambulance Service and been denied service, do you?
I have no direct knowledge of that.
Let's take a look at the four letters in the Exhibit B to the application. Do you have those before you? The four letters being the ones from Christus St. Vincent employees.
Allow me just a moment. I have them in front of me.
All right. So the first one that I see in Exhibit B after the two letters that you included from yourself is one that's identified as coming from Rebecca Reinhardt. You see that?
Pardon me, I do.
You would agree that this letter is not dated?
It is not.
And are you aware that Albuquerque Ambulance Service received stationing authority from the commission on March 20, 2019?
I was not aware of the specific date. I was aware that generally you had received, or I'm sorry, AAS had received stationing authority in Santa Fe.
Well, subject to check, I'm going to tell you that that's the date on which they received stationing authority. And you would agree that when we look at this letter, it's not possible to know whether it was written before or after Albuquerque Ambulance Service was given stationing authority in Santa Fe County. Isn't that right?
Objection. Misstates the evidence. He says it's not possible to know. If the question is, does this letter disclose? That would be proper, but he's asking a broader question.
I think I asked the witness to look specifically at this letter and agree that you can't know whether or not it was written before or after stationing authority was given to Albuquerque Ambulance Service.
Mr. Lennon, you're muted again.
Thank you, Mr. Marks. I'm going to respectfully overrule your objection. The reality of cross-examination is it's not pretty. And, you know, I think I allow a particular expanded leeway in the way witnesses are examined. And each attorney has their own style as well. So take that into consideration. And I believe it's Mr. Bartel's style that creates your objections more than anything. So I'm going to allow him to continue with that line of questioning. Please proceed, Mr. Bartel.
So, Mr. Prescott, can you answer the question that I asked?
I disagree that I can't know that that letter post-dated the March 20th that you cited, as I know roughly when that letter was obtained. However, I agree that that letter does not have a date on it, and thus you can't know that.
And neither can the commission. Isn't that right?
I would agree to that.
All right. You also agree that this letter contains no reference specifically to Albuquerque Ambulance Service.
This letter contains no reference to any specific ambulance service that I can see.
All right, let's turn to the next letter in Exhibit B to your application. This one coming from Montesa Valdez. Do you have that?
I do.
And again, this letter is undated, correct?
That would appear to be correct.
And again, we cannot know, based on what's in this letter, whether or not this letter was written before or after Albuquerque Ambulance Service received stationing authority in Santa Fe County, correct?
Again, I'll agree that you can't, however, I can.
And you would also agree that nothing in this letter refers specifically to Albuquerque Ambulance Service, correct?
I will again agree that nothing in this letter specifically refers to any ambulance service.
Take a look at the letter in Exhibit B signed by Melissa Ortega. You have that.
I do.
Again, undated, correct?
Again, correct.
And from what we see in this letter, it's not possible to know whether or not she wrote it before or after Albuquerque Ambulance Service received stationing authority in Santa Fe County. Isn't that right?
I again agree that you cannot, while I can.
And there's nothing in this letter that specifically refers to Albuquerque Ambulance Service, correct?
Again, there's nothing in this letter that specifically refers to any ambulance service.
And then finally, the Daisy Baca letter, again undated, correct?
Correct.
No mention of Albuquerque Ambulance Service in this letter either.
Again, there's no mention of any particular ambulance service.
And you would agree that the complaints that these nurses are raising about there not being adequate service relies on the unestablished predicate fact that they have actually called every authorized provider in Santa Fe County and been denied service. Wouldn't you agree?
I don't believe I would agree to that.
Well, you can't, as a customer, as a sending facility, you cannot legitimately complain that there's no adequate service when you haven't made calls to all of the authorized providers to determine whether or not anybody's available. Wouldn't you agree with that?
I would say rather that it's not a matter of there not being any available service so much as there not being any available service within a reasonable time frame given the acuity of the patient.
But the facility would first need to call and be told that there's no ambulance available within the time frame that they are establishing before they could complain that there's no service available. and that there is a unmet need, in other words. Wouldn't you agree with that?
I would agree with that. However, I would also say that it is a general practice when facilities who are sending patients don't get a response within a reasonable time frame, they keep running down the list until they either do or they take the best time frame that they can get. So I would say that by raising these complaints, there is a general trend that they were not getting responses within a reasonable time frame.
But that's your assumption, which is not supported by any testimony by anybody in Santa Fe County that they've in fact done what you said and been denied service by LPRs. Isn't that right?
That is my testimony as someone who is familiar with the way that interfacility transport works, both nationally and specifically in northern New Mexico and Santa Fe.
Prior to filing this application, did Helios ask Krista St. Vincent to provide any documents relating to their attempts to get interfacility transport service from Albuquerque Ambulance Service?
I know that they asked many employees of Chris St. Vincent for letters such as those included in the application. However, I do not know if any specific requests were made for documents.
Is there any particular reason why Helios didn't subpoena Lillian Montoya to appear at this hearing today?
That would be a question for my counsel.
And would that be also the answer you would give as to why the nurses whose letters were included in Exhibit B weren't subpoenaed to appear at this hearing today?
My understanding.
Objection, privilege, it's work product.
I'm not. Well, the privilege has been waived if that's what your objection is, Mr. Mark.
Okay. I don't think, Mr. Bartel is asking Mr. Prescott to release protected, privileged attorney work product. I don't think that was the basis of the question. I think it was more to send a message to me that if these documents were so substantial, or that certainly the people who executed the documents could have appeared herein at this hearing, and they could have been subpoenaed, but they were not, and thus to reduce the veracity, to use the same word again, or the weight of those particular documents. I think that was Mr. Bartel's point, and that point was understood.
Mr. Lennon, and
yes, sir.
For what it's worth, there are legitimate reasons why a company that's trying to start up in Santa Fe or start up an ambulance company serving hospitals would not want to antagonize its potential customers by compelling them to testify when they did not want to testify. And so I think the commission is taking an improper inference from the fact that we did not subpoena people who did not want to voluntarily appear.
And Mr. Hearing Examiner, this is Fred Maurer. I absolutely disagree with that comment, and it should not be given any weight.
Mr. Mark's comment, is that what you're referring to?
Yes, sir. And the reference and reference that he's trying to make with that comment.
Okay. Continue on, Mr. Bartel.
Mr. Prescott, let's turn to the question of the adequacy of the service in Santa Fe County. looking at your resume, I don't see that you ever worked for Albuquerque Ambulance Service. Is that correct?
That is correct.
So you do not have personal knowledge as to the resources that Albuquerque Ambulance Service has available to it to respond to calls for in-facility transport service, do you?
I do not have personal knowledge. That is correct.
And so when Mr. Casper indicates in his pre-file direct testimony that Albuquerque Ambulance Service has 60 units overall that it could mobilize to respond to increased demand in Santa Fe County, you have no factual basis on which to disagree with that statement, do you?
I have no factual basis to disagree with the quantity of ambulances they have. However, my understanding is that recently AFR had to file for amendment to their certificate to allow them to transport patients in Albuquerque because they were having problems with getting response times from AAS, which indicates to me that AAS probably does not have the stretch capacity to cover additional calls in Santa Fe County.
So do you understand that ultimately AFR was granted transport authority in Bernalillo County?
I understand that they were.
And so now, if there was a problem in city of Albuquerque and Bernalillo County, the fact that Albuquerque Fire Department can transport and charge for it, I mean, that's the point of that authority, would mean that whatever conditions pre-existed Albuquerque Fire Department's application have changed. Isn't that right?
I couldn't speak to that. I have no direct personal knowledge.
Well, you're speaking from what you're seeing in the records of the commission, I take it. Is that right?
I am.
So you would agree that if the entire Albuquerque Fire Department fleet is now able to transport and charge for it, that the resources available in Bernalillo County have been greatly increased. Isn't that right?
If I were going to speculate on that, I would have to also speculate on the increased demands of the COVID pandemic.
The fact of the matter is, as we sit here today, you have no knowledge as to whether or not Albuquerque Ambulance Service has the ability to increase its response capacity in Santa Fe County should Rocky Mountain EMS lose its operating authority, do you?
I have no direct personal knowledge of that, no.
All right, I'll pass the witness.
Thank you, Mr. Bartel. And that leaves Mr. Borman, but also leaves Ann Maggiore. Ms. Maggiore, are you online? Can you hear us? And we are not hearing you, so please unmute yourself.
Can you hear me on the phone?
Yes, ma'am. We can hear you, but there's an
Completely
echo.
off on the computer.
We hear you, but there's an echo. Now we don't hear you.
Mr. Lennon,
Yes,
as
sir.
a young man, can I request 5?
Well, I think a young man can request just as much as an older gentleman like me. Let's see what time it is. It's 4 o'clock now. I was planning on 4:30 starting to discuss what procedural things and when we're going to regroup for this meeting. So we don't have that much time, but I think 5 minutes is reasonable. Let's all take 5 minutes. It's 4 o'clock. We'll be back at 4:05. Thank you.
Thank you,
5
sir.
minutes. Be right back. Ms. Maggiore, if you could please do a little work on your machine there and see if you can get it up and running, it'd be great. Appreciate it.
Mr. Hearing Examiner.
Hello,
Hi, Mr. Hearing Examiner.
Chief Graham, is that you?
Yes, sir. I spoke with Ann Maggiore.
Mhm.
She's requesting that if there's on your side, if you can unmute that 505-504-339 number.
Thank you. Hold on just a second.
And then she will just speak through the phone.
Well, I thought we had already worked that out. I have to ask her to unmute. I don't have, she's muted herself, actually. I mean, I have that number on my list of participants. I have something I can click where I can ask her to unmute, and she has it muted.
Have her try *6.
Yeah, try that.
Mr. Hearing Examiner, this is Jason. If she pushes *6, it should unmute her phone.
Thank you, Jason.
I just sent that to her via message.
Thank you, and thank you for helping. How are you?
I'm good. Thank you.
We met in another proceeding, didn't we?
We did, sir, yes.
Okay. You need not record any of this small talk, Miss Hoyman, and that's all it is.
You can tell me when you want to go back on the record.
Thank you so much.
You know, one other thing she may try, especially if she's using Windows 10, it tends not to let go of prior programs and close them out properly. So one thing, and I do it every time I have a Zoom, I start off with a fresh boot. So she might try rebooting. It might free up some resources on her computer, if she can hear me.
And if not, Mr. Grant, Officer Chief Graham, if you could tell her that, that'd be great. Because otherwise, we're going to have to continue this cross-examination the next time we meet, and I think there is going to be a next time. And
She just responded with, I'm on the phone and unmuted, so can you hear us? I don't see her.
I do not see her either. And I don't see her phone number either in my Oh, there's somebody in the waiting room. Let's see. Let's see here, but it's nobody. Oh, there she is. Okay, I just admitted her from the waiting room. Now can you hear us? Ann? Well, if she can hear us, she's not able to tell us she can hear us. Well, Chief Graham, when we reconvene for the continuation of the other witnesses in this case, and I presume it's going to be another day, may I respectfully suggest that you invite your counsel to your office, perhaps, and maybe she could work from your office.
Can you hear me now, sir?
Yes.
Okay.
You sound clear as a bell. Where you been?
I've been right here. I think there's a problem that it has to be unmuted on your end because we're good to go now.
Well, for one thing, I didn't do anything, so apparently that's not the case. And secondly, I do not have, the only thing I can do here is ask you to unmute yourself. But
okay, well, we're good now.
Whatever you did is great. Shall we, lest we be cut off again, do your testimony? Are you ready? Your cross-examination? Are you ready?
I am ready, sir.
Go for it. Mr. Priskop, Ms. Majori's got questions for you.
Sir, Mr. Priskop, can you hear me?
I can indeed.
All right, and I'll try to give a little pause because it seems like we have a little bit of a lag. Mr. Priskop, you spent 5 years with Rocky Mountain EMS as the Deputy Director of Operations from September of 2012 through July of 2017. Is that correct?
That is not quite correct. I was employed by Rocky Mountain in that time frame. However, I did not accumulate the title Deputy Director of Operations until later.
Okay, I didn't hear just the last of it. When did you become Deputy Director of Operations?
Late 2015.
All right, so your entire experience in the management side of EMS was a little over 2 years, is that correct?
I would argue that I was involved in management before then, however, not as Deputy Director of Operations, but I would argue that both pharmacy operations and compliance operations are managerial duties.
All right, so during your tenure at Rocky Mountain, you were a compliance officer, is that correct?
Again, not during my complete tenure, but for more of my tenure than I was the Deputy Director of Operations.
So you were compliance for about 2 years?
Or I apologize, I was assistant compliance almost the entire time, but I was the compliance officer for roughly the same time frame as I was deputy director of operations.
Right. You were also a pharmacy officer, is that right?
That is correct.
Narcotics officer,
That is correct.
IT officer,
That is correct.
and a field training officer, is that right?
That is.
Now, you held at least some of these positions during times when Rocky Mountain was being investigated by the PRC for various complaints. Is that not true?
I do not believe that is true.
Okay, so it's your testimony that during your tenure in management at Rocky Mountain, there were no investigations by the PRC for any complaints that arose.
Allow me to clarify slightly. I believe that as I became assistant compliance officer, which was immediately prior to the first PRC inspection that took place during my time at Rocky Mountain AMS, that was the inspection that closed out an investigation by the PRC.
All right, now you worked with Rich Erskine the entire time you were at Rocky Mountain, right?
Correct.
And he's now your partner in Helios EMS, correct?
Correct.
And I believe you've testified in your direct testimony that you found that you and Mr. Erskine had similar work styles. Is that right?
I believe the quote was more along the lines of similar ideas of how an interfacility operation should be run.
Okay, even better. Similar ideas about how an operation should be run. Is that better?
It's a paraphrase, but I believe it's pretty close.
All right. Now, certainly during Mr. Erskine's tenure at Rocky Mountain EMS, there were a number of investigations, complaints, and violations. Is that correct?
That is correct.
Including, but not limited to, one fairly spectacular ambulance accident in 2010 that severely injured a 19-year-old EMT. Is that correct?
That was before my time, but I am aware of it, yes.
And you're aware that that happened on Mr. Erskine's watch, correct?
It occurred while Mr. Erskine was the deputy director of operation. However, it occurred because Mr. Erskine could not overcome the reticence of Mr. Little to spend money to maintain his ambulances.
But Mr. Erskine was responsible for compliance at that period of time, wasn't he?
I'm not sure who was the compliance officer at that time.
And Mr. Erskine, interestingly enough, is not here for this hearing today, correct?
He was here earlier. I don't know why he's not here now.
But he didn't provide any pre-file testimony?
That is correct.
Now, according to Mr. Smith's pre-file testimony, you know who Mr. Smith is, correct?
I've never met him personally, but I am aware generally of who he is.
All right, on page 3, lines 20 to 21 of his pre-file testimony, he indicates that Mr. Erskine was terminated from Rocky Mountain in January of 2020 for failing to properly supervise day-to-day operations. Do you dispute that?
I dispute the characterization of it.
What do you mean by the characterization of it?
I don't dispute that he was officially terminated. However, I do not believe that the characterization that it was for inability to, I'm sorry, I don't have his testimony in front of me. I don't recall the direct quote. Allow me just a moment to pull that up, please.
Sure. Page 3, lines 20 to 21.
Okay, I see. I have the quote in front of me here. I apologize for that.
All right. So did I mischaracterize it in any way?
You did not mischaracterize the quote from Mr. Smith.
Right now, while you were pharmacy officer, there were some problems with the pharmacy regulations. Isn't that true?
When I took them over, yes, there were. However, after I had worked with it for a while, I brought us back into full compliance.
What problems did you have to clean up?
There were problems in the forms of our pharmacy operations guidelines. There were problems with the tracking of medications, both controlled and non-controlled substances. And there were problems with, I apologize, the actual literal forms that were logging things on, quite aside from the lack of logging on the forms that we had.
And those things all occurred during the tenure that Mr. Erskine was Deputy Director of Operations. Isn't that true?
It was while he was Director of Operations, but not while he was Pharmacy Officer.
He would have been over the pharmacy officer. Isn't that true?
That is generally true, yes.
All right. So during the time that Mr. Erskine was overseeing that aspect of the practice, Rocky Mountain was not compliant with pharmacy regulations in a number of aspects. Isn't that true?
I believe that's true, but that's why I was brought along to bring them into compliance and why I will be handling the compliance for Helios.
All right. You've also stated, I believe, that all of the formal complaints and enforcement actions that the PRC has done against Rocky Mountain were either before your time or after your time. Is that correct?
I believe that is correct.
But they were not before Mr. Erskine's time, correct?
I believe that is correct.
So a lot of those complaints arose while your now partner in Helios was running the show, so to speak, correct?
I think that it is incorrect to say that he was running the show. He was the Director of Operations. However, he was forced to work with the oversight and management of Mr. Little, as well as the ownership of Mr. Little, which precluded him from taking the actions that he felt were most appropriate to ensure safe and compliant operations of Rocky Mountain.
He could have quit at any time, could he not?
I couldn't speak to that.
Do you know of anyone holding a gun to his head to keep him working in a situation that he felt was untenable?
I know of nobody actually holding a gun to his head, no, but that doesn't mean that there weren't other circumstances which precluded him quitting.
Do you know of any other circumstances that forced him to stay in a work situation where pharmacy board regulations were not being followed?
I do not have direct knowledge of that, no. I'm not willing to say that there weren't any. However, I do believe that he stayed under the belief that he could resolve those issues and thus continue to serve the patient populations of northern New Mexico.
And there are certainly other places where Mr. Erskine could have served the patient population of northern New Mexico, are there not?
Not in the way that he was serving them at Rocky Mountain EMS, as far as I'm aware.
So he elected to stay for 16 years in a situation that he now describes as out of compliance and extremely difficult. Is that right?
I believe he describes the end of his tenure as extremely difficult and out of compliance. I'm not sure he necessarily described his entire tenure as.
During the time of that ambulance crash, it was found that the vehicle that was run into by the drunk driver, the ambulance vehicle, was in very, very poor condition. Would you agree with that?
I'm sorry, that, as I said, that crash was before my time. I do not have complete details on.
Mr. Hearing Examiner, this isn't my.
Yes, sir, Mr. Padilla.
Yeah. This isn't my witness, and I hesitate to interrupt when the witness is not mine, but I'm not sure where all of this is going. We're talking about an accident, which from a factual standpoint was on a snowy day. It happened on a highway. It was insured. I'm not sure. I'm assuming that Ms. Migliori is attempting to show shortcomings on behalf of Mr. Erskine, but to the extent that these shortcomings are reflecting on Rocky Mountain EMS, I don't think they're relevant. And I guess I'd simply like a continuing objection with regard to any implications concerning Rocky Mountain EMS, because this isn't a case involving Rocky Mountain EMS.
Okay, Ms. Maggiore, what is your point of the line of questioning regarding this accident?
Well, I find it interesting that Mr. Erskine is nowhere to be seen, but a lot of the complaints and problems that arose in his former employment happened under his responsibility. And I think we need to look at who he is in applying for a startup company that we've already established is underfunded, under-equipped, under-informed, and I hope that you can see that we're heading into a problematic situation. By the way, that was not the accident that I was referring to. There have been more than just a couple of them, but I'll be happy to move on.
Thank you. So I won't have to roll on the motion anyhow. Roll on the motion. Continue, please.
All right. In your rebuttal testimony,
Roll on the
Mr.
objection.
Prescott,
Go ahead.
in your rebuttal testimony, Mr. Prescott, you noted that Mr. Erskine was Director of Operations, right?
That is correct.
And he was Director of Operations for how many years?
I am not sure of the exact number, but I believe 8 or 9.
Right. And for those 8 or 9 years, he was responsible for the day-to-day operations of Rocky Mountain, right?
He was responsible for, but you assume he has more power than he did, I think. Ultimately, any decision he made that required the expenditure of money had to be signed off by Mr. Little. And frankly, Mr. Little didn't like to spend money. So a number of these issues that you've been raising come down to issues where we couldn't get the funding released. It was one of the skills that I personally had was getting money out of Ed. I'm sorry, Mr. Little. And so that's part of why we had an enhanced compliance while I was under.
But for many years, Mr. Erskine participated in unsafe practices. Isn't that true?
I would argue that he was minimizing them while continuing to provide service to the patient population.
I think that would be a no. Mr. Borman, your mouth is moving, but I don't hear anything.
I didn't know that my mouth was moving, but my wife did just walk by. I had myself on mute.
Okay, sorry for the interruption. Ms. Maggiore, sorry for the interruption. Please continue.
Right. After you left Rocky Mountain Ambulance, Mr. Erskine suddenly began reporting compliance issues to the PRC. Is that correct?
I don't know exactly when he started, but I don't believe that suddenly would be an appropriate phrase.
What compliance issues did he report?
I do not know every compliance issue that he has reported.
Well, why don't you tell us the ones that you do know?
I know of instances in which Mr. Little had set up transports without consulting Mr. Erskine, which would involve either improper cohorting or transports performed without an EMT on.
You're muted, Mr. Prescott, if you were continuing.
I'm sorry, I do believe I have more to say, but I wanted to refer back to my rebuttal testimony to make sure I didn't miss anything.
But why don't you look at your testimony, your direct testimony on page 6, lines 1 through 7 regarding complaints.
Let me just a moment. I apologize.
I'm not sure.
What were those page and line numbers?
Page 6, lines 1 through 7.
Okay, I see that those lines. I'm not sure how they apply to the question that you were asking.
Mr. Prescott, pardon me, Ms. Maggiore. Mr. Prescott, you've become kind of a master of that space bar, but I appreciate it if you would just leave it unmuted while you're testifying. Every once in a while, there's a bit of a latency, and we're missing the first syllable or so, or the last syllable when you're clicking too early, either way. So just leave it unmuted unless there's a problem. Thank you, sir.
I apologize, and we'll do so from now on.
All right, Mr. Prescott, you noted that Rocky was the subject of multiple NMPRC enforcement actions. Is that true?
Yes, and that is an area I wish to clarify. At the time that I made that statement, I was incorrect about there being multiple enforcement actions. I did not clearly understand the differences between the various actions of the PRC. At that time, there was only one enforcement action.
All right. What did that enforcement action entail, the one that you know about?
That was the incident in which, I'm sorry, I shouldn't say the incident in which, that was when the PRC had served Rocky Mountain with a temporary suspension of their operating authority.
And the reason?
I do not recall the direct reasons offhand.
All right. Still on page 6, you've talked about having conversations with Christus. Did you have any conversations with Christus management?
I did not. I'm not sure whether or not Mr. Erskine did. I believe he did, but I can't be certain about that.
And Christus Management has not provided support for Helios's application. Is that true?
That is true. They have not provided any official support.
And the letters from nurses that are undated, unsigned, and unverified don't mention Helios anywhere in them, do they?
I would note that one of those letters was signed. However, no, none of them mention any particular ambulance service. They're all in support of the need for additional ambulance services without naming names or getting on any one side.
All right, I think we've already established that you only own 2 ambulances, yet you're asking for statewide authority. Is that correct?
Those are both correct statements.
And I'm not asking you as a lawyer, I'm asking you as a person who considers himself in the EMS management realm. Are you aware of any authority that exists today for statewide certification of an ambulance service?
I'm aware that multiple services within the state of New Mexico have statewide authority, which would indicate to me that the authority thus exists. However, I am not a lawyer, as you pointed out.
Or existed at one period of time. Do you know of anyone in the last 10 years who has been awarded a statewide certificate?
Objection, relevance.
Excuse me, I was actually looking at another paper. Could you please ask the question again so I can roll on the objection? What's the question?
I asked Mr. Prescott if he knew of any service in New Mexico, any EMS service, who had been awarded a statewide certificate in the last 10 years.
Overruled. You can answer if you know, sir.
I'm not aware of any service who has been in the last 10 years now.
All right, and I think we've already talked about your belief that $20,000 buys an ambulance, and that you will not have any backup ambulances, correct?
Not initially, although we will be able to use our downtime on the second ambulance to perform maintenance.
Now, are you aware that a stretcher alone, new, costs about $12,000?
I'm aware that they vary in price, but that's certainly within the range of a new stretcher, yes. However, we did not buy new stretchers.
I understand that. We're going to talk about the dangers of old stretchers here in a minute. Are you aware that a cardiac monitor can run in excess of $20,000?
I'm aware that that is within the realm of possibility, yes.
Do you think a company like Zoll would certify the cardiac monitor that you plan to put on your ambulance?
I'm not aware of any reason why they wouldn't. As far as I'm aware, they still maintain support for the Zoll E-Series. However, we have identified independent biomed certifications, biomed engineers who are willing to certify.
Are they certified?
One is not. We are holding off until we are getting close to starting operations before we get that one certified so we can get the longest run on it.
Are they 12-week capable?
They are.
All right. The stretchers that you have, are these the old style, we used to call them backbreakers, but are they the old style stretchers without any hydraulic assistance?
They are Stryker MX Pros.
Do they have hydraulic assistance?
I'm not actually sure if they have hydraulic assistance. I know they do not have electric hydraulic assistance, if that's the question.
All right, now you've already told us that you have no budget for employee benefits, correct?
Not initially.
And you do understand the statistics for on-the-job injuries for EMS personnel, is that right?
I do.
On-the-job injuries in EMS workers are extremely common, are they not?
As a paramedic for 15 years, I could say that they are certainly more common than they are for, say, office workers. I don't know that I'd characterize them as extremely common.
And you're aware that they're more common with the deadlift style stretchers, right?
More common than with power stretchers? Yes.
Yes. All right. Now, with you not offering employee benefits, and for the initial startup, when it's just you and Mr. Erskine, and you won't have any workers' comp insurance, how do you expect to attract the best and brightest employees without offering any of those benefits?
Objection, misstates the testimony. Mr. Prescott has never testified that they're going to start the business with just him and Mr. Erskine as the only two employees.
Well, it was my understanding there are no other employees, correct?
Yeah, objection is sustained. So break down the question and ask him how many employees he intends to start with. I also heard him testify that not concerning attracting employees with benefits. He never really said he didn't have money to attract benefits, to attract employees. He said that in the beginning there would not be benefits. That was his testimony. So it was slightly different than the question regarding benefits. So I would caution that we be very careful with the questions we ask and perhaps build up to the question that you really want to ask. So if we could break down the questions a little bit, that would be helpful for me as well. Thank you. Ms. Majori, continue.
All right, let me just back up a little bit then. If you are awarded a certificate, how many employees do you plan to hire?
We're planning an initial hire group of between 8 and 10.
All right, and you would have to have workers' comp insurance at that point, correct?
We would, and we intend to.
All right, and these initial 8 or 10 employees, you would not be offering them benefits, correct?
That is correct.
No time off, no paid time off? Is that right?
We would not have a paid time off policy to begin with, no.
No sick leave?
We would not have a policy on that, no. That's not to say, however, that we would not offer paid time off or sick leave as necessary on a case-by-case basis until such time as we can establish policies that we feel are appropriate.
And even more important, you would not be offering health insurance, is that correct?
That is correct. Until such time as we get a little more established and figure out the most appropriate option, we do not intend to offer it.
So you're intending to hire 8 to 10 employees, some of them paramedics, some of them EMTs.
I'm sorry, I didn't get that. I'm sorry, Ms. Majori, this is the reporter. I didn't get that. You were breaking up.
Okay, let me start over. So you're planning to hire 8 to 10 employees without offering health insurance in the middle of a pandemic, is that correct?
That is correct.
Mr. Chair and Examiner, this is Ray Padilla. I don't know about the rest of you, but Ms. Migliori's questions are breaking up and I can't understand what she's asking.
Yeah, you're right on the edge, Ms. Majori. So I don't really know the answer right now. Let's try to get through your cross-examination. How much more cross-examination do you anticipate in time? 10 minutes, 15?
Maybe about 15.
Okay, well then, before we continue, I want to ask Ms. Hoyman. Ms. Hoyman, are you agreeable with proceeding beyond 5 p.m.? Okay, that was a nod. Yes. Mr. Borman is yet to cross-examine, and I think we have this scheduled till 5 o'clock. So I might have to click some buttons to make sure it continues beyond 5.
Mr. Hearing Examiner, if I may.
Yes, sir,
I
Mr.
will. I will not have cross for.
Excellent.
Pre-cup.
Okay, thank you very much. That's very helpful to know. Appreciate that. All right, sorry, I don't want to create any more time pressure. Go ahead, Ms. McJory. Let's see if we can proceed and finish yours off. Al, thank you.
All right, and I'll try to be as concise as I can. I know we've looked at Exhibit MP-R-01 to your rebuttal testimony numerous times, and you've told us that you have never met with Lillian Montoya, the CEO at Christus, correct?
I have not.
And as CEO of Christus, she has not filed an affidavit in support of your application, correct?
That is correct.
In fact, you've provided no sworn testimony in support of your application, correct? Other than your own.
That's correct.
All right. I'm looking again at page 6, lines 14 through 21 of your direct testimony. You talk about Rocky Mountain having insufficient personnel and arriving late or not at all. Where did that information come from?
That information came from conversations with staff members at various facilities throughout northern New Mexico.
Which various facilities throughout northern New Mexico are we talking about?
Christus St. Vincent, Los Alamos Medical Center, and I believe Espanola Valley, or Espanola, I'm sorry, I don't recall if it's a regional hospital or a valley hospital, but the hospital in Espanola. Those are the ones that I know of. I'm not sure if there are others.
All right, so not Taos, correct?
I do not know if there were conversations in Taos.
And not Raton, that was another place I think you mentioned.
That was, I do not believe we've had any direct conversation. I'm sorry, I shouldn't say I do not believe. I do not know if we've had any direct conversations with Raton recently.
All right, and where you talk about the formal complaints with the PRC, you used a phrase, improper patient cohorting. Can you tell us what you mean by that?
I am honestly not sure if this is a legal issue, but it is certainly a best practices issue of placing multiple patients within the same ambulance being transported at the same time. It is something that is acceptable during, say, a mass casualty event where there are more patients than there are ambulances available, but is frowned upon certainly as a best practice outside of that event. And on multiple occasions, Mr. Little had set up transports involving multiple patients being transported simultaneously in the same ambulance without consulting Mr. Erskine.
All right. For example, if you were given a certificate and you get a call from down in Carlsbad, they want you to come down to Carlsbad and take a patient from a facility to home. Will you accept that call?
If our quote was the best quote that was available in time, then we would accept that call.
What is deadhead time?
I've never heard that phrase specifically applied to EMS, but generally deadhead time is referred to as time spent not in revenue, but time spent not in revenue, I believe is concise enough.
So you would drive one of your units to Carlsbad with 2 staff members on board, pick up that patient, take them home, and then drive back when the trip down there and back is deadhead time. Is that what I'm hearing?
Yes. That patient needs to move. If they're willing to wait 8 hours, 7 hours, however long the transport is, I don't know the drive time to Carlsbad off the top of my head, I apologize. But if they're willing to wait 7 hours, they cannot get anybody to move that patient for that length of time, then we'd go move that patient, because we're in this for the patients. We're not in this for the money. We'd accept that we would be taking a loss on that transport.
All right, I'm going to wrap up with dispatch. Am I hearing correctly that you and Mr. Erskine are going to be dispatching via your cell phones?
Potentially with other employees, but yes.
So one of you is driving and is going to be answering a cell phone and dispatching another unit from the cell phone?
I don't believe I said anything like that. Is our intention that it would be dispatched by somebody who is not on a truck at that time, not assigned to a truck?
Okay, so you're going to have an employee who is assigned to dispatch. Is that
An employee
correct?
who is assigned to duties other than being on a truck.
Such as billing?
Administrative support, compliance work, what have you.
Do you plan to have this person certified as an emergency medical dispatcher?
We do not, because we are not providing pre-hospital services, so it would be inappropriate to be an emergency medical dispatcher as we are conversing with other healthcare professionals.
You think it would be inappropriate to have that training?
Inappropriate is perhaps a poor choice of words. Unnecessary. Since we're generally speaking with nurses requesting transport, there's no need to have an emergency medical dispatch certification, and there's no requirement to have an emergency medical dispatch certification. However, they would have people.
I'm sorry.
However, the people answering the phone would be emergency medical technicians at one level or another.
All right, I'm going to go ahead and pass the witness at this time.
Okay, I know there could be redirect, but I will ask a couple questions so that the redirect can include any questions that arise from my questioning. I had a bunch of questions, but fortunately most of council have covered all the issues I had. Mr. Prescott, you mentioned the word template twice, as if some sort of template you were using was limiting your analysis. Could you help me to understand what you meant when you were referring to this template or these templates?
Well, I used one thing that could certainly be referred to as a template, which was what I used to develop our pro forma financial projections, which was a spreadsheet that was developed by SCORE. I don't know the name of the acronym, but it's a business incubator type.
Service Corps of Retired Executives, I believe.
Thank you, sir.
Yeah.
And it was developed to help new businesses develop pro forma financial projections, as well as existing businesses developing their financial projections.
All right. And like I said, almost every issue I had with your testimony was dealt with, except for on page 10 of your direct testimony. You on line 19, you indicate that you average annual volumes over 12 months and then adjusted downward by 25%. And I understand these kind of analyses, but it seems like that 25% just came off the wall somewhere. I don't find any basis for it. Where did you get that 25% figure? What does it mean?
In general, that 25% was meant to provide a conservative estimate.
Okay.
I didn't have any formal basis for that. I just wanted to make sure that all of my pro formas were as conservative as possible when I was looking at places where I had to make estimates based on my experience.
Okay.
It's the same reason that, for example, my Medicare billing rates don't include any of the patient contribution.
Understood. Well, I don't have any other questions for this witness. And Mr. Marks, I understand you want to do some redirect, so the floor is yours, sir.
Okay, I think I'm going to work backwards.
And this has to be within the scope, of course, of the cross-examination. We're not going to do any type of direct examination at this point. Just redirect based on the scope of the cross, correct?
Of course.
Please,
And
sir.
I'm sure yourself and several other counsel will keep an eye on that. Ms. Maggiore asked you about whether you had ever met with executives of Christus St. Vincent. She called it management. Do you recall a meeting with Christus St. Vincent that I attended and with you and Rich?
Of course, that completely slipped my mind. But yes, I did attend a meeting with yourself, Rich, as well as the director of the ED, the CFO of Christus St. Vincent, and I believe, head of case management, but I don't recall her exact title.
Mr. Hearing Officer, it's Fred Maurer. I object
Yes,
to
sir.
that question as being extremely leading.
Well, you know, I hear you, but we're on redirect at this point, and I'm going to overrule the objection with respect for Mr. Maurer. Please, Mr. Marks. We're
Can you
losing.
search your memory? Any other executives you remember in that meeting?
Oh, I do believe the chief nursing officer was in that meeting as well. I apologize. It's been a long day for me. My memory is slipping a little bit here.
Mr. Priestkop, in some of your pre-filed testimony, you addressed the circumstances of Mr. Erskine's termination from Rocky Mountain. Do you recall?
I do.
Okay. Ms. Maggiore asked you if it was possible that Mr. Erskine could have quit at any time. Do you know if Ms. Maggiore said that Mr. Erskine could quit at any time? Do you know from personal knowledge whether Mr. Erskine ever threatened to quit?
Mr. Erskine threatened to quit on a regular, well, I shouldn't say a regular basis, but he did on a number of occasions threaten to quit. In order to...
This Rapidi, I'm going to object.
Yes,
this is part of the direct testimony or the rebuttal testimony. I recollect that statement has previously been made. This is not to rehash testimony that's already in the record.
Yeah, we're going to try to keep this redirect to limiting the scope within the cross-examination. I also recognize it from the direct testimony. Were you leading up to something, Mr. Marks, or was that your final question on that topic?
That was my final on that.
Okay.
Because Ms. Maggiore left it as if Mr. Erskine had done nothing, and I am responding to that. We were just following up on her question. You were asked by Mr. Bartel about those letters that are undated, and you stated that you knew when they were obtained. When were they obtained?
They were obtained after we initially started talking about Rocky Mountain, about starting Helios. I apologize. We started discussion on, I believe, October 26th. All of the letters that we obtained were obtained after that time, October 26, 2019.
Mr. Bartel asked you about whether there were needs not being met from the certificated companies in Rio Arriba County, serving Espanola, Santa Fe, and possibly some other places. And your answer wasn't very clear to me. Do you, from your own knowledge, when you work for Rocky Mountain EMS, do you have any personal knowledge of whether all the needs were being met for interfacility transports originating or terminating in those counties?
I'm going
From my own
I'm
experience,
going to object.
Yes, sir, Mr. Maurer.
I'm going to object. That question was asked and answered.
I will join that objection and also point out that any information that he would have from that period of employment is now at least 3 years old. It is really not relevant.
Well,
This is Ray Padilla, Mr. Hearing Examiner. I also join that objection.
what was the question again, please, sir? Mr. Marks, what was the question?
The question was, does he have any knowledge from the time he was with Rocky Mountain EMS about whether all the needs for interfacility transports originating or terminating in those counties was being met? And as Mr. Bartel has acknowledged, that was a question he asked, and I don't think the answers were clear.
The objections of all counsel jointly are sustained. Please ask another question.
Mr. Erskine, in response to Mr. Bartel's questioning about unmet need, you did state that there were some unmet needs. What is your basis for knowing that? In those counties?
The basis for knowing that is both personal from my time and also from conversation with Mr. Erskine, in that there were occasions on which patient transports were delayed for many hours waiting for an available unit, including all of the, they had accepted a long time frame from Rocky Mountain while Mr. Erskine was there or while I was there because nobody could get there sooner. We were talking transports with delays of up to 8 hours because that was the soonest available unit.
Mr. Hearing Examiner, this is Ray Padilla. I'm going.
Yes, sir.
I didn't object during the response because I didn't want to be rude to the witness. But again, it seems to me that the witness is rehashing what he's testified to in his redirect testimony, and that's not appropriate response.
Yeah, but in the Mr. Marks.
I'm done with that topic.
Okay, Ms. Maggiore, I saw you light up down there. Your phone number. Do you have some comment?
No, sir.
Mr. Padilla, I'm going to overrule your objection. I have a slightly different feeling about the nature of that question concerning that it's in redirect and that I believe it was within the scope, even though he may have testified to it in direct. I think it was rehabilitative after the cross-examination. So I wanted to allow that in. We're kind of talking about the closing the door to the barn after the horse is already out, but I don't like to leave loose ends hanging out. So I thought it better to address that. Next question, Mr. Marks.
You were asked about your supply budget. What supplies are typically consumed in interfacility transport?
Very little. Typical consumption during IFT is occasionally a nasal cannula or a non-rebreather, maybe some gauze here or there. But typically during IFT, very few supplies are used because by and large, the patient comes already packaged from the sending facility.
You were asked various questions based on the number of runs and miles in the NPO3 exhibit and whether they were whether the volume was that you projected was doable. Did you make an analysis of that?
I asked that question about the source of and analysis of, and he's answered it.
Yeah, well, this is redirect, and I'm going to allow the question. Please continue.
I did. As for, I'm sorry, could you, I want to make sure I'm not overstepping. Would you repeat the question, Mr. Marks?
You were asked various questions about the volume, the number of runs and miles in your spreadsheet. What are those based on?
The volume and number of miles are based on a analysis of myself and Mr. Erskine, are based on our experience serving the patient population of northern New Mexico. We estimated the number of calls that were available, and we based our numbers there upon those.
Are the revenue numbers, the dollar numbers, based entirely on the volume of pickups and mileage that are also shown in that NPO3 sheet?
They are, as compared against what numbers I could establish firmly and conservative estimates for all other numbers. Every, ambulance services are paid based on the number of runs they perform. So, or I should say, they are paid by the runs they perform. So, perforce, any estimate of revenue is based on an estimate of call volume.
I'm sorry, what's that last word?
Call volume.
And when you were asked about the NPO3, and then there's and the equivalent in your rebuttal, you said several times you made guesstimates or guesses. Can you clarify which numbers in that spreadsheet or that template are not based on some actual number that you either knew from your own experience or tracked down or obtained by getting a vendor quote? Which are the estimates or guesstimates and which are not?
Almost everything is based on either my knowledge, Mr. Erskine's knowledge, or vendor quotes. There are a few exceptions. Of course, I can't firmly claim the call volumes, but I believe them to be accurate. As I said, those are based on our knowledge of the market. Places where I had to be a little softer in my assumptions include the cost of buying furnishings for an office. Also included in that are the cost of office expenses, which I've estimated at $50 a month. And there's also travel, meal, and entertainment expenses. We are anticipating a policy that would reward people who perform long distance transports with money to pay for their meals while they're performing those. And unfortunately, I was forced to guesstimate exactly how those would come together. And of course, miscellaneous expenses, by their nature, I can't predict. They are miscellaneous.
How did you get a, are you through detailing the things that you estimated?
I also was forced to estimate the utility expenses, as I don't know exactly how much our utility bills will run once we're in full operation and have people in there 24/7.
You were asked about the cost of a third-party billing service. Did you estimate that cost?
In that cost is based on another estimate. That cost is based on our run volume estimates, and each we'll be paying on a per run sheet basis.
Did you estimate the amount that it would cost you to get a bill generated?
Yeah,
bill?
we spoke with a billing agency to determine that number. We spoke with specifically the company that we're intending to contract with.
Okay. Very good.
You were asked about adding additional ambulances and whether that turned on profitability. You said it depends. So what is the decision to add additional ambulances going to turn upon?
We'll turn upon the call volumes that are out there, the demand for our services, as well as the availability of capital. We have sort of backup options for capital that we can tap if we need to. For example, if an ambulance were to break down. However, we would not want to tap those for expansion purposes. We'd rather finance those out of revenue. But ultimately, that does come back to the demand. If we believe that there is sufficient demand, that it makes it worthwhile to tap our backup revenue sources, our backup capital sources, then we would do so.
You were asked about by Mr. Padilla about several things that are in the application, such as whether documents were to be sworn or not.
Mr. Marks, could you repeat the question? You're shuffling papers or something.
Sorry. You were asked by Mr. Padilla about the application. How did you come to understand what the specific requirements were for the application in terms of the workers' compensation page and the other documents that were attached?
We had multiple conversations with various members of the PRC transportation staff. We asked questions where we were unclear on specifics and received their guidance and followed it.
And how did you determine what level of insurance to submit with your application?
That was in response to we'd asked a member of the PRC staff what level we needed and made sure we complied with what we were told.
And if it turns out that Helios needs a higher policy limit, will Helios be getting that? Is there any reason why you couldn't get that?
Absolutely not. We're in close contact with our insurance agent, and I'm sure that we would be able to rewrite our policy to a higher limit.
Back on NPO3, there was some discussion about cost per unit. To clarify, does cost per unit, does that refer to the line that says COGS?
It does, yes. That is our variable cost per mile.
And just for the record, what does that acronym stand for, COGS?
Cost of goods sold.
Cost of goods sold. I apologize. As I said, this template came from SCORE, which again, you do the acronym and I did not.
You had some discussion about your eligibility for an SBA-backed loan, and you were asked if about how much was available for you to borrow, and you did not give a precise answer, and then Mr. Padilla dropped that. How much, do you know how much you could borrow based on the company's finances?
Objection, Mr. Hearing Officer. I asked that specific question on how much would be available, and he did not provide an answer.
Well, I think he's trying to rehabilitate his client and perhaps clear it up and provide an answer. So respectfully, Mr. Maurer, I take all your objectives seriously, but I'm going to once again overrule. Please answer the question.
Mr. Hearing Examiner, this is Ray Padilla. I just want to stay for the record. I didn't ask that question. It may have been Mr. Maurer or somebody else, but Mr. Marks attributes the question to me. It wasn't me.
Okay.
I stand corrected. Thank you, Mr. Padilla.
And thank you, Mr. Maurer, as well. Appreciate it. All right, let's keep it rolling. Next question. Oh, answer.
Based on the conversations that I had with SBA lenders, I was given to believe that we would likely be able to qualify for between $75,000 and $100,000 worth of a working capital line of credit or a SBA 7A Express loan. More likely the 7A Express loan, the working line of capital credit, has some additional requirements that may be harder for us to meet, but not impossible.
And then there were questions about an item in the spreadsheet that is called line of credit interest. You're familiar with that line in the spreadsheet?
Was that asked about during the cross-examination specifically, Mr. Marks?
Yes, it was. He was asked about it, and I think it would be Mr. Maurer was trying to figure out how that reconciled with the fact that they had no loans, and it was left open.
Thank you, sir. Pardon me for interrupting. Go ahead, answer, Mr. Prescott.
Again, that line is an artifact of the template that we were using, and I failed to correctly zero that line out, as these would be the line of credit, so to speak, that we are referencing would be contributions from myself and Mr. Erskine, and thus would not have direct interest charges on them.
So is that a payment that would be made once you begin operations, yes or no?
It is not, no.
You were asked about your estimate that 10% of the volume of call volume from St. Vincent's could wind up coming to Helios, regardless of whether Rocky Mountain or AMR or some other provider was their primary provider. Do you recall that question?
I do recall that question.
And what's the basis of your 10% estimate?
Again, that comes from experience, that there will be times, no matter who the primary provider is, where all of their available units are otherwise occupied and they cannot respond in a timely manner. And so that call that they can't get a timely quote on will be called out to other services in the area. And I'm estimating that approximately 10% of the time that will occur, and those calls will come to us.
you were asked about whether you had separately accounted for BLS and ALS in your pro formas, and I think you said you did not. Why didn't you?
Well, they're not broken down separately. However, they are accounted separately. They are accounted for in there, in that both of our Medicare and Medicaid billing rates, we took the published rates, we averaged the percentage of each level that we assumed we would be performing based on our estimates of the call volume that would be available to us. And then we took that out as a single number in order to make it fit into the spreadsheet that I was using. So the numbers are in there, but they're not broken down separately as far as the number of ALS and number of BLS.
That's it for me, Mr. Lennon. Thank you.
Thank you, sir. I believe that concludes the testimony of this witness. There's not going to be any recross examination. So at this point, I cannot imagine we should start another witness. I think it's time for council to agree on when we can continue with this hearing. So we can go off the record, Ms. Hoyman. Appreciate it. I suggest sooner rather than later, so next week looks good to me. I'll tell you what I have available. I have Tuesday, Wednesday, or Thursday, 17, 18, or 19. Anybody have any preferences on those days? Anybody specifically not available on any of those days? We could run down the list.
Can you give us those dates again?
I'm not available.
Okay, on any of those dates? Was that Brad?
That was not me.
Who said you're not available? Mr. Casper?
It's Mr. Casper.
Okay, I'd like to hear from council actually first. And usually council confer with their witnesses.
Can you give us those dates again, please?
17, 18, or 19. And Mr. Casper, who's one of the witnesses, has already stated that he's not available. So we can move on to other dates. I don't want to cause any conflicts that we have to resolve. The next week is actually Thanksgiving week. I don't mind working that week. It doesn't matter to me. 24th or 25th look like dates. I always like to have I don't like to work on the day before people are off from work. It just doesn't seem to work out well. So I would suggest November 24th. Is November 24th a conflict for anyone? That was a no response.
Yeah, I'm checking with my witness. I just want to make sure.
Thank you. Please do. November 24th, Tuesday.
It's clear for me, but
so Mr. Montoya, he's probably still on. Yeah, you can use chat.
yeah. You are available? Okay.
Okay, 24th looks good for staff. Mr. Marks, are you available on the 24th?
Yes, I am.
Okay, Mr. Mauer.
As
Available on
far as, I think my client's been listening in the entire time. I'm not hearing anything or seeing anything, so I'm assuming yes.
Okay, Mr. Bartel.
That date is okay with me, but I'm still trying to get clearance from Mr. Casper, so, okay, all right. 24th is okay for us.
Okay, Mr. Padilla, 24th. Tell me yes.
I'm assuming that I will be. I am probably more computer challenged than anybody in this whole proceeding. I'm definitely old school. I graduated from law school more than 45 years ago, so I'm not up to date with these guys. I'm assuming I am, and my witness has indicated that he probably is. I'll do everything I don't think that I have anything.
Okay, that sounds like a yes. And by the way, it's been, I think, about 37 years since I got out of law school. I remember those pre-computer days as well. Hell, it was pre-cell phone days. Didn't have those either. beepers were just coming in. Anyhow, Miss Hoyman, I left you for last. I'm sorry about that. Are you available on the 24th?
I just went and grabbed my calendar and I am available on the 24th.
Spectacular. This doesn't always work out so well. So we're going to reset this to begin on the 24th. I suggest 9 a.m. That's early in the morning, but I'm usually awake by then. So 9 a.m. on the 24th, we will continue and hopefully conclude all the testimony that day.
Mr. Lennon, you did not include us.
I was
We
going to
are
say,
available the 24th.
Oh, I'm so sorry. And I don't have an excuse except for I don't have a picture to look at. And I'm just looking at phone numbers. So I'm sorry, Ms. Maggiore. Thank you for being available.
That's all right. I apologize for interrupting.
No. It's perfectly okay. I didn't, like I said, you just have a phone number there. I had suggested to the chief, your client, perhaps you could conduct your presentation from his office so that you have adequate internet service and we don't have to have all those problems again. What do you think about that idea, Ms. Maggiore?
Well, I think he's about 200 miles away from me, but I'm happy to do it from my own office.
Okay, well, whatever works. If we could save some time and that would be helpful. So it's scheduled for continuation of this hearing on the 24th at 9 a.m. I really don't believe an official notice is necessary. All the parties are present, so there will not be an official notification. We will continue right where we left off at 9 a.m. I'm going to optimistically presume and hope that we can conclude by 5 p.m. that day. That's a goal to shoot for.
this
Yes,
is Fred Maurer. Are you going to be using the same Zoom passcode and access number?
You know, I think I have to do another one.
Yeah, I think you do.
I have never really done it where I continued one like this. I'll set up a new meeting and I'll send everybody a new notice of the new meeting. I'll send counsel, actually. I won't send witnesses. I'll send it to counsel and counsel can circulate to witnesses.
That would be fine.
Okay, wonderful. Is there anything else we need to discuss, Mr. Maurer?
Mr. Attorney General, this is Ray Padilla. I know that you've got a court reporter here. And so ultimately this is going to be transcribed. Is the court reporter going to go ahead and transcribe before then, or at least start, not necessarily provide it to everybody, but get a jump on the transcription and then after the 24th, complete the transcription?
Ms. Hoyman, I don't have no opinion on that.
I do not wait to transcribe. I will start transcribing this before the next hearing.
But it's not going to be distributed, of course, because it's not the transcript. So I had no intention of distributing partial transcripts. Is that what you were asking for, Mr. Padilla?
No, sir. I'm anticipating that what's going to happen after the 24th. We're coming into the holidays. If we're going to do proposed findings of fact and conclusions of law, we're going to be jumping into January, it seems to me, with that type of thing, depending on your ruling, of course. I'm just kind of trying to anticipate what might happen with regard to the availability of the transcript to the parties and how that's going to affect follow-up procedures.
Thank you for that, sir. Are there any other comments or anything else any other council would like to discuss while we're all online right here, right now?
Mr. Lennon?
Yes, sir.
For your benefit and the other party's benefit, I would estimate that I have between 1 and 2 hours of cross and for when we resume, and I would all speculate that the other parties don't have very much cross at all, and so we should be able to get done by noon on that day or 1 or so. Just want to give people that advance notice.
Well, that
and
sounds
you're welcome
promising.
and you're welcome to hold me to that.
Really?
To
How
2
exactly
hours,
do
yeah.
I enforce that?
Probably 2 hours.
Okay.
Mr. Medeiros does it all the time.
It's a tiger without teeth.
Throw him out of the Zoom room if he goes over. That's not even.
Yeah, while you guys were talking, I went back to Zoom and I got the time extended today. There's a bit of multitasking going on over here. So sorry, that's if you ever pick up that I'm doing that. let me see something. Okay, so is there anything else we need to address or we can address? And I just have one suggestion if there's nothing else. Okay, we did have one stipulation today, and stipulations are great because stipulations are, by definition, something I don't have to decide. I can't decide. It's more or less a done deal, and it makes the requirement to present evidence go away. If you guys can, if you have any ideas and you want to confer with each other to reach any stipulations, you don't need me. Even though we're mid-hearing, you could agree to something. You could agree, well, you could agree to almost anything. So consider, if you have any ideas for stipulations, communicating with each other. Always feel free to communicate with counsel for the other litigants. Other than that, I am going to adjourn this meeting if there is nothing else we need to discuss. Is there anything else we need to discuss? All right, meeting is adjourned. Have a good evening, folks.
Thank
Bye-bye.
you.